Hopefully everybody has coffee with them so we can march through this. The one thing today, the speaker in the middle of the table is picking up the meeting. So if everybody, when they speak today, can speak up to make sure that you can be heard by everybody on the interwebs here. But I want to start by thanking everybody for their time. I know it took a lot to get through these comments, and we got a lot of good feedback on the meeting materials today. So I look forward to going through that. A couple things that, as far as timing goes, what I've done before this meeting is create a summary of the comments. And so I'm going to suggest when we get into those agenda items that we go through the issues and topic areas, and then go through the individual comments later to see if there's anything else that needs to be addressed in the comments. But I've taken the thrust of the comments and summarized them for that purpose, and hopefully that can allow us to get through the meeting today quickly. To start things off, we can discuss possible action to approve the meeting minutes from last meeting, from the July, to approve the July 8th and July 29th meeting minutes. Did anybody have any changes to those? Move to approval. Second. I have one change myself here on page. Let's see if I can get to the right page. On page 2 of 5, which is page 4 of our materials, in the I, it says 2A2. I believe that should be 2A1 for that paragraph reference. So after recorded in State County, paragraph 2A1. It's the property description section. And today promises to be management of paper more than anything as well. We have a lot of different contracts to go through. Any other changes? John is typing that in. I have a motion to approve the minutes as modified.
So moved.
Second.
All in favor?
Aye.
All opposed? All right, the meeting minutes with the change has been approved. So the next agenda item is public comment on non-agenda items. Do we have any members of the public that wish to make a comment on any non-agenda items? Okay, seeing there are none, we'll move on to the next agenda item. So agenda item number 4, discussion and possible action regarding comments received on changes to contract forms proposed at the August 8th, 2022 commission meeting.
Do we have any comments?
I think we can find a couple in this packet here. And so, like I said earlier, I went through and summarized the changes by topical area. And we have, of course, many different forms that we went over, but most of the contract changes we had applied across all of them. There are some outlier comments that I think we still need to flip through and pick those up later. But I suggest we kind of go through the contract, pick up the provisions as we go, and discuss those.
Before we start going into it, could I ask a question of the staff? If we make any substantive changes to what we have proposed in the past, is that going to prevent the forms from being adopted at the next correct meeting, or would it be pushed to the next one?
So Abby and I had a bet on what time that question would be asked.
When
I am super impressed that it was this early. No, so this is how I think about it when in terms of receiving public comment. So the purpose of proposing rules is to receive public comment. So inevitably in theory, inevitably there will be changes when you receive this amount of public comment. It's really going to depend on the extent of the changes. That said, I like to think of it as, is what we put out there significantly different with the changes you're making today? And if it is significantly different, or if you think, for example, with paragraph 5, and all the comments we had last time, like, if you think there's so much interest in the changes and the modifications you're gonna make, does it make sense to repropose? So I know that's not a hard and fast answer. The general answer is you can make changes in response to the comments you make. Let's see how different it looks once you've agreed on those changes, and whether it seems like it's something like, the public really hasn't had the opportunity to comment on it this way. And I think that's gotta be a pretty big shift, right? But that's the whole thought with comment. When I get into the substantive changes like at other times, what I mean is if we have a form and we wanna make just a real slight change to it, and the thought of not proposing it, that we can't do, just because they're already tied to a rule. And so that's a rule change. But here, you're really responding to public comment. So I say, go for it, let's look at the changes, and then, we can determine what it looks like. But feel free to make changes in response. Does that help?
That's very helpful.
Yeah, okay, good.
If something were dropped, if the suggestion was accepted and something's dropped from the contract, is that considered a substantive change?
You mean, so,
One of our proposed changes, we just dropped off.
and it just stays the same?
It stayed the same as before.
I think in that instance, that's probably not a substantive change because nothing's actually changed.
Even
It's
though
changed from the
change from the
proposal.
proposal.
I don't know, yeah. I think we could probably address that in the comments, or in the preamble, but I'd really have to look at it.
The lawyer answer, it
Yeah,
depends.
I don't know.
Let's ask a broker instead. Let's
That's
get a
the
broker's
lawyer version,
opinion.
I don't know.
Is that part of the bet?
That's not an
Well,
exclusive
if
lawyer
it's something
comment.
real
I'm thinking
substantive,
it
do you have
depends
like a whistle you could blow?
Depends a lot. I mean,
It's funny that you say that because I did take a whistle for my son this morning.
Yellow flag.
Okay, so if we jump right in, the topics as I summarized don't necessarily fall in order of the contract, but I think it would make sense to start with the 1 to 4, with the changes we made, and go by topical area by paragraph. I think that will help us flow through. So if you pull out the 1 to 4, it is, starts on page 167 of our materials, if you want to look at the red line version. And the first change that we have is to the cash portion of the sales contract. And if you recall here, we were trying to address the situation where cash means cash. People were writing offers that said they were cash, but the buyers really needed financing. And one of the big concerns we had was disclosure to the sellers so they can make an informed decision on it. And this is one of the areas that we received a whole lot of comments on. And just to tee up a summary of the comments, and then we can go through each one. There was 6 people that commented on that as an invasion of privacy. Why should I have to disclose where I'm getting my money from? And a lot of this was tied to, well, if I'm getting out of a retirement account and borrowing it from there, I shouldn't have to say anything to the buyer. It's invading my privacy. I shouldn't have to do that. 2 thought it limited the buyer's options to finance if desired. And the example is given a high wealth individual that's buying a piece of property for cash, but may want to around and finance it for whatever reason. And now with interest rates going up, that may be less likely, but they were concerned that it creates an actual obligation to use cash and not to go to financing. And if you went to financing, to actually amend it, to have to amend the contract. 3 were concerned about the ability to use 401k money or a 1031 exchange. 5 were concerned about seller needing cash from other property without using the addendum. And so there was 5 people thought Well, and I think that's exactly what we're trying to address, but they were concerned about, well, if you sell another property and are you committing fraud by not disclosing that upfront? 5 thought it was confusing and unnecessary. 1 thought the language is generally too long. 1 thought there is not a place for hard money loans, which we'll talk about the addendum later on that one. Cash should just mean no financing contingency. And we've had several people call us as well. I had discussions with, actually an hour-long discussion on that exact topic with a particular person that called in that thought before the contract had it was cash, but there wasn't representation there. And now they think that using this is creating a contingency for it. 1 likes the change. So we did have 1 who really liked it. 1, you don't know what terms are out there yet. You know, so if you're using the 401k money, for example, I think they gave, you don't know what terms those will be. I think you probably would in that case or could find out, but not knowing what the exact terms would be when you enter the contract and having to change that later. And the last one, there's 1 that they why have to name the terms if there's no contingency, right? So if you checked, we had that box we added that had 2A and 2B waivers in there. And so why, if there's no contingency, do I have to name my terms? I'm just telling you I'm having to finance it. So that's kind of an overall summary of the changes there.
I don't get
or
it,
the
cash is
concerns.
cash, I just don't get what their concern is, because if it's not financing, it's not financing. Because they're saying, we might have to finance, or we don't know what our terms will be, so we're putting it under cash, well, I don't get it.
What about the biggest concern about invasion of privacy? We walked through that one.
Aren't we invading their privacy already with pre-qualification and proof of funds? I mean, if that's the case, we do that on a pretty regular basis.
I think that's.
But that's not mandated in a
No, it's not.
form, it's just industry custom.
Well, and it's, in a sense, it's not mandated here. I guess you don't have to buy the house. I don't know. I'm trying to think. I mean, we detail the terms of the, if you're getting a regular conventional loan, we detail the terms you're getting. And is that, I mean, that's mandated.
True.
So, I mean, you know, I do kind of agree with the thing. If it's not contingent on financing, why do I need to know the details of the terms? I gotta say, I don't understand why I do.
Because I want to know that you're going to be able to perform. There's no invasion of privacy issue here because the contract is voluntary. You don't need to contract.
Right.
Every time you make a loan application, your privacy is really being invaded.
I agree with you. I agree with you.
I don't see a privacy
Well,
issue. People are free to contract
Yeah,
and they don't have to agree to.
right, so the proof of funds is, I think, a good practice. And if I'm taking a cash offer, I have every right to ask to see proof of funds, financials, whatever it might be. But that's not what we're talking about here. All we're talking about here is some sort of representation or disclosure that says, I'm not gonna go borrow the money someplace else, or I'm not gonna use my line of credit, I'm not gonna use my brokerage account or whatever it
They don't
is.
need to.
To me, that's a totally different thing from looking at what proof of funds are. So I don't equate those 2 things together. So I think what Don Moore in particular was talking about is what we're mixing disclosure issues with financing issues. And that, I think, probably problematic from a drafter's point of view, because this is not dealing just with financing issues. This is a disclosure issue is what this is. And it's not even a disclosure issues. It's sort of a mix between a disclosure and a representation that could be into violation of the representations paragraph. That's my problem, has been with all along. I know I've been the sole voice here, but I do think that some of the comments are well taken because it's a mixing of 2 different animals that I just don't like.
And I'll second, I share your concern. Once we got past that concern into draft language, I was okay with the language itself.
Yeah.
But I do share the concern that we're creating a representation that can then be sued on. I'm not necessarily in the camp that I firmly believe there was an implied promise for paying cash in the original contract. My view was that you just didn't have a contingency to terminate based upon any financing option. And now we've made it a firm representation that you actually have the cash, which then will potentially open up liability for misrepresentations. A lot of the comments were, well, do we have to change it up later if the terms change? Or if I'm using a different source, do we have to modify the contract to make that a correct representation at that point?
Keep
I would
in
say-
mind,
Every
keep in
day,
mind,
every
you don't,
contract, we do amendments, all the time.
Can we go back to, refresh me on a real quick bullet point, what our, because I agree with the two of you, like, the language I like, but the idea of using it at all, I don't know that I'm on board with. But what's our original core reason for defining this? I remember, I was here, but
Hard money.
we're just trying to flush that out.
I think what it was is, at least when we had back in the day when we had a seller's market, buyers wanted to make themselves look as good as possible. And so they would say, look, I'm gonna bring you a cash offer. They don't say, but I need to sell my home first, or really I need to get a loan and I don't know that I'm gonna be able to qualify. So buyers were taking a risk that they'd be able to come up with the money, they'd write it as a cash offer. In a perfect world, the answer is, well, why doesn't the listing agent look in the mirror? Why didn't you do your due diligence before you accepted that cash contract? But we all know that that's not, we don't live in a perfect world. They don't comply with that. And there's been some abuse of people submitting cash offers. Personally, I don't see a problem of making a disclosure as to whether you have the cash or not. Or I may change my mind to get a loan. Because if there's a misrepresentation, as long as the buyer is able to perform, there's no material misrepresentation and it's not actionable.
No damage.
There's no damage, but it puts the burden and the risk on the buyer that you tell us whether you need to get a loan or you need to sell your house. And if you don't, yeah, you're right, it is a misrepresentation and you should be liable. But if you're able to, if you change your mind, I am gonna go get a loan, and you're able to do that, fine. But the burden is on you, when you say it is a cash deal, there's a stronger burden on you, the buyer.
Why don't we just require proof of funds?
Well, there is a comment in here that suggested some interesting language. Instead of saying you have to disclose the financing terms, right? And when you're not paying all cash, is making a representation of buyer currently has an immediately available funds available to pay the sales price. And I'm paraphrasing it, but it's a pretty concise sentence in one of these. So it removes it from the contingency, creating contingency to a representation.
Now, the only question I have, and why I like the disclosure, is because now we have different ways people are paying cash. I mean, they're using Homeward, they're using Up Equity. I can keep calling all those different companies that actually are providing the cash, right? They're basically buying the house and then they're selling it to the buyer after the fact. So those are always disclosed. They always send us letters of disclosure and proof of funds. And if anybody wants privacy, I guess it would be them, because when they send me a disclosure, there's a lot of money in that account. It's not just, so we do have a lot of those going. I mean, Homeward, Up Equity, there's like 4 or 5 of them.
So you have a comment on the tip of your tongue?
Well, I'm trying to give everything equal and due consideration. I think someone had also suggested maybe we just say not financed. I think that may go more towards the hard money issue, because the hard money's not going away. The market has changed, but the hard money has not. It's still happening and people are still being misled as to what that means. And the same challenge, I mean, we have a lot of problems that don't happen a lot, right? The whole 5% rule. But we have at least one problem that does happen a lot, and that's where we get to 2 days before closing and they find out their hard money lender needs to appraise the house they're buying. And that's a problem for the seller, and that seems unfair to the seller, from my perspective anyway. So that's the most important piece of this to me. I think what we've drafted helps that, and I don't really have a problem with somebody having to do an amendment later, because we always do. I mean, that's not an argument. And the privacy issue, again, I don't see that, I mean, if I ask for proof of funds, which, I mean, we all should be doing, and not everyone does, but when you ask for proof of funds, that could be, I mean, I'm thinking that's more of an invasion of privacy than this. And if they wanna use all those things they're worried about, it specifically says all they have to do is disclose it.
Let's say the situation with the amendment, that me as the buyer, I put all cash, and then I decide I want to change later to financing. Getting the seller to sign off on an amendment, switching it over to financing and creating potentially the contingencies, I think that's where the difficulty will come in. The seller's like, no, you told me you're gonna pay cash.
You shouldn't have to cash, you signed off, you shouldn't,
Yeah,
you
you made a
shouldn't,
commitment.
you should, yeah, that's right, you shouldn't be
Even
like betting
so-
on, well, I'll be able to get out of it and change my
But
mind
even
later.
so, I mean, I hope I'm not the only, Mary, back me up on this, but sometimes the seller isn't gonna sign that amendment that changes the financing until we have clear to close. And once we have clear to close, the seller, okay, I'll sign. And that happens it's before closing, I don't see a problem with that.
It happens at closing a lot,
Can-
just sign off to make the deal fit what's actually happening.
And could I make a point as well? Remember, we need to read this paragraph 3A in conjunction with the change we're making to the third-party financing amendment.
Right.
And we added a category for other financing. So when you have the hard money, again, it gets to disclosure. You're gonna use a hard money lender? Tell me about it. I'm not saying no.
And you can still check the box that says it's not subject to it.
Exactly.
Right.
And I think that kind of goes along with what we were talking about, going back to the very beginning issue was agents don't understand hard money. It's out there. It is going to stay. How do we clarify that, disclose it, protect everybody involved? And to your point, we do have that section G added to third-party financing addendum with the idea of it going along to say how this is really happening. So I think we're heading in the right direction.
Well, I think what we're gonna invite, at least immediately and probably for several years to come, is a lot of confusing addenda that I think are gonna come from the sophisticated parties who are the ones that we're trying to solve the problem against. They'll see this, they'll say, oh, okay, I'm gonna draft an addenda, attach it to it. Brokers are gonna see this and they're gonna go, what's this? And so I think you're gonna be inviting that kind of confusion because you have it in the comments. And I think we already see that pretty prevalent in the comments. While I understand the issue here, I think the more direct attack here is to do what John recommended, which is to just deal and have a good statement that says you have the funds available, right? And we make that representation. And then that way, if I want to go and use my brokerage account or whatever, I have to liquidate in order to avoid a breach if I go there.
But I'm still gonna ask for proof of funds.
That's fine, you can still do
So I'm
that.
still gonna ask for that account to say, do you have the
And
money?
you can still do that.
Okay.
That's what I think is the more direct approach.
But not everybody
This
will
approach.
ask for the proof of funds.
Well, they
Like,
should.
we talked to- Understand that they're not, but we have to be realistic, they're not, and I guess to your point, we're at least making a representation that it's there, and then if there's a problem down the road.
Yeah, when I get to third party, there's questions I have about you.
I think it's a simple, the way it's written here, it's cash is not borrowing. And if you're gonna borrow, tell me about it.
So
And I
That
have
was
no
the
problem
But
with
see,
it.
that's the problem, is that a lot of people look at this and say, no, non-collateralized borrowing is still a cash deal.
No, well, not when you say cash portion does not
I
include
know, but
proceeds from
what I'm
borrowing
saying
of
is,
any
in
kind.
the marketplace, a lot of people think if I've got a line of credit of $1 million, I can pay cash.
Well, let's look at the actual comment that was suggested. It's on page 58 of the materials, in the third paragraph down. And this was what I was indicating earlier would be an alternative to the language that we have in 3A. Page 58, and this is from, let's give credit where credit's due. I believe this was Don's comment. So Don Moore contacted both Ron, myself, and maybe some others for a very extensive conversation about this. She's very passionate. And she made a comment of buyer warrants and represents that buyer currently possesses the cash portion of the sales price and immediately available funds. So what we do here, or what this does, is makes the representation that we're concerned about in terms of the hard money guys, right? By making that statement there, you're saying you have it. And that if you are relying solely on a hard money lender, then that statement would not be true. What this does as well is it removes the requirement then to disclose the other financing in the third-party financing addendum. You wouldn't have to check G, right? If you wanted to go finance, you could, but you're not having to disclose it. You're telling the seller, I have the money. And then you have the open flexibility to finance it if you want, without having to amend the contract.
So with these, I guess, would you call homeward and up equity hard money? They're really not hard money. They're, I mean, how would we, I mean, as a listing agent, I wanna know where it's coming from.
Well, and what their representation is the buyer is that I do have it immediately available because they're telling me they'll give it to me.
Right.
And then you can request proof of funds too.
And that's where you'll get that.
I'm okay with what Dawn has suggested there.
Yeah.
I think it's very clear.
Is there such a term as cash equivalent? We're talking about these things where, okay, I've got stocks, I can immediately turn them to cash.
And I think that's what immediately available funds
Yeah,
goes into, kind of the cash equivalent.
I don't think the phrase cash equivalent is gonna satisfy the problem with the hard money.
I agree.
I agree.
But like I said, I am comfortable with either what we drafted or what Dawn has
What-
recommended.
In what Dawn has recommended, we have some kind of other reference point for what we find to be immediately available. I mean, I'm not trying to overlord, but like, what is immediately available? Like, I knew I could get it in 10 days.
That's what I think.
Yeah, I have publicly traded stock that I'm going to sell before closing.
Okay,
That's
now
not immediately available funds.
that is not immediately
How
available. You're
quickly
saying
is
write a
it?
check now, you're saying
Right.
that's not,
If we
that
could
doesn't
just,
Yeah.
if we could just train everybody to get more earnest money, this would be something.
what, like 20%?
Well, whatever the cash portion is.
Oh.
But
Well, the major difference between these, what we have now and what's there is that what we have now would require, if you use theme financing, to have the third-party financing agreement, because it has to be disclosed elsewhere in the contract. Where the language that Dawn is suggesting, and Ms. Moore is suggesting, is that we're making representation and are not going to require you to use that addendum if you end up financing.
Her language is more problematic for me.
And which way?
what's the concern?
In that you're making an affirmative representation that you currently have the cash to close. And that is not necessarily the case.
As a.
The way we have it currently is that you're saying, I'm gonna bring cash, and it's not gonna be in the form of a borrowing or proceeds from the sale of my house unless I've disclosed it in the contract.
You know, I agree with you, because when you enter into this contract, let's say you do 30, 45, whatever your close date is, you don't have to have that cash until closing. So the idea that it's immediately available when I enter into the contract is really not what is contemplated on the contract. Contemplated on the contract is I will bring you this much cash at closing. So I have my 45 days. It shouldn't be immediately when I signed on.
What if the word immediately was removed and available by out of before closing?
That makes sense, but you're already obligated to do that anyway. You
Yeah,
don't even need language for that.
The-
If you're trying to get rid of the hard money concept, then we need to put something like it
I don't,
doesn't include borrowing for cash.
yeah, I would like to
Which is
clarify,
what we
I don't
have.
wanna get rid of hard money.
You wanna
I
know
just
about it.
wanna know about it, I want
Well-
it to be disclosed. I think that,
Yeah, I
you
said that
know, I mean,
wrong.
it's an option out there, let them use it, just make them disclose it.
I'm sorry, I said that wrong, yeah. We're not trying to eliminate it.
And I think personally, after I got over the hump of the contingency, you know, when in our last discussion, I was okay with the language we had. My hang up is creating a contingency out of this, not just a representation. And so, you know, looking at this language, you know, that Dawn draft, I can see the issues with immediately available funds. But there's issues, like you said, with having
I think there's a cure in Don's language. If you go to paragraph 19 deals with enforcement of the representations and says that if it's untrue on closing day, then you have a default. But if you make a misrepresentation, let's say by accident or whatever the issue is, then you can cure that by the closing date. You're not in default.
Well, I can tell you when somebody puts cash in there as a competent agent and saying immediately available funds, I'm gonna want something to show me they have the funds. Now again, and hopefully trigger a conversation where I'm gonna find out what's going on. And I think it's gonna be really hard. I mean, either one's fine with me. I think it's good. We have a really difficult time trying to protect the public from wildly incompetent agents. I think that's just, I don't think we can fix it. I don't think we can make the form where incompetent agents can perform.
And to throw this out there, if we do make this change or to see, that would be a substantive change to the contract. So where we're looking at, we're going to have problems either way, I think. The language that we've drafted, I say problems, we're gonna have a lot of misunderstandings from the license holders and the public about either language. And if we made the change to Dawn, I personally prefer Dawn's language, but I can see the argument for this language. And if we changed it now, and we discussed this thoroughly at our last meeting to come up with this, and I think we put a lot of thought into it, I think that I would suggest that we stick with the language we have now, even though I like the other language better, because I understand there's going to be issues on both sides. And this pushes it down the road, and if we get the feedback back after it's been in use, then we can look at going back to the representation side and address it then. But this gets the ball going to address the core issue of the hard money lending, the disclosure to the seller, and advances the ball instead of kicking it down the road.
We also have 3 hours of contracts that they all have to take.
Yes.
So it should be very clear, once they take that class.
But not all the educators. I mean, some of the educators
Email.
sent responses. Just keep that in mind.
I'm for our original language. I don't love everything about it, but I kind of like Dawn's a little bit, but I'm for our original language.
And I don't want to shortcut the discussion here, but I'm pretty sure we thoroughly discussed this last time to come up with it.
And she is.
I would hate for us to dwell too long on it, but does anybody else have any other comments
I
or
have one last
suggestions on that?
question. And, as far as either Dawn's language or what we've already proposed, which do you think is likely to be more clear to the consumer who's not working with an agent? Because they're using these forms without an agent or an attorney. And so.
Well, that's the brokers in dealing with their clients. How do you think they will react?
I think most people believe cash is cash. You're getting more sophisticated when you're starting to talk about borrowing hard money or doing different things like that. That's more sophisticated people, and I think they'll be okay.
I think if
With
we're
which
comparing
version?
the two as they appear now, because we have cash portion set out, is going to draw attention to it as a clarification, more so than it would be another line such as Dawn's, so I do like that as well. For now, I think the consumer and the average agent would draw their attention to it, and probably of the two would be more helpful.
It's good feedback.
Is there any, I know some of the comments related to, selling other property and not wanting to use the addendum. How imperative is it that we have, I mean, it seems like the bigger issue is the borrowing as opposed to selling other property. Do we?
Well, there were 5 comments on the selling of other property.
Yeah, it says other than disclosed
Except
in
as
this
disclosed
property,
in
in
this
this contract, I'm like, that's pretty clear.
Yeah, and that would mean the addendum, the
Yeah.
sale of other property.
Yeah, and we want them to use the addendum. If it's indeed not going to close, if that other deal doesn't close, we want the addendum.
But the whole intent of the addition was disclosure,
Mhm.
the representation point.
If
is
it's
valid, though.
contingent, it needs to be disclosed.
And then
And
it
we have
pushes-
had some that didn't do contingencies because they wanted the
Exactly.
house, and then all of a sudden, they can't sell their house, so guess what? they're bailing.
And it pushes them to use the addendum, which has the seller protections in there, but the date, the deadlines and stuff that come with it. So I think that facilitates that transaction better than finding out right before closing, oh, couldn't sell my property.
So if, to correct this issue, and I agree with leaving this language as is, but if you have a situation where you're gonna borrow part of your cash at closing, does that trigger anything in potential language for third-party financing? Should we make a provision
Well,
that,
that's the other
We got-
financing.
yeah,
We
so does that reference, okay, I am gonna borrow from my 401k? So I can't really say that unless I then amend that contract by way of my financing addendum?
Could
That's the
I,
intent.
could I not put in paragraph 11, which now allows us to make disclose factual information, could I not say, buyer may use 401k funds to pay the cash portion?
I'm just saying for
And
those
that
that
has
say,
now been disclosed in this
yeah,
contract.
that's, right, that's what I'm saying. There is a way that I can disclose that I am borrowing some of those funds.
That's a very good comment there, because you don't have to use the addendum, you can just disclose it elsewhere.
But it says he may use 401k funds, but he's.
I may
you're not
borrow
disclosing
from my
borrowing.
401k.
Right, so, but you can simply do that in the financing addendum because there's a
I could,
provision in
yeah.
there. Which
Okay.
means then raises an enforcement question, if we have a form that addresses the issue, then you have to use the form,
no.
right?
Right?
But third party
And that's
is
It's
what
a
third
not,
party
fact,
that's
is.
third
it
party.
is
but
disclosing
you have a-
factual information.
You have a form that addresses that issue.
Right.
But if it's forward.
And the form requires the details of the loan, instead of just generally saying, I'm going to borrow from my 1030 or my
But you can put
401k.
in 12% interest rate, you don't care, right? It's a maximum interest rate.
But third party wouldn't be taken for my 401, that just means I'm just disclosing, I'm taking the money from 401.
Well, it's technically borrowing it from yourself.
If you're borrowing and not just
And
withdrawing.
you'd have to put that down under G?
It's borrowing.
I agree with you, I don't know that, it's not a third
I don't
party.
like that
I don't
idea
know.
at all, I like the
Put it in
fact that they
special
said
conditions.
Take it out.
utilizing
401k.
How would you write that?
401k.
Well, I think you're gonna have an educational
Is that
question
wrong?
that pops up. So-
I didn't hear what
How you guys want to address that?
Sorry, but I would think it would
I
need
think the
its own
same
paragraph
conversation is
again.
happening.
Yeah, I think we
Yeah.
have.
Oh, sorry.
Sorry, yeah, sorry.
No, I think it's just, you're both
Yes.
talking about the same thing.
Yeah,
Same
good
thing. Are we right?
information, but we're not on.
Yeah, go ahead.
No, they were talking about.
Okay.
I'll summarize. We said that if you are borrowing from your 401k, it's not a third party. So it does belong in special provisions. If you're borrowing from a third party, then you use the third party financing addendum and then do one.
But if there are terms and conditions, and when you borrow from your 401k, you're getting a loan. It is your money, and if there's an interest rate, there are payments, if you take it that way. Or if you just take it all out and deplete your 401k, that's a different way of taking it out. Just did it, that's why I know it. So then the question may be, do you disclose it in special provisions that that's where the cash is, and do you have to? Is that any different than taking out of your savings account? But if you've got a structured loan with an interest rate, then maybe G in the third-party financing is where it needs to be disclosed.
I think only if there's a third party in it.
Yeah.
Third party,
But isn't your 401k lender, I mean, it's your
Yeah.
money, yes, but you're going through your 401k and you're getting a loan. You're making monthly
Well, if
payments.
you're getting a loan, I get it, sure, that, I guess that would be a third party that you borrow from, but if I'm gonna go close with cash, I don't wanna have to tell you that I'm gonna go sell, not loan out, sell $20,000 to get the $20,000 to get in there, like that's frankly none of your business, I'm showing up with cash, I told you I'd be there with cash, I'll see you with cash. If you wanna know where I'm gonna get my cash, then your listing agent should have said, where you gonna get it? Here's my proof of my 401k.
I think it's that kind of argument and attitude that we're trying to help the agents with, because you do have people with hard money, they have this attitude that, you know, I don't have to tell you anything, I got the money.
Well, that'll be part of my
And always
presentation to
make
my
things
sellers.
exist.
Okay,
That
which
you have an
would be
attitude.
different from, remember, borrowing from your brokerage account, because you are borrowing from a third party at that point.
Sure. If you borrow from your brokerage account, you are borrowing from the third party. If you cash out,
They only have the right to foreclose on your brokerage account.
right. Oh, true. Yep, you're right.
So this may be difficult for the minutes today, but I think we.
Yeah, thank you.
That we,
Getting into this level of discussion, Brown, don't worry.
It's but I suggest that we move forward with the language as we have drafted. See how it plays out with an asterisk that when we go through the comments later, let's see if anything changes our thoughts. That's a good summary. I think we went through most of the people's comments here, but I don't want to shortchange anybody, because there are a few outliers. So I would suggest that we move on to the next paragraph that we made changes to, and then come back at the end to approve all the changes together. So the next change we have is in paragraph 5, and this was changing, really just capitalizing escrow agent. There was one comment in there that wanted to change escrow agent to escrow agency. And they attached one of the contracts or form that actually listed an individual's name in there, not the actual escrow agent. And to step back for a minute, we have a title company, which is what you think of like the Fidelity, Chicago's, First Americans that are actual title companies. Then you have agencies that are independent agencies that underwrite for the underwriters. And escrow agent is meant to be just that. The escrow agent can be still First American or Chicago Fidelity, whatever it might be, but it also could be an independent agency itself by any particular name. So there's confusion on that. We've been over this in several meetings and always said, has it caused any problems? And is it more than a 5% rule? We've always fallen back on the 5%.
Lately, we had some outs on that because they would accept a contract that said Mary Ann Smith, not the agency, the actual agent, and Mary Ann Smith changed companies. So now there's a default in the contract. So I know when I teach, I'm like, just like broker, it's not broker, it's brokerage. Escrow agent, it's not agent, it's the company. But that's why they're confused, because some still put Mary Ann Smith.
And I see it more and more.
I do too.
And I do know of at least one school that's teaching it that way. So,
Teaching that you should say the individual?
yes,
Oh my gosh.
Well, there's been a couple things that have come out this last year.
I can remember the days of Dick
because I-
Hargis, who worked for HAR Legal Counsel, and when they did, this goes back 20 years, always teaching, do not put the person's name in. For the example you gave, what if they change companies? And even the paperwork that was submitted now is the same thing. And I think the word agent is very confusing, and it only fosters the very favorite closer to have their name in there as opposed to the agency. And I would strongly suggest if we have the opportunity to change it from agent to agency or escrow company or something that is going to take it to the entity as opposed to the individual would really help.
I agree.
again, I get the 5% rule, but I also think this is an easy change and why not?
Yes.
And we said it happened all the time. It just created issues in less than 5% of the cases, but it does happen more than, I think, the 5%. Is, Brian, for agency, is that I know agent is a proper term, but is agency equally valid as agent in terms of the TDI regulations?
So you say escrow company?
I think you're assuming
Yeah,
that
but
people are
technically
gonna
we're not
read
escrow
that word
agents
and
in Texas.
make
Oh, yeah.
a distinction.
At the risk of being laughed at because I like to add words a lot.
Well,
Note,
there is that.
the escrow agent should be the company holding funds, not an individual.
That should be what they go with. The agent technically is not, the agent is the agency. People are just putting individual names in there when it
Yeah.
should be,
Right.
So he's saying add a sentence.
I think that's
I don't wanna add a
education.
sentence.
I think,
mean,
I'm with, that's
Is there-
education. They should know not to put the individual.
It doesn't work that way. We'd like to say that it does, but because the word agent, they're an agent, they think of it as being a person. I know that may seem very basic, but if we can help the cause.
Insert the name of the company, not an individual.
You could put that in there.
So,
I hear what you're saying.
did you
going
give
forward.
a reason that we can't just say escrow agency?
Well, no, I was asking Brian if it,
Why would
For
you
some
do that?
technical
He always
reason,
adds
yes.
words.
but, I like keeping it short and changing it to agency as well. I just want to make sure that's a proper change. I think it is, but I just want to make sure in the TDI regulations that we're not using agent for, I know what that means, but changing it to agency, I don't think matters. I just don't want to.
Yeah, and that was my question, is if there was
Wasn't Ryan saying though, the term escrow?
How long have we used the term escrow agent?
Thank you.
It's been
Years.
quite a long time, I think.
I think you are making a big assumption that by changing 2 letters in that word that people are gonna change.
Yeah,
Yeah, it may not make a difference, but I'm just thinking we have an opportunity, it's an easy change, why not?
I think
It can't hurt.
it will make a difference.
It's not gonna make it
I personally do.
worse.
Because we see it quite a bit, as you know,
This will give
In
us
there
a
it
chance
is.
to educate, again, as we're going over all the changes, and restate the fact that you're not supposed to put Sally Smith in there, your very favorite closer who takes you to lunch. It is the agency.
could you say
The
company, not individual?
What?
Yeah.
well, no, because an agent is a legal term of art.
Right, so that when I think of
So-
agency, I think of that as a different type of noun that, now we're getting grammatical. When I guess I get it. I understand where y'all are coming from on their confusion. They think, oh, that's a person, because I'm an agent, that must be an agent. But I don't know why they, I don't know.
Let me ask this too, is changing those
They do it
two
because-
letters a substantive change or not?
I think
You
they do
can't
it.
email it.
I think they do it because the escrow agents market to them
I don't think we
heavily and
should
say,
be
put my
making
name in there,
decisions
put my
based
name in
on
there,
it.
put my
Right,
name in there.
Well, no, I just wondered, because we can put this in our bucket, right? And if we delay the contract by making this change,
I just, yeah.
and whereas opposed to keeping it for next time as a good change and noting,
Brian has a
Take no
crinkle
advice, but-
forehead.
The defined term in the procedural rules is title insurance agent.
Okay.
Okay? And that is, and it can be an individual, but they have to be licensed by Texas Department of Insurance.
Well, no, that's the agent for the title insurance company.
That's
right?
the escrow agent,
But the escrow agent is the agent for the
No,
purpose, for the purpose of closing the
Yes, and it
transaction.
doesn't
Which
have to be
is-
the title company. It could be a law
Right,
firm.
could be a lawyer.
Making-
Could be a lawyer.
Which is
that's a very good point.
So,
So I think we're talking
Not
about two
everybody
different
closes
animals.
at a
Now, they
time.
may have a definition of escrow agent, but
What if
Yeah,
we
it's
take,
not always the same 2 names in the blank, if you do it right.
we'll put this in your bucket.
yeah, I think if,
Yeah.
at least, we're at the threshold of at least continuing this discussion, because I do think that it happens a lot, we all knew that, and I think the issue before was it wasn't causing problems. But we do have somebody addressing it in these comments, you see it quite a bit.
And our
I
change
think all
was just
of
to
the
capitalize in
should be
essence as a
that
defined term.
Correct, we're not changing anything other than making it,
But if it's being
Capitalize.
taught, I mean, I know who it is, but I mean, if it's being taught, that put a name in, that's the problem.
Well, that needs to be
Maybe we should be bringing that
Yeah,
up.
but none of us are
Yeah,
gonna
but
bring it up
that's-
to that instructor.
No, but
Well, but
maybe
that's not.
some.
Bring it up to
Right,
trust.
That's correct, that's not.
Well,
That's
and
how it works.
it theoretically could be an individual, if we're looking at an attorney, and then if we put agency, are we limiting individuals? And practically that hardly ever happens, but
Yeah.
it could
Could
limit
be
it
an
the other way.
individual. Yeah.
there have been some in East Texas.
That's it.
There's still some lawyers who do
That's the
closing.
East Texas rules.
Yeah. Nobody reports that they have it, yeah. I'm just saying, is there are a lot of attorneys that still handle closings and,
Yeah.
you know, they may do
Yeah, there's
I
fee
run
officers
into 'em.
all
But
the
wouldn't you
time.
put that law, like John Smith Law Firm as the agency?
if it's a firm, yeah.
Well, now we'd have to put John Smith.
That's it. Yeah, that's it.
Yeah.
So what if we take a straw poll of, I think this is a good discussion. I'm not sure it rises to the level of making a change right now. But those in favor of keep putting this in the minutes and continuing the discussion to the next meeting.
Well, question,
Go ahead.
to your point, we don't really want to do anything that's gonna delay the contracts moving forward. And is that why you're asking that question? Because this would delay the contracts moving forward, or do we know?
I think it's kind of twofold. One, I'm concerned about delaying the contracts, but two, I'm not sure we have the exact answer. That is the best answer for agency versus adding, I'm not in favor of adding words, but adding a sentence and looking at it more individual versus that. And with the time we have today, this is a new thing that it really, we just capitalized escrow agent. It wasn't a substantive change in here. And so I think it deserves more discussion. That's why I think moving it on so we get to the more substantive changes in here is why I'm suggesting that. And that's why I want to ask if everybody's in favor of that or address it now.
Would it affect,
Did the answer?
would it affect the
I gave you a lawyer
contract?
answer, so.
I think we just said it I wouldn't move forward today with this sort of overwhelming fear that it's gonna delay the contracts. I think it's important to note, like, to ask those questions of like, is something like this, but really when making these changes, I think it's really crucial here to just really flesh everything out. And then see where we land, you know, towards the end of the day. But I think I would just say, I tend to agree with you, this is something that just came up, maybe defer that for further conversation later down the road.
And that's what I'm suggesting.
Yes, right, I totally agree, I think it was just, you know, sometimes things come up, and you start talking about them, like, let's do it, and then, you know, 2 weeks later, oh no.
And this is kind of outside the substance of our change, right? This is a new change.
Well, it definitely seems significant enough that we need to bring it up later, but I'm for just hitting the agenda, and maybe definitely bringing this back up at another time.
Agreed.
Can we at least capitalize it, or is that?
Yeah, well, yes, that's, yes, that's.
Yeah.
Make or bold, or put it in bold, so they, you know,
And
it
oddly
will
enough,
bring
when you
attention to
capitalize it,
somebody.
may make a difference.
Yeah, that's true, when we teach it and they see these changes.
Yeah, maybe it does, huh?
Okay, so with that, we'll move to the next change in the contract, which is the survey section, 6D. What we did here is merely
Lowercase.
making it lowercase. And there was only a few comments on this issue that I think we wait until we flip through those to get to those comments. They were essentially, we need to make it bolded or make it capitalized, so, because the survey is so important. And then there's some other survey comments that aren't addressing our change that we can walk through.
Yeah, I just noticed that in those sentences, commitment, exception documents, those are capitalized, and survey was, and now it's not.
Those are defined terms in the contract, and survey is not. So that's why those are capitalized. And that is one of the comments that was raised, with why are those and
Yeah.
not survey. But I did go through and check and make sure those were already defined. Okay, next one we have, which we had a whole lot of comments on, was in the required notices section, or the title notices section, paragraph 11, required notices. And there were a lot of varying comments on this. 4 said it was easy to miss being buried in here. And so let me step back before we get into that. What we're doing here, there's several types of notices that have to be given at or before the time of contracting. And if they're not given, the buyer potentially has an out in the contract all the way through closing for some of these. And so it's a very important event to happen in the contractual negotiation and execution. What we had before in the contract was the PID notice in paragraph 22 with all the other addendums. But then we discussed, well, these other notices have to be provided as well, the MUD, WCID. Why don't we add those to paragraph 22? And then we decided, well, they really aren't an addendum. They're not a part of the contract. And I personally had several agents call in the last few weeks with that exact dispute. Which one's right? Is it part of the contract? Is it not? And in here, you can tell in the comments, we have a lot of people with that misunderstanding, whether they are or are not part of it.
It's a lot like the seller disclosure.
Exactly. And that's a lot of the comments too about, well, it should just be like the seller's disclosure, or we should add the seller's disclosure to it. So what we decided to do at the last meeting, in debating on where it should go in the contract, that it wasn't really an addendum. So we wanted to put it in the title notice section, because really it's a notice given to the parties. And so here it is in paragraph 6E11, where we put required notices and say they have been given or are attached to this contract. And then we give a few examples. So the comments, just to run through a summary of what we received. 4 said it's really easy to miss being buried in paragraph 6E11. 5 wanted it moved to paragraph 21. The paragraph 21 is the notice section, where you list the notice, where to give notice to the parties. 6 wanted it moved to paragraph 22 with all the other addenda, and where they thought, well, that's where agents are looking for these things, so that's where they should be. 1 wants check boxes, whether you actually receive them or not. 1 was concerned about the paragraph 6E7 language, which indicates that PID notice is attached to the contract, which was interesting, and I don't recall us talking about that last time. But the Public Improvement District 67 at the end says an addendum containing the required notice shall be attached to this contract.
Mhm.
So that's something we need to look at. 2, want the lead-based paint and seller's disclosures added to the list. 2, think that the parties are, that parties will think they are a part of the contract itself, not just notices. 1, questions why it was removed. I think that's why it's removed from paragraph 22. And 6, want the non-realty item addendum listed in paragraph 22. And so those are, again, an informal summary of the comments there. But I think one of the main ones to address first is where this goes in the contract. We had a very long discussion last time of the need for this because of the draconian penalty to the seller if they're not provided, right? The buyer can potentially have an out all the way through closing.
But that's the thought.
So I tee that up. A lot, we have about split. Half wanted in, that commented, wanted in 21, which is the notice section, and half wanted in paragraph 22. We didn't have any saying they really liked it here. But what can you, tee that up for thought?
I might spell it out more. I mean, if you had, we're gonna put it in this paragraph 6, okay? We already have public improvement district, so we have that one covered. Why don't we just have the other 2 the same way?
Well, that's not an inclusive list necessarily, all-inclusive list.
No, but I mean, the ones that are required, the mud and the PID, and there's certain ones that are absolutely required at the contract.
But what we're trying to do is get it, go ahead.
Or before the.
Well, I'm just saying, what if we made this 611 look more like 22? So that we have a section that is required notices and we have a section that is addendums. That way we're keeping them separate. We're going along the rule that they've taught or has been taught, right? Because, we've always told them notices are not an agreement, they don't go in the contract. But these are required notices, so I understand why we put them there. But if they looked more alike, I think that it would be a better understanding of the difference.
I think that solves the problem of it being easy to miss, which was a lot of the comments. And it would turn it more into like paragraph 22. And we can add the other box, the main ones and then the other box. That can be
It's
put
more
there.
words.
I can see him smirking over here, he's liking it. What about that? Anybody have thoughts on?
Where would you put
It
it?
would lengthen the contract.
Where would you put it? What section?
So keeping it in paragraph 6E11, but making it like paragraph 22 in terms of
Checklist.
listing it out with checkboxes of what has been provided.
And so we would have a check box for everything that is
Required.
statutorily required, and then an other box for things that might apply for Gillespie County or versus Pearland or something like that.
Exactly.
Correct.
Yeah,
And I think if we do that,
you have to move
then
seven.
exactly, what's in 7, we take that out and move it down to 11.
I like that.
I don't have a problem with where you put it. I do think that since this whole large paragraph deals with title notices, which is a question by itself, is that a right title? But I'll defer that for other meetings. But you could put in here to make this issue with regard to required notices, dealing with issues of districts or title issues. In other words, it's not the kind of addendum that you're attaching, but rather things we're focusing on being already under paragraph 6E, or excuse me, 6E, whatever it is, 6F, whatever that is. So I don't know if that helps, just to clarify that we're talking about title notices, whatever that means.
What are you saying though? You're saying a description or something, or change the title? What do you mean?
Well, what we have right now is we say required notices. So the following notices,
Right.
but really what we're talking about are the types of notices that you would normally see under paragraph 6.
Yeah, they're not necessarily title notices.
But they,
I get what you're
and
saying.
remember, they don't have to be a part of the contract. They can be given before the contract.
Yeah, and then that's the other issue here is that if they've already been given, you don't have to attach them. But I suspect copies are going to be attached anyway, just to show evidence that they've been given.
Can I point out too, if people liked this phrase, they're not writing any comments to it. So I know we're getting caught up in a lot of people just like now, if you have it, I don't see a problem with the way it's set. But
Yeah, unless you wanted to make a check the box. Mud notice, water notice, private transfer fee notice, which is required.
What would you call that, 6F?
I like it
I
because.
like it, and I
I
would,
do too.
instead of required, I would say say the word,
Statutory.
required notices.
And so that's 6F?
How about
And take it out of the E?
No, because there's all kinds of notices that aren't required. I mean, like, if
Just say
you just say
It's a whole
notices,
new-
then they
The
start
following
putting in
notices
seller's
have been given
disclosure.
or attached to this contract.
At least required.
Because it doesn't really go with transfer fees and propane gas system, so is it a 6F?
That would highlight it more, and we have the separate contracts. What we have in 6E are really the boilerplate notices, right? These are ones that we need to put in there to make sure the seller meets their obligations in general. And so I can see it staying in there or 6F, and if we had that with the checkboxes, it definitely would highlight it.
I'm good with 6F.
Yeah, because I think 666 or whatever, what are we talking about, E6 or whatever, the property located in the utility and the PID needs to be more relevant that it's required, because I've had people walk. I've had people walk because they were not supplied those notices on time. It was another out, of course.
Well, the idea of there being basically a list of things that are required would be very helpful to consumers and license holders.
Especially those that are from areas without a lot of water districts, for example, and coming into the urban areas. And that is one of the commonly missed notices that are out there. And traps a lot of people. And it gives that buyer that absolute right before closing to terminate, another option essentially.
Does it matter that the PID notice is an addendum?
Well, no,
I mean, it
it's just a
actually is
notice, though.
Addendum 53.
Is the PID an actual addendum?
Yeah.
Yes, it
Addendum
Yeah, there are
53.
some like the coastal areas, those have to be addendums.
Yeah,
well,
If
section
it's an
7 says
addendum, then it goes
addendum
to
containing
22.
required notice.
And
shall
then
be
that
addressed.
separation.
Yeah, and there's statutory
Maybe
form.
do
Yeah,
we
statute
just
requires
call
them to be
it
addendums.
required, statutory required
in-
forms?
Now, I will say that to be consistent.
Because you've got
if you
some
wanna look at
non-addendums in
paragraph
22
7
as
in
well.
terms of our,
Can we do one conversation at a time?
Yes.
Sorry.
So if we look at our lead-based paint addendum, we do reference the lead-based paint addendum in paragraph 7, and says you might have to attach it, and then we list it in 22. So I'm not saying that we have to be consistent, I'm just pointing it out. You want to move to 22?
So,
Blood-based paint is in 22.
No, I'm talking about,
The PID.
Yeah.
These
I mean, if
Well,
it's-
the PID was in 22, we took it out.
I think if it's an amendment, or if it's an addendum to the contract, then it should be in 22. But if it's a required notice, then it should be in our new 6F. And I think of, well, you know, like, if we don't say required, then we get the seller's disclosure and that kind of stuff. But what if, say we move the lead-based paint to 6F, which will at the very least be titled required notices. Now they're filling out a lead-based paint form on a brand new house because they think it's a required notice to say we don't know anything. So I
Yeah.
think that becomes cumbersome.
And lead-based paint is more than a notice.
Yeah.
Yeah,
And it's
exactly.
federal.
It
So I
has
think it does need
agreements,
to be in 22.
waivers.
Yeah, it needs, I think it needs to be in 22.
Well, 22 has some non-addendum forms in there. It's buyers and sellers, temporary residential leases, they're
Those
not
are
addendum,
those are
but
addendum.
they're forms part of the contract.
actually, all
So-
of these have more than just simple.
Yeah, so is there any reason why we can't have the statutory required forms together? I think it's gonna be much easier to understand by the consumer and the agent, and leave that as it is in this new 6F. And
What if we did 22A and B to keep it together?
Yeah.
You have the addendum in A, like it is now, don't change anything, just move the notice we have in 11 two required notices right beneath it.
So you have
And it's
a
all
laundry list of
together.
all of them in one
I'm
place.
fine with
It's
that.
just like creating a new 6F, we're just doing a 22B instead of
Put it
22A.
there.
I'm fine with that.
I don't think that would be substantive because we're keeping the language of what we did.
Pencil time.
Just agree with us. Just agree with us.
The answer is yes. No,
No, it's-
so what
John
we're
is right.
talking about
That's-
doing here, we generally like the language we drafted for required notices in 6E11. There were a lot of comments that it's easy to miss, and they want it moved to 22. So what we are discussing now is moving it to 22, have A, which are the addendums, and then B, which are required notices. So it's essentially moving E11 to 22B.
That's not substantive.
No, it's just
Formatting.
It's formatting.
Yeah.
We suggest the following formatting change.
While she's thinking about that, let me ask, I like it being under the 6, because that's where title notices are and where the explanation of those forms are, as it has a whole section for, we were just talking about lead-based paint, while they're thinking and reading it, and if there is a list with boxes, it's gonna draw their attention there. It would seem a more logical place for it to be where it is now, under title notices with boxes.
That's a very fair point as well.
Formatting change, keeping it as under F.
Yeah, I
Yeah.
just think it seems like a better place
Have
for
a
it.
separate set of.
It will now, the problem was it was lost, well, I think that would make it seem more apparent. I'm afraid it would get lost in this whole list of forms.
Yeah.
With the checkboxes added?
Yeah, well, with the checkboxes added, yes, in 6, definitely. I think if it's not added with boxes, then I would suggest it be removed there, because I agree that I think it would be lost. There's so much in that section, and it's so important.
Now, do we lose the concern of why we moved it over there, that having paragraph 22 have PID already, and having their required notices in 2 sections, is that some of the, because we want
Could
to
you say
call
that
out.
again?
So the PID notice is an addendum, was in paragraph 22. And we talked about moving that, or we did move it over to 6E. Do we keep it in 6E under what
I
you're
would.
suggesting?
Like the example of lead-based paint, that's an addendum as well. And it's not in that list, well, yeah, it is, but it's also talked about in 6.
Well, and I think in addition to that, you've got several of your other notice addendum that are also notices that are also talked about in what we're discussing. Gulf Coast Intercoastal Waterway, the propane gas, I mean, there's several of these that are in 22 that are mentioned in the section that we're talking about. So are we gonna move them all?
Good point.
And
I mean,
that
no.
might lead you back to, is it better to do 22 A and B and separate them? But I think if you move, to me, it doesn't make sense to have a checkbox list in 6F or whatever paragraph it is and not move these other one. I mean, you're doing 2 different things in the same thing.
So,
That, not a very good way to say it, but.
right.
We're talking about totally non-substantive changes. I think there are good ideas on how we would want to format these things, but I don't think it's something that we need to do today.
In terms of, you suggest leaving it 6E11 as it is?
Leave it as it is. And if somebody wants to revisit it and come up with a formatting idea, great. This is not going to be anything, I don't see any of this as being substantive. It's optics. Where does it look the best? And I don't think we need to deal with that today.
The comments that came up from those who made statements were repeatedly, it's gonna be missed, it can't be seen. So our conversation, I believe, is only to make it more visible. And then the conversation got more involved into the how you're gonna do it. So we wanna make that simple, just make it more visible.
And I think moving it to, the more I'm thinking about this, my personal view is paragraph 22B will make it be caught more on boots on the ground, right? The agent's using it, the consumer's using it, will be right there. It's the same exact thing, just 22B adding checkboxes.
So if you want to leave it as is and make it more visible, just add more lines to it. It'll stand out.
Well, then we ought to go to.
And they'll sit there and go, what can I write there?
Exactly.
What are the other things?
And bold.
I think mine's will never upset. So I think, and we were just chatting about this, maybe what we do today is, well, here's what I'll say. If substantive changes come out of today's meeting, it is not a major delay, right? So we would just re-propose in November, you'd meet in January instead of launching, I'm gonna say a January 15th form date, not do things on the 1st. You'd be looking at probably like an April 1st, right? So I would not, in terms of when the changes would go live. So it's not
not the end of the world.
It's not the end of the world, and, I think if we
And then in
take each
June-
item being like, no, it's not substantive, I don't know, I think, I want you guys to like really flesh it out and respond to the comments as you see appropriate. I'm all for some non-substantive changes and getting things done, but, maybe cue it with that in mind, which is like, really, you're not pushing it that much further out. And if you do wanna make these changes, so if you think, hey, you know what, that was a really good point, let's make that change, it is a big deal, then let's go for it. And if it's not a big deal, it's not, right? I mean, if it truly is in response and it's not gonna change up what people saw in the proposal, then we're moving forward in a way that's constructive. But I just wanna put those dates in your minds when it comes to the changes, like what does it really mean to re-propose and come back? Now, it does mean another meeting,
So,
which we love.
so when you open that door, like she's explained our calendar, when you open that door, then maybe go to April, then we go back to escrow agency, and then we go to everything else for the rest of the day that now comes in, because we're allowing ourselves to bump.
Yeah, and could I also, it may not be, although it's non-substantive and everyone talking about it, it may seem very simple. But we better be sure we have all the right boxes. And we also have to look at, do you have all the same boxes on all the same contract forms? So all of a sudden it becomes a little bit more complicated, even though substantively it's nothing of any real big significance. Getting it right is gonna take a little more attention to detail.
So would you see having those check boxes for the various required forms as being a substantive change, even though they're referenced here? All that's just doing is presenting them in a little different format?
And moving it to 22, right?
Right, well, I'm just saying,
Or
you
maybe
left it where it is now and just made boxes to show these are the required notices.
No, I don't think, that doesn't feel substantive
Yeah.
to me. That feels responsive to the comment of, it's hard to see, right? So does adding as Ron said, like adding more, you're addressing that issue there. When you start moving things in different paragraphs, I think you're getting a little closer, but it's still gonna depend on, I'm just gonna say, if I had to guess, by the end of the day, we're gonna have enough changes that it's gonna feel substantive.
So I propose that we work towards a 22A and B. And I do think that either a subgroup or staff, if they have the time, somebody needs to go through the whole contract and make sure that we're capturing all of the required notices and getting them into this new 22B. But if it's, if it's not something we can do today, then, I'll swallow that. But I don't want it to be a kick the can issue. I want it to happen at the next meeting.
So I agree. I think in response to the comments moving it, a lot want to move to 21 or 22. And everybody said it's easy. Others said it's just
21 's
easy
not
to miss.
appropriate.
Yeah, 21.
And so I think 22 we're all, if we move it, that would be the place to move it to, with a 22.
Not really. I
No?
kind of like it
Yeah, oh, yeah,
6
so-
because it has an explanation of what those forms are. And maybe it'll get people to read 6 and then see, oh, we gotta do the forms.
Well, it's just like what in 6 and in number 7, the PID says, an addendum containing the required notice shall be on this contract, and that's where you put it on 22, which I don't understand why we took it off of 22. Because it's telling us,
Yeah, and that's the only, I was thinking the same way you were to begin with. But I am in favor of 22 because we have so many things like that are required, but they are also addendum, and then things that are required and are not an addendum. It's, I mean, the legislature should decide that.
And it may be that we're going to, there are some very good comments that people have made that are things we'd be talking about in the future, and maybe making the 22 A and B maybe future, and fixing what we have already, the immediate response. But I think if you're keeping a list of how we're getting close to maybe being substantive by the end of the day, we can maybe keep it where it is right now with boxes and then reconsider.
So are you saying just leave it as we proposed it?
With
And then
With
they-
that checkbox.
Do boxes.
And
With boxes.
in 6E,
Yes.
6E, leave it as we proposed it, so we don't make any subs, so we can keep on the same track for getting this approved. And then later come back to add moving this to 22 with that escrow agency and those other topics.
Right, and I think
Maybe.
the what we're addressing here is easy to miss, right? And whether we move it to 22 or we keep it in 6E, we're addressing that issue. And I think some of the 11 comments for moving it to 21 or 22 were based upon it being easy to miss. So we're solving or responding to the comments to that degree.
Yes, well,
And I think in the bigger picture, I'm leaning towards paragraph 22, but I'm equally fine, I'm on the fence, I'm equally fine if we went the 6E, keeping it as it is right now with the checkboxes.
Yeah.
And then there's a couple comments of wanting to add, to address here in this discussion, to finish it out, adding the seller disclosure notice there. Do we
The
add
seller
that?
disclosure notice has an explanation of what happens if it's not received. It's also got the thing saying when it's not required. And the seller disclosure notice is not simply required on certain properties. It's required on every residential 1 to 4 family at least property.
There, summarize my thoughts.
Yeah.
Exactly. Anybody have any other thoughts on the seller's disclosure?
So I think it's gotta stay its own, yeah.
And the other one they wanted added there was lead-based paint, which is already in paragraph 22.
Keep in mind too, that many of these notices, they do not need to be a part of the contract. They just need to be given at or before the execution of the contract, which is the way we have it written here in 11. They have been given or are attached to this contract.
So just basically acknowledged by the buyer that they've received.
Exactly.
Yeah,
So what if we do this, and keep the notice the way it is, just make check boxes for what we already have listed with an other checkbox to account for the other forms. And then in 6E7, remove the reference to an addendum containing the required notice shall be attached to this contract, since we already have that substantively in our new 6E11.
Okay.
We take a vote on that one? I would make a motion to make that change.
and the reason for taking out the line in 7, an addendum containing the required notice shall be attached to this contract, even though it's stated in lead-based paint, for example, and others, what's the reasoning?
Well, it's repetitive and conflicting with our new section. So our new section says it either has been given or is attached. And so if you give it beforehand, it's been given,
Uh-huh.
you would then have to go back up, well, no, it's required to be attached in 6E7.
Mm.
And so here, we're substantively capturing that it's either attached or it has already been given. So we're just giving that other option.
and that's not a,
Isn't the title of the form addendum?
It's given.
I don't know why we took it out of 22.
We're trying to get it all together.
yeah.
I think we just think of mud and goods as the same
Well,
animal.
we have the same question in 9 as well, addendum required. So I think where addendum, the statute requires an addendum, I'm now suggesting we can leave that language there.
In 22?
In, no,
Oh, in 7.
in 6, 7, and 9, for example, both of those say the law requires this to be on an addendum, as in 4, I believe, as well. So I think those are
Yes.
handy. There doesn't hurt anything for them to stay. First of all, they're handy because it says this does need to be attached.
Yeah, that's a great catch.
So I would strike your last suggestion.
Okay.
So the listing is in 22, and we do our checks in 6011, but we take out the bid notice there, because it's an addendum in 22.
Yeah, I mean, I have no problem with the checkboxes there in 11. It's because it's just saying these notices are given or attached, and you check the box. And so I don't have a problem with that.
Right, but you wouldn't have the PID notice in 11.
Yeah, but it doesn't
But it's
hurt.
an
It needs to
addendum,
be.
it's an addendum.
Right,
it should
so
be
I'm
in
thinking
22.
that what you would probably want to do is add the others, right? Propane gas system service area. Okay. The,
You kept that there.
no, right here. Right.
No.
No, I'm saying if we're gonna leave it there and we're gonna have check boxes, why don't we have check boxes for all of those in 6E? All the ones in 6E that say it has to be an addendum.
Nothing says that they can't be addendums and be in 611.
Because on 6011, it says notices have been given or are attached.
Right, and
So I think they're gonna think they don't have to attach those addendums.
right, but if they read 9, which is a question,
That's
right? It
Oh, we have
says
to
addendum
say.
has to be attached if it applies. So why don't we have that there?
I think.
I mean, this is a good discussion.
Clearer.
We're getting down to make this
I
consistent.
think all agendas are in the same place.
So-
If we're gonna
this
say
may
they're
be-
not gonna read the contract, we're screwed.
How many agents,
I
how
don't
many
think-
sitting at this table really knew it
Let's
was an
leave it.
addendum until I looked it up in the list to be sure.
PID
So,
notice back in
I
paragraph
think we're
22.
trying to make it easier for the agents to not miss something. And I think Ron's point is really well taken,
Yeah.
and that probably is gonna be part 2, when we do that A and B of
I think we just.
22, to kind of maybe clean some things up.
Well, again, not just agents, the consumer is not using an agent. Are addendums in 22 or are addendums in 6? I mean, anything that says addendum, if it's in a bunch of different places, that's confusing.
You're right.
And it makes it easier to miss something.
Okay, but I mean, Brian's point is correct. This is a formatting issue. You can state in one place this addendum attached, and you can state, either repeat it again later, or you can refer to other ones. It's a style issue. Right now, we have this drafted this way, but if we're gonna add checkboxes, my question is, why are we just having those checkboxes there and not the others that are required to be addenda that are in 6?
My mind is shifting. I think Brian's point's well taken. What you say too, I think we need a change, and we need checkboxes, we need something, but what you're bringing up with it being conflicting in the addendums and stuff, make me worry that we're making a rushed decision
Yes.
that can impact more things that we're not thinking about forward.
No, I agree.
And so now, what you're
And
saying
my
is bringing in
motion
my
is-
head of keeping, because we have it here, and then let's go and make the checkbox. Let's put that on the agenda for next time, on where we put this and how, if we do checkboxes.
And while we're at it, I'd say let's put the PID notice back in paragraph 22, don't delete it.
Why do we need to wait? Why can't we, I mean, because all we're doing is we're prolonging this contract, but because what they're saying is if we
Feels like
do
we're
changes,
kicking it.
we're then having to do another meeting and it won't be till April. But if we wait, it's not gonna be till May or
I'm
June.
concerned we don't have enough time today to fully flush this out. That's where I'm landing on
Okay.
doing it down the road, because, these things that Ron brought up, I wasn't even thinking about in here to make sure that we're consistent and thorough, instead of just throwing something out because of lack of time concerns me. Where with what we have now isn't harming anything, it's just getting an additional thing out there.
Is it not? Is there a rule against a special meeting? I know none of us want to make an extra trip, but is there a rule against a special meeting? I mean, I would like to quit delaying things. Like, we know we need to address it, I would like to address it.
And could we put in 11 required notices, C 22, A and B, and it's taking them back to 22A and B where they can check what you're talking about is the required notices. If we're gonna do a 22A and B.
What if we, because I think all this deserves more discussion, what if we take some action now, subject to having time at the end of this meeting to come back and flesh this out more. Because I think we centered on the issue. We generally think it should have checkboxes, and a lot of us think that it should be moved to 22, and but issues have been raised that we can talk about for another hour.
Yeah.
That we may miss some of the really important stuff that we have to talk
That is a
about.
good idea.
But if we have time, I think we absolutely can
Yeah.
and should.
I mean, a lot of these comments to me were very enlightening of maybe some fast decisions that were made where there are some items that went into all the contracts that I kind of wonder why they are in there. And some of the comments made me look, and I thought, we do need to spend more time on really making some good changes that are cleaning things up. And we might not be able to do it all today, but at the end of the meeting, we may decide it. You know, I'm fine with a special meeting to do our job, to make it easier for everybody.
So can I make also a suggestion that kind of tells in with yours, whether we discuss it again at the end or maybe have some action taken between now and our next meeting where we can address this. And I'm not trying to put y'all on the spot, but let me ask, is it reasonable to either ask you as our, guiding lights here, or if we needed to put together, another group of a few of us to do it, maybe having a proposed way to, because I'm still concerned, what you were just saying about the checkbox. I think we need to be consistent about all of these notices, not just the PID one. So I think it makes sense to either, whether we put a checkbox section here in 11 with all of the notices that are related and move the ones that are in 22 up here, either that, or move everything to 22 and have the A and B like we talked about. But I think that focusing on the PID and treating it one way and not having the rest of the notices treated the same way seems inconsistent and confusing to me.
Yes.
So either whether we talk about it at the end, because I agree we need to move on so that we can catch all the other comments, but is it something that we can ask the staff to put together, like pulling all of these statutorily required notices, whether we want to do it in 22 or put it up in this paragraph, and not us have to sit here and do it all, but then you could give us a red line, and then I think that would help us look
It's like a
at,
starting point.
yeah. Is
Yeah.
that reasonable?
That is reasonable.
Great idea.
So something that we would bring back to like the next regular meeting, you don't want like a notice working through?
I'll defer to that, to the group, to whether we want to meet in addition, or if we can just address it at the next meeting, whichever is fine.
So we can put something together, to that extent. I will tell you, we would probably send it to one or two of you just to make sure, hey, this is, hey, Amy, here's what we got, here's how it would, theoretically look like, does this match what you were thinking, just to make sure we have it ready for the next meeting, but yeah, we can do that.
So what do we think? So anyway, that was just another suggestion to help
I
us.
like that idea, and we're advancing the ball. We're not kicking the can down the road, because we're taking action, but we're making sure we take the right action.
Right.
Yeah.
Now, to get your thoughts on what we have now, are you proposing to keep what we have now and then develop that? And with keeping the paragraph 22 PID notice section and putting that back in?
My thought would be, since we've proposed it this way, there's no point, in my opinion, in spending a lot of time adding checkboxes in 11 if we're gonna address it at the next meeting. Keep it like this and then I would add the PID back in 22, just for purposes of meeting.
But are we thinking when we say, we'll look at this at the next meeting and start working on it, are we thinking like, and then a year and a half or 2 years or whenever legislative changes come, like down the road, we're gonna make that change, which actually isn't that far down the road? Or are we thinking sooner than that? Because I'll say, one of the comments we receive a lot, I'm sure the brokers in the room are gonna agree, is why do y'all keep changing the contract forms?
Right.
And so it is such a big deal that like, if it's gonna be sooner rather than later, maybe there's merit to an April launch, to getting it all resolved in the next week. Either way doesn't, obviously I don't have a stake in it, but I will say that's the feedback that we get from the user standpoint. It's
Well,
always such a
and
big
in
deal.
June of next year, we're gonna be at the end of the next session of the legislature.
That's right.
I think we have to get some,
I was thinking we were, maybe it would be April, but that would give us another, I was not thinking it was a kicking, what I'm suggesting, based on the comments that are being made here, that there seems to be some concern about delaying it. I was not trying to delay it, I was trying to get us in a position where we could take action, even if it would mean an April.
Even if it would mean in April. Okay,
Right.
that's just the I didn't want changes to go forward in November with the thought of like, oh yeah, and I know you know this, but like then we can add some more, just thinking of the timing of those changes and how they're received and like the sort of the re-education that has to happen, the legal 1, legal 2, all of that, just to keep that in mind in terms of like the end users. But we can certainly do that, and April 1, I can already tell you that there's gonna be a conversation, let me just put it out there. Well, it's April 1, and we know we've got these changes coming in the June you all know how that goes, so I also see the reason to advocate for,
I think the mindset going in is we're getting these forms out before the legislative changes, whether it's on the
April.
schedule we're looking at now or April.
Okay.
It's my strong desire to get these out, not worrying about the legislative changes.
Okay, that's good
That
to
could be
know.
another round, but these I know have been desired for a long time.
Yeah.
And it's my goal to keep it on that track.
Yeah, I think that makes sense too. I wanna be mindful of our calendar, what the goals are and what responsiveness is the right word, the people receiving the changes. But I think what you just said makes perfect sense, right? Our legislative changes, last time it was just the PID, which wasn't, super significant. So I think that's a good thing to keep in mind in terms of calendar. I think you're right, if it pushes to April, probably not, if you wanna get it the way you want it.
Since we're contemplating a few reviewing this, do we want to have some volunteers be on the subcommittee to take those changes and review them and propose it?
I'll do it.
I think the easier thing to do actually would be to get the draft from them, and just come back to the next meeting, because you have to, let everybody look at it.
I would say too, if this is the only thing, if we get to the end of the day and this is the only issue that's gonna push that contract to rolling out in April instead of January, then can we do like a Zoom meeting or something and address this so that we can get it out there? I don't wanna delay the whole contract to April, but I do want this in it.
Yes.
I wanna get it right.
I think absolutely. And if we're at the end, we can even stretch the end of today, or we can do the Zoom meeting, whatever it might be.
So Zoom, I'm just thinking in terms of, well, let's see where we're at the end of the day and figure out what the plan would look like. In terms of doing that though, yes, we can do that, and if I had to guess, we will send our draft version to Amy and Lee in advance. Mary will just be like, look cool, you can just respond via email, no, you forgot these 7 really major things, we'll add them and have it ready for you.
Well, the only rush that I see that we had before, if my recollection is correct, was the hard money question. Otherwise, we'd be in no rush to make any changes. So if the hard money question is not a rush here, I would say let's just take our time. And if it's April or if it's next year at this time, then we kick out a new draft, that's fine.
I think that's too long. I think we oughta, this is something that is being missed. We have agents that have lost contracts because a PID hasn't been delivered or the mud notice hasn't been delivered. It's an out for the buyer.
I'm not saying that it has to be, I understand that we should take our time drafting it good form.
Well, let's go for, I think we're all agreeing that this needs more thought. So let's go to the next item, right? And see what time we have left at the end to do this. And if we need to meet again, we can do it again. But because of the time we spent on that, we really honed in on a big issue that I think we can address. Yeah, Ron, for the minutes, or allow you to catch up?
Yeah, no, we're fine, because I think these are just items that we're gonna address in subsequent meetings without making any changes to the proposed forms.
The next changes we have, I believe, are to the completion of repairs and treatments.
Yep.
and this is in paragraph 7F. And there were quite a few comments on this language. A lot of them centered around the warranty language. And for what we did here substantively changed we put that seller shall provide the buyer with copies of documentation for the repair, from the repair person showing the scope of work and payment for the work completed. And at the seller's expense, arrange for the transfer of any transferable warranties at closing. And so we had 6 comments say that the responsibility for warranty transfer fees should be negotiable. 2 of them want the buyer to be responsible solely for the transfer fees. So we have 8 total about who should pay for the fees.
Well, and that's, and in many, if I have an electrician out that gives a 60-day warranty, generally he's not charging a fee to transfer that to the buyer. Where you see a transfer fee sometimes is foundation warranties. And if you're concerned about, there was some talk about the contractors knowing the language will stick a big transfer fee in there. Don't use that contractor.
Keep in mind, paragraph F is talking about agreed treatments and repairs that seller has agreed to make.
Right.
And so that's clearly on the seller side.
Yep.
And the seller doesn't have to agree to make any of those changes.
Right.
So it is negotiable by virtue of the fact that you've reached an agreement to dump that agreement into paragraph F in the first place.
Mhm.
So I think it's correct the way we drafted it.
And they can do the due diligence in advance to know what those fees might be if they did the repairs.
Yeah.
That was good clarification, the fact that these were agreed upon repairs that the seller said he was going to do. It's not just a potpourri of transfer warranties, so that would direct it to the seller.
And there were comments in there about wanting it to be broader, to be applied to all warranties, not just for the completion of repairs. And so there was a suggestion of that, which I'm not sure we want to venture down that road for those concerns. That's something that it's not a current obligation in the contract. And now, if you look at the new home contracts, there is an obligation there. But that makes sense because the builder has built the house and has all the initial warranties. Where in the resale environment, they're buried and sellers might not know what's out there. But I think Brian's point's well taken on, these are just for completion of the agreed upon repairs.
Oh, okay, I think you just covered that. Okay, this is just complete the repair that's been requested by the buyer. But the seller's not warranting that work for any future. If the warranty's provided, that's great.
Right.
But it stops at that point. I've done the work that you've asked me to do. I'm not warranting that this will last 10 years or that you'll need service back. So I'm not sure why we're really concerned with what that warranty is or isn't.
Well, the concern that was raised was if it comes with a warranty that's transferable.
Right.
We're now requiring the seller to transfer that, to whatever it takes to transfer that to the buyer at closing, and be paid for the expense of that transfer.
If there's an expense.
If there's any expense.
Yeah, if there's.
And it's only if there's a transferable warranty. And so some comments misunderstood our language here. We have the word any already in there. And one comment said add if any, right? But we already said only if there's transferable warranties, do you have to transfer it, and the seller you're responsible for.
So you'd be in favor of leave the language as it is?
I'm in favor of how it is. I think it's
Yeah.
clear.
I am too.
Let's see, 2 comments were the seller should have the option to complete the repairs themselves.
They can negotiate that they can personally do it in the amendment or in the special, whatever, wherever the repair is discussed.
That was my
like
thought.
2 years ago, we've been through this.
It's a
So
bad
those
idea.
comments were about, I'm a realtor and I'm flipping, I'm doing a lot of my own work. Okay, identify that in the agreement.
Right.
that This is what I do and.
And I think this is really consumer protection oriented to require it this way, because so many people, slap some, the tape on something and then it ends up breaking shortly after the buyer's moved in.
Often
I
the
don't see
repair
it.
that's necessary was done by the seller in the first place.
That's true. So does anybody think we need to add any additional language about sellers being on complete repairs?
Do you want to add to the list that we talk about other types of warranties that are transferable?
Yes.
Okay.
Yeah. And so,
Other discussion?
oh, well, I think let's throw that out, because I don't think there's going to be a lot of,
The only two that are really out there that I see are roofs and foundation work that were done previously. And so if someone discloses the fact that there's a roof that was placed on 3 years ago, the natural question is there a warranty that's transferable, right? And then discuss that. That's what takes place. Same thing with the prior foundation work. But I don't know if anyone's asking about it, if we should come up with an addendum for that or add
I don't
something.
think there's a hue and cry.
there's a few comments on wanting it to apply to other warranties that are out there. But I think, to me, that's more of a negotiated thing up front. You see the roof has been replaced or something, as opposed to my fear, if you make a general statement, or any way we can make a statement, would be so broad that sellers are gonna be caught in this, potential breach of contract by not even knowing there's a transfer
So I will add
warranty.
that to the list to discuss.
No, I don't think so, unless somebody wants to add that for further discussion.
Just as a question on that, if I'm writing up a list of repair requests from the buyer, and it's involving a roof or a foundation, do you think it should be my point to request that roof be replaced and a warranty, a 5-year warranty or some type of, at one point in time, does it get described what kind of warranty I want with that repair?
Well, I think that's part of what you negotiate.
Yeah.
And so if you only negotiate a roof repair, the warranty only transfers if there is one. And so if you're concerned about having a warranty, I think it's the duty of the consumer or agent to negotiate that up front, to be a part of the repair list and specifically the list.
So as a licensee would be my point to go ahead and try to describe what I want the repair, what the buyer wants is the repair and the warranty?
You do what
Yeah.
the buyer tells
Tells
you
you
to
to
do.
Yeah.
Because do you want the 10-year warranty? Are they gonna give you a warranty on a partial repair? Is it 30-year shingle? Is it asphalt? Is it 20 years? Is it architectural? I mean,
If we go to the fidelity and competency, right, goes to there, knowing what questions to ask, right? If a good agent is going to know, well, if you're getting a roof replaced, well, you should consider the warranty. Well, can you draft that provision for me? No, but consider the stuff and what you ask for and what you write.
So the contractor might be the one, the roofing company might be the one that puts that language in, and so the buyer's request is, I'd like this roof with this.
Yeah,
the
to
buyer
require
needs
this.
to find out
Yeah,
what kind of
right,
roof
that's
they
what,
want.
that's
so they
what I'm
can
getting
talk-
at.
Don't be a roofer.
Which the legal update materials are out there, both the old one and the new ones go into that exact issue. And how agents, it's a tough line sometimes, but they can't draft the exact provisions, and the roofing one is particularly concerning because when it's replaced, what type, the warranties,
Yeah,
all
and
these
the
different
foundation,
things.
you talk about 2 big ticket items, and so the warranty kind of becomes a part of the negotiations on the replacement. Right. So.
Exactly. But being I guess the good agent, the better agent, a good agent is to bring those issues to light for the buyer to consider and what they ask
My
of the seller.
roofing company or my foundation company put that into the proposal.
So 3 wanted the requirements to have documentation to be removed because they're concerned about the seller securing that from the buyer or from the contractor. And I think this goes along the line when we made the third-party financing change of requiring some evidence from the lender, that the property didn't meet their approval. Here, it's the seller's burden. Don't agree to it if you're concerned about getting the documentation, in my view. And
When
it's,
you're hiring the contractor, tell them I'm gonna need this.
so to me, that's more of something you need to jump out ahead of as an agent or consumer.
Either way, I think the only time you have problems getting any documentation is when you're doing it yourself, and it already specifically says that they have to be commercially engaged, and so I think we did a good job on this paragraph. I think we should leave it.
I agree.
I agree.
Make sure there's no, what were concerns about?
That's non-substantive.
Got one.
I was gonna ask you about that.
So, and the other 2 comments in here, well, one said they like it, so we do have a like on this one, got that like button.
It wasn't me, but.
We should be like
whoever that
Facebook,
person
not
is.
have a dislike button, we only have like buttons.
I
So
have
one,
to say, I was disappointed that with all of the hard money concerns that would not, I'm not opening that topic back up, but on the comment of liking and not liking, of all the people that have expressed concerns about that, we didn't get, it was just all, we don't like this, we don't understand, and they're like,
It could be that one love comment or.
We didn't get a lot of positive comments about anything this time.
But most people don't do positive.
That's true. If they like it, they don't.
They
say
do.
it.
It's like
Anyway,
online
move on.
reviews.
I
Yes,
just was like, I was looking at all these comments, I'm like, all of these people who've been jumping up and down wanting us to do something.
Are
And all we got was
they don't
gravel.
have our back.
The other two comments that they're out there on this was, that I don't think we need to get into. One's concerned about who determines if the documents are acceptable. You know, we're not judge or jury here, we're grading the obligation. The last one was the buyer should have an option to decline the warranties. There's one comment on that, which I don't understand that part of it. I guess the seller's footing the bill and it only benefits you, and I guess you could always decline.
Not sure what
it, but-
obligation it gives to you.
So I'm not sure I fully understand or appreciate that comment. But that is the last for the repair language. So we'll move on to residential service contracts.
John, at what point are you going to do the section 7E? Are we going down 1 to 4 family paragraph by paragraph? Are we going paragraph?
You know, we
It's
can,
revisions.
I was doing 1 to 4, but we can move over to 7, paragraph 7, because there was a whole lot of comments on
I think
that
that's
one.
gonna be a lot of conversation on
That's a-
7E.
Very good suggestion there.
On a different.
So if we go to the 7,
It's on there.
it's the disclosures that we have.
Oh, yeah.
Now, I'm not gonna say we
Right.
added 2, but all of them were already in there. And every time we get comments on this, it brings to the point of people didn't realize, agents didn't realize that there's disclosures in 4 of our contracts. And so, step back for history, we have 4 contracts, the new home contracts, the unimproved, and the farm and ranch. That in paragraph 7, different subgroups and different number of disclosures have disclosures in there. And they always stated, unless stated otherwise in this contract, seller is not aware of any of these issues. And it listed some big ticket issues, flooding, tanks underground. There were 5 or 6 depending on the contract, and we added a couple more. And some will dive into the comments on this one because there are quite a few. What our concern was, but nobody realized they were there. And every time I personally taught a class, I asked anybody, well, what about the seller's disclosures in the contract? You know, who knows that they're there? Crickets. You know, maybe 1 hand or 2 hands go up. And the reason they're in there is because for these type of transactions, most of the time, or a lot of the time, seller's disclosures are not required. For unimproved property, it's vacant land. It's not required. Farm and ranch, when the value of the residence is less than 5% of the land, seller's disclosures are not required. New homes that haven't been lived in, being sold by the builder, don't require seller's disclosures. So historically, a long, long time ago, these were added to protect the consumer. But what happened is because they're buried, nobody realized it, and this just it was overlooked. And we had a subcommittee probably a couple of years ago now that looked into, well, do we develop a form for this? Do we add checkboxes? What do we do? At the time, we took no action. Now with this last round of changes, we decided, let's call it out, right? Let's not make it another form, but let's make sure the agents realize it's in there. And then that tees up all these comments we got back, which this is the most comments of anything I think we received, maybe besides special provisions. But 11 think it will create logistical issues. In our last meeting and the several meetings before that, we discussed these logistical issues at length. And the concern is the buyer's the one that fills out the offer. The buyer doesn't know what the seller's knowledge is. So how can the buyer check the box no and send it over to the seller? And if they do check no and it has to be checked yes, well, it's gonna have to come back and the buyer's gonna have to initial.
That's how it's gotta be though.
And my point on that is it already was like that. If the buyer sends it over, it already said the seller doesn't know these things.
Right.
And so it just proves our point, I think, as a whole committee, maybe not everybody individually, but as a whole committee, that we want that to happen. We want the seller to have to know, this isn't right, I have to send it back to you. Because all too often that wasn't happening. So yes, is it a logistical issue? And yes, but it's making the contracts right, making the representations right in that case. So-
And their comment about electronic, you just tag on that. I mean, it's not a big deal.
No.
Well, I think the timing aspect of it, that the complaints were, or the comments were, is that what if the seller wanted to accept the offer, but yet it's not complete? Because I don't think the buyer's agent is gonna feel it's their place to represent what the seller answer to that question is. So that section is going to be left blank for the seller to complete. So now we have a counter offer, a loss of time and possibly loss of the offer. I think that's where they were feeling it's an inappropriate place to put it because it's affecting the negotiations.
And to that point, some said just say no, and if it's not no, attach an addendum, that has the actual answers, was one of the suggestions to that point.
I would say this is exactly the same way we have the insulation question formatted in the new home construction contract.
Well, and let
We
me
all-
addendum.
We already fill out an offer on a new home contract that says, what that insulation R factor is that we have to fill in. So we're already doing this on the new homes. This is the very same process that will happen if we adopted this. So
And you can contact
I
the
have a-
listing
I have
agent.
a potential solution to that, to address all of these. We can add a little sentence in there that says, if a box is not checked, then the answer is presumed that there's no information about the disclosure of that item exists. So if the seller wants to then go ahead and just accept, then he's accepting on the basis that he has not disclosed that. He's not aware of anything. It's an interesting thought. Now, we use that in other types of forms that says if you don't check either box, then this one applies.
Proactively addressing
So then,
likely is going to be an issue in that.
so that knocks out the objection to there. I don't know if we want to go to that or not.
Yeah, I've done that before, where you just say, if no box is checked,
This one applies.
then it means that seller is not aware of that matter.
Can I say, if it's not scrupulous, but if you send me over a contract without a box checked and I check it, who's to say that box was not checked when you signed it? If it's not a change in initial, I'd rather see the wrong box checked marked out and the run corrected initial.
The one logistical
just
thing
saying,
there is
I
the
like that.
seller's the one that signs and sends it back, so
I know.
they can correct it.
Yeah.
When they
Yeah.
send it back.
That's what I'm thinking, they can, everybody said on electronic signatures, how can we do this?
Yeah,
They can tag it,
oh, yeah,
it comes back to the person, we either execute it or we don't. If we don't like those
yeah.
check boxes,
That's an
we move
opportunity.
on.
That's an opportunity for the buyer to
Their
see the
issue in
change.
comments was the time factor of going back and forth because there is information that the buyer writes the offer and they don't know the answer. I mean, Ron came up with a solution to eliminate that time factor,
Well,
but
it's still gonna be a factor though, because if it's incorrect, you
Yeah.
still gotta check the box that says, yes, this is a problem.
so does it
and
really
send
need
it
to
back.
be in the contract?
But
that would've been done
Yeah.
anyways.
Let's go back to what Lee said, on the new home contract,
It's there.
what does the buyer do? They call the darn seller
Right.
before they submit the offer and ask them.
Right,
The more I'm thinking about it, the more brilliant I like that idea, because it solves, this was a lot of comments on this issue. And so it more than any other one almost, so that eliminates the logistical thing if there are no changes. And it really is in line with our current, what's there right now, because nobody fills that in, and if they do, they have to send it back with it noted elsewhere. Personally, I've never seen a contract come across my desk that had anything noted elsewhere when it should have.
I also like the fact that they have to communicate with each other. What a concept. Two agents have to talk to each other.
But it brings it to light.
I mean-
This is a big change and people are now thinking about this, which is.
well, which
I
is
think,
what
our
we
main goal.
wanted. But I think you ought to check a box.
Well,
I
And
don't
if
like-
we don't make any
and
kind of
if you
change
leave
like
it
that.
blank, then it's not a part of the contract. Seller made no representation one way or another, and the buyer's agent should look in the mirror. It's their own fault.
Well,
This is for the protection of the buyer, and if I'm the buyer's agent, I'm gonna check not aware on everything and submit it to the seller.
Are you in favor of Ron's suggested language?
I'm like Charlie said, it creates a problem that when you get a contract back with something checked, then was that checked the first time around or the second time around? I get it.
I don't, because it invites buyers agents and buyers not to check a box.
Yeah.
Because it's, really you should just go with one box, check the box if it doesn't, and not have two boxes if you want to do that.
Well, the reason why I think people feel uncomfortable as, I'm sorry.
No, you start out.
As buyer's agents to fill out something for the seller when they haven't talked to the seller or the seller's agent. I think that's the uncomfortable situation of checking boxes. I probably would do the same as you're mentioning and force the seller to make the change by making the offer. But I think there's a lot of people who feel uncomfortable doing that. And by adding the language that if you don't check a box, you also take care of errors, that neither box is checked by either party.
That is an affirmative representation, as opposed to not checking any box, and it's not important to me
Exactly.
whether you have a representation or
We
not.
make the representation now in our contract form, so we're not changing anything from our current practice.
What if you just had one box that said, check the box if any of these apply, or I don't know how to say it. If you have a floodplain, if you have a tank, if you, and just have that, and you present it, and there's no boxes checked, and the counter proposal is to check the box.
Well, that's what we're suggesting here.
Without the phrase, I'm saying, because you don't, do you need the, if you have that phrase, you're never nobody's ever gonna check no.
By definition, if the seller ever checks a box, it is now a counteroffer.
Right.
Right. It was
Yeah, sorry, yes.
Like 2 months
ago.
So I feel strongly that what we've written is good the way it is, because again, it almost mirrors what we have in the new home contract regarding insulation. And we haven't had a bunch of write-ins about that. I mean, it's the same thing.
Yeah.
And I mean, I get that it's new, it requires whatever, but we've already been doing it on new homes. Why not just keep doing the same thing?
Brokers.
It's working. I am a broker.
No, other.
For credentials.
I concur with Lee.
Thank you.
I tell you. Don't do for SJ.
I'm not really comfortable with the wording in there for the reasons that the people who commented said. Buyer's agents should not be put in a position to represent something they don't have knowledge of. Pick up the phone and call the seller's agent.
Sure.
Maybe they can get them, maybe they can't. So they will leave those blank. The same way they do on the lead-based paint addendum, they can't make a representation. So what agents do, many of them fill it, listing agents, and upload it into the MLS. Not all agents have access to the MLS, so I like Ron's statement better to keep the transaction moving forward and not put the buyer's agent in the position to make those kind of representations that hold up the transaction. I mean, I even question why it needs to be in there. I would rather see, and I don't even know how, in the next legislative session, to make suggestions to add these kind of questions to the property code under seller's disclosure. So we're not even talking about what doesn't apply. Property code just says seller's disclosure goes to 1 to 4 family. There are other things that should be disclosed.
Well, and some of these are in the seller's disclosure, but
Right.
the issue is it's exempted from having to provide it.
Right.
So-
Exactly. And where we've placed it are those areas, as you said earlier, that are an exemption. But I would rather go with Ron's statement, just because I really question.
You're not representing.
So
Sorry.
if
Wanna
we
get back
add
on our good
Ron,
side,
if
so.
we add, thank you, if we add Ron, it's not you. If we add Ron's statement to this, why would we not go back and try to add some kind of statement in the new home contract about, I mean, it doesn't make sense that the philosophy is different on the different contracts. And the process is, I mean,
I think Ron's statement is brilliant, but I'm in my head now to let's throw this out there because it has been the standard practice in other ways and see if it becomes an issue. If it becomes an issue, then we can address it, but it is part of the current practice. And I do really like it, but I do think either way, we're gonna get comments back. And I think we can put that in the bucket to add in the future if we see those issues. There may not be any issues, but it's definitely going to be an educational thing, which is what we want to highlight more than anything.
It was the most responded to with a negative of any of the topics
That's true.
I think it's because they didn't know those representations were in the contract in the first place.
No, I don't think it
That's all
has
we
to do
have.
with the representations or knowing it's there. It's the logistics of the negotiation process that is gonna slow it down. And is this the right place to put this disclosure for that reason? I think that's why they.
Well, theoretically, it should have slowed down the negotiation in the current contract. It's just people didn't know that those representations were being made by the seller in the affirmative, in the negative, whatever, you know, that they didn't have knowledge. And so we just made it more apparent. And
Those
so,
were, it was in the contract.
yeah,
Yes,
yeah.
we added
Always been
two.
there.
The boxes are the new thing. And it's not making a representation of the seller when you check the no box. What it's doing is saying, if this isn't accurate, I need to change it. And there's no real way to avoid, unless you call them ahead of time and talk to the other agent, which I'm gonna try to if I'm doing that. But, you know, I do that all the time on lead-based paint when they're not in the MLS, where I check the seller has no knowledge and the seller has no reports.
I don't
And
think
if that's-
buyer's agent should speak for. the
Oh,
seller.
absolutely you should, because that's my buyer's assumption when the contract goes forward. If it's different, the seller has the obligation to change it before they sign it.
Well, to throw in the discussion here, there's 5 comments that said it should be on a separate form. And I think some of those said the separate form can be uploaded to MLS to give advance notice of what the seller's knowledge is. But, you know, that having a separate form, which we discussed before, creates a whole nother
Well, it
Separate
doesn't work for the
forms,
consumer.
forms.
Because we have
It doesn't
different
work for the consumer that is listed in it.
One thing I would like to do, just as a side note, once this project is over, we'll provide this form. I would like to put a good group together to look at our new home forms, because I think they're not reflective of really what needs to take place, especially the incomplete construction. The completed construction, if you have substantial completion, you're probably okay. But the incomplete construction form, I think, is a difficult form. It's probably not widely used, if at all. So if we're gonna have one, I think we need to decide if we continue with the incomplete form at all. Is it necessary to have one? Or do we go ahead and really work on it? Because I think it's lacking in a lot of reasons.
I think that fits in here since we're discussing the change of the contract. Do you want to inform the subcommittee today and get volunteers?
No, I'm not ready to get to work. So, but I'm just saying that for further discussion. And there, I don't know if there's a hue and cry because it may not be widely used.
Well, I was gonna say, one consideration is, the builders I've dealt with want their own forms.
I'm
Yeah,
just,
now the only time I ever see this form using is occasionally a build on your own lot, type of thing here. But you're still having to get the builder to buy the lot to use this form.
I'm seeing it used a lot out of our Huntsville office and in the Trinity County, San Jacinto County areas. We see it more often, actually that being used in the building contracts.
I
They have
see it
a they have a lot of new
On the
builders,
incomplete forms?
yes, on both.
Yeah.
And because you don't,
That's correct.
I say less sophisticated builders that don't have the experience, like those jumping in and they don't have lawyers, so they're.
People
using their
can
own
just
form.
trust each other. right?
Exactly, but I do see it used quite a bit, especially in rural areas, that's what you said.
And I've seen it in Houston in the upper end, the multi-million-dollar homes that they do, you know,
That's
half
good.
dozen homes a year. And they don't use the Greater Houston Builders Association contract or have their own. They use the Trek contract.
Well, I do think the incomplete form needs a lot of work, so we'll just mention that later,
Okay.
for later discussion.
To push this discussion along, and we circle back to what we want to do, or at least one person wanted oak wilt defined and was concerned that the sellers won't know what's oak wilt and what is not oak wilt. If they have a diseased tree, is it because of oak wilt or something else?
They can go to the Texas Department of Agriculture and figure that out.
I've not heard of that lawsuit.
I did like the one comment where they said their neighbor tells them they have oak wilt. Is that now disclosable? It's a, you know,
That goes with any issue, right?
Yeah.
So if your neighbor says anything, do you
Yeah.
stick your head in the sand or you
yeah,
have some
it's kind of,
obligation?
yeah.
And we did have one comment that said they like it as well, so
Yeah.
we do have somebody that likes this change. So I'm in favor of keeping it as we have it with what I consider Ron's brilliant idea with this language. If we do see issues, that's a good fix for it. But this is going to be an education issue. The fact that we got all these comments back I like, because it shows people are now noticing it. And the logistical issues I see are largely the same logistical issues as we had before with the added one and maybe blanks coming across, but that I don't think should override what we've already drafted right now, but I'll entertain other thoughts before we move on.
Just a disclosure that brilliance comes sometimes from stealing other people's ideas.
But you recognize it's a good idea.
That one wasn't me.
So that, there's brilliance in it.
Brian?
If a
Can I
seller,
move for a 5-minute break?
Yes. Is any other last comments on that? Because we'll shut the door on that and move on after
Well,
the
do
break.
we have a straw poll on if we want to add that brilliant language or not?
Sure, sure.
Yeah, I
No.
think it was
I
defer, I think
defer-
it was defer until we see if there's issues. That's the way you just
That's
said
what
it.
I, yeah. So who's in favor of deferring until we see if there are issues by adding Ron's language?
Defer the brilliance.
Okay.
Do not divert the 5-minute
Yeah,
break.
the first one, the first one, you voted.
I'm very.
Marching through.
Oh, no. I,
if a
I just want to
seller,
be sure I apologize.
no, you're good.
on that idea, if a seller does have that
It
disclosure,
helps that we were agreeing.
if you've asked for, if you do or do not have a disclosure of that.
Oh, yeah.
Flooding. Okay, so how does the seller respond to that? Just answers yes, but does he also need to provide the disclosure? I mean, what information he owes?
He just says, if you're aware of any of those items, then attach information.
Which we can discuss more. in break.
Mary,
It's
fascinating. let's get Mary, she's right outside.
Okay.
I think she's on the phone.
Okay, so are we to paragraph 8 now,
We are
or are we on 7H?
on, well, we just wrapped up 7H.
Okay, great.
Wait, no,
7E.
that's,
7E or H, depending on which one we're looking at.
on the 1 to 4 is 7H.
Yeah.
Thank you.
On the 1 to 4 resale, I think we're on 7H.
Yes. Yes, the residential service companies, you are correct. So 7H are the 1 to 4 again. So there was a couple comments here wanting this completely removed. The comments were based upon, having the language in here is a endorsement, that's right, endorsement of residential service companies, or more commonly known as home warranty companies. The reason we made a change here was to follow the statute that now has it no longer regulated by TREC, but it's now regulated by Texas Department of Licensing and Regulation. I don't know if any are even considering or being in favor of removing this language altogether.
The license act says that we have to tell them.
No, does it?
I think so.
So,
I think so. I mean, somebody verify that.
I don't
But
think.
I think there's something in the license act about we have to tell or
So the seller has to notify the buyer.
Or the
Yeah.
agent.
or that an agent has to tell them they exist. We don't have to sell them or promote them, but we have to tell them they exist.
Which one is this?
This is the language that you may be talking about, the bold language.
Residential.
maybe.
Right, I'm on 1 to 4,
But it's H.
Yes, 7H.
That was in the residential service company.
and even though there's a lot of gripes about home warranty companies, they do serve a purpose. And I would not be a very limited one, as I see some eye rolls here, but no, they can be good, they can be bad. And I don't know if it's for us to judge, but it is a big part of the home purchasing process. So required or not, it has bolded language in here that it's optional, and that similar coverages may be purchased from various companies authorized to do business in Texas. And it's a regulated industry here. So I'm personally not in favor of entertaining the removal of this section, especially if it's required to be in there.
I tend to be kind of anti-home warranties in my own bias, but again, I don't think that's a promotion of it. If it was taken out, it wouldn't bother me, unless, of course, she's right about that. But yeah, I don't.
Does anybody?
Well, if we take it out, we have to renumber all these things.
No, we don't.
Yeah, that's it.
No,
H at the end.
That's a great point.
Yeah. Okay, it's out.
Anybody want to discuss anything about that before we move on?
No.
Okay. So the next change we have escrow agent in 9B, which is just capitalizing it. Okay, so this created some issues. We're at now 9B, 3 and 5. Let's throw these in together. In sub 3, we merely added to an obligation at closing for the seller to transfer any warranties. And this is going to the warranties that we added for the negotiation of the completion of repairs and treatments. I think there's a whole lot of confusion. We have a whole lot of comments on number 5. We have at least 6 comments that don't understand the difference between private transfer fees and HOA transfer fees. And then one wants a checkbox on who pays on the private transfer fee. So if we step back for a minute, the private transfer fees were always at least noted in the contract in terms of being the possibility of being one, right? So it's a statutory, I believe a statutory notice. But private transfer fees are a wholly different animal than the HOA transfer fees.
They always mess that up.
And it is confusing. And unless you go read, chapter 5, chapter G, it says private transfer fees are any fees associated with the transfer. And I'm grossly paraphrasing, but then it exempts certain transfer fees, including the HOA transfer fees that we're used to. So it is a confusing statute if you go read it, it's long. But a lot of people were now thinking that, okay, with this in here, HOA transfer fees are now the obligation of the seller unless we write it in somewhere else. As opposed to under the HOA addendum, which says that the buyer's responsible to a certain amount, the seller, everything over that amount. So there is confusion here, and I can see the confusion. But I'm not sure there's anything else what we can do to solve it. I don't have a solution necessarily, but.
Maybe we say, in the parentheses, we say not HOA fees, but as defined, or something like that.
Could there be, and I'll throw this out there, I don't know the minutiae of the statute. I reread it again. I'm not sure if there is a private transfer fee that an HOA fee could qualify to actually be one. And anything
I don't think
associated
so.
with it.
This was all before 2011. So these are hopefully gonna go away, because if the developments were developed prior to 2011, the developer or whoever could create his private transfer.
Because the statute says they're void if they're created after 2011.
Right, but the challenge is they could be developed, not built, developed. So I mean, it can be on paper, because there's some investment going on right now that were developed before 2011. I mean,
But do
the paperwork was done, but nothing came out of the
but
ground.
they continue to have to be paid every time it's sold in.
Every
That's
three-
your-
For
yes.
99 years.
99 years, but they have to recertify every 3 years. The developer now has to recertify every 3 years to say, I'm still alive or whatever, I don't know.
This is, I'm not gonna get into too much detail, but this is a hot topic. There is one company out there that is aggressively asserting that they have them, and from some estimates, there may be as many as 100,000 residential properties in Texas that they are alleging that they have this private transfer fee obligation in place.
Is it in the deed?
Is it in the deed?
Is it in the deed when they add, I'm just asking, on the older properties, is it in the,
chain of title.
it's in the change?
It's in the chain of title. And interesting, if you read this subchapter G, there is an affirmative requirement of a seller to give a prospective buyer a notice that there is a private transfer fee.
Well, and I think we have that in our
We have
notice
it in
section.
there, but that might be another thing we put in the check
It's very
box.
confusing. Everybody always messes it up with HOA, and it's like, no, this has
No, that-
nothing to do with
Right.
HOA.
The key distinction
It's
is
private.
it a fee that is associated with the property? Okay, so an HOA, that fee is going to go back into the community. Or you can have a 501c3 for the local PTA. That goes for the benefit of the owners in the development. The private transfer fees that the statute address are those that don't go back to the property owners.
Right.
And I'm saying this in a very rough manner. They don't go back to the property owners, but they go to this third party
Right.
who's making money off of it. It's like a real property toll road. Every time you go and sell the property, somebody's making the toll and it's going to.
And Lakeway's doing a lot of it.
Well, and let me throw this out there. I'm concerned our change is going to create, relative havoc for a while, especially without adding something, or do we look at just removing it? Right now, in our 6E, where is it, 6E7, if the property is in a public improvement district, seller must give buyer written notice as required by the property code.
Right, but 6.
Oh, no, sorry, I was reading the wrong
It's
one.
8 is the
Eight,
property.
If the property is subject to a private transfer fee obligation, the property code requires seller to provide buyer notice as follows. The private transfer fee obligation may be governed by Chapter 5, Subchapter G, to the text of property.
And I don't know that is sufficient.
And what we've added here, though, is merely that the seller is going to be responsible for it. That's the only thing added in 9B5.
That the seller has to disclose that it's there. The question is, a lot of sellers, and this is what I've had in training, where do I find that out? Because because sellers don't know.
Exactly.
Sellers don't know. So,
Especially if they're seller paid.
right, so that's the question, it might be better that where they can find it,
Exactly what
where they can find it, because that's the question.
Well, it recites by G, subchapter G.
No, she's talking about if your property has a
Well, this says
transfer,
if
private
it's
transfer fee.
subject
There's a lot of sellers that have no clue.
Then seller notifies buyers as follows.
That's no disclosure.
Right, so then we have to go open title before we go into
Argue,
a closing,
argue,
and now we have title
argue.
companies that don't like to
You know,
open
either side, I can see
until
arguing
we
either side.
confirm that they're for sure gonna get the closing.
Well, if you, hopefully what will happen is that when you bought it, you paid the private transfer.
But I'm not gonna know that as a buyer, I'm not
Because the
gonna.
seller paid it.
The
So
seller
the
paid it.
buyer wouldn't know. And
And
then when
they
it's their
disclosed
turn to be the seller, they have no
Aren't
idea.
they usually
They
have
don't know.
restrictions though? They don't know if they have a
No,
fixed
they don't.
rate.
They
Right.
definitely don't know if
It
they.
is a-
So what about the, circling into the comments we received, that, and are not going to the detail of the comments, but they were saying, this is crazy. How is the seller gonna be responsible for all these transfer fees? And they're thinking it's the HOA. They're not saying I'm confused. They are thinking this is the HOA transfer fee that we're now shifting the burden.
Not to,
So,
I
yeah,
think
is
if we
there a
tell
way
them
to-
where they can find that private, maybe
would it,
5 would be, where can I
But
find?
that's not their challenge.
Can I-
He's right. It's not an HOA.
Yes.
That's
Do
right.
that on
That's-
purpose.
All right, I'll turn.
I wonder, is there any reason that this phrase could not be put in, I know, 6, whatever, 8? Right after we've talked about the transfer fees, and maybe they would understand that that's, instead of standing alone, if it stood right where they're talking about private transfer fees, would they be less likely to be confused with HOAs?
They don't read 8 as
Oh, I
separate
got,
from HOA.
I got you.
8 is HOA.
Yeah.
I think the reason
Oh, okay.
where it is good and it's clear is it's falling under closing costs.
Yeah,
And there is a confusion with the HOA addendum and transfer fees noted there. It's not the same as this one. This one clarifies that it is a seller's cost, it's a private transfer fee. It tells you where to find it in the property code. And I think that clarity was very well thought through.
It just doesn't tell the seller where, if they can even say if they have it. That's the only, the
Seller
seller
listening,
doesn't know if
That's
they have
not
it.
the public comment.
You're right.
And so how do we address, and does somebody have some language, I think we have to address this, because when it goes out there will be, I can foresee being a major issue. Does somebody have parenthetical language or additional sentence?
Well, you could add to the definition, it says as defined by subchapter B of chapter 5 of the property code, that excludes HOA or POA fees if you want to. Because it does, it excludes the
But
the code excludes it.
the exclusion
I know.
is this long
But-
as to what HOA fees
Now, or the-
are or not.
The other solution is add another sentence that says, property owner association fees are addressed in the addendum.
That's good.
mhm,
That's good.
It's pretty straightforward.
mhm.
That's what the agents are looking for, clarity, and one is the separation. I mean, there are a lot of other issues, capitalization fees, foundation fees, is one of the people submitted an example that always comes up, but at least we're dealing with the transfer fees. Because it's used in the HOA addendum, it makes them think, Well, what about the private transfer fees for those communities who have them, and in Houston, we have several. So I think it's good as it is.
So
you're.
I like the fact that you wanna just,
No, I'm in
you wanna
favor of
put
leaving
that
it as it is, where it is,
and say,
And
this
add.
doesn't include,
and
Right,
add what Ron just
I'm on
said.
board with that.
I think we're all,
Yes.
sounds like we're all in favor of
Because
that.
that points them to exactly where they need to go to
Yes.
see what the agreement is on those.
In the question there, do we use the language, we said property owners association, do we, yeah, that's what it is,
That's what
property
the-
owners association, it matches the addendum. So
Right.
then
I
it-
think you would want to do that.
So, we could say transfer fees assessed by a property owners association, are governed by, we'll say that. The HOA addendum.
And there's one comment that came that touches on this, is that the HOA addendum is not required.
Right.
And so you may not always have that, even if there is a mandatory HOA.
I don't think
I don't
most
think anybody
people
ever
look
does,
at it
but-
that way, but if they read what it says, it's not a requirement,
What
but I
happens
think
when
they're
that
trained to
occurs?
believe it is.
That's what I'm thinking
And
of,
they
just
use it.
because there is a
What
comment
happens-
on
What
that.
happens now, you have to, if the title company says, oh, we've got transfer fee, and it doesn't know where to plot it, right? And HOA, so what happens, the title company calls the parties and says you gotta agree?
Or we're calling
I would
it
think
having
it'd
one
go
that
to the
didn't have
seller
it attached,
if
but
they didn't have the addendum. I would think the seller would just have to pay it. On the HOA addendum?
No, let's say the HOA addendum's not attached.
That's what I'm saying, if it's not attached, I would just say it would be the seller would be responsible for it. Because as a listing agent, I didn't get that addendum signed. I mean, you know what I'm saying?
Oh, so you're saying listen.
So you're saying you pay for it.
Maybe.
So the seller's obligation include, or said there will be no liens, assessments, or security instruments. That's an argument there, no assessments against the property.
I'm sorry, I couldn't hear you, where are you?
Well,
Oh, so I'm just reading on B4. I'm trying to figure out the answer to if the HOA addendum is not attached, not even considering a private transfer fee, who pays all the HOA fees? How do you determine who pays it if the agents do not use the addendum?
I think that
Well,
would be
it's
fair.
sort of a burden of the sellers because it can't transfer
That's what I
title.
said.
I would,
That's what I would say. It's a seller's job if it's not covered.
Maybe it's negotiable if it's not in writing.
well, if they're
Is that a place
attempting to
to
transfer title and these fees are obstructing transfer of title, it seems like it's the seller's obligation in the absence of a.
It's a security interest because it's secured by
Right.
the lot and the seller's promising to sell the property, not
It's there.
subject to any security
Yeah,
interest.
and it's their obligation as members of the homeowners association to satisfy those.
Well, I think that's
Weird.
5%, right? We've had this issue forever but getting back to the clarity of the comments, so we talked that one through, I think.
I mean, it covers under title notices, basically says a buyer is concerned about these matters, which is the HOA fees, use the addendum.
Yeah,
So we want to just add a statement,
No.
transfer fees assessed by property owner associations are governed by a property owner association are governed by the addendum for property subject to land ownership of the property owner association.
That works. That works.
yeah, let's do it.
So,
I mean,
We're gonna have to
it's not attached,
be
it's not
a
attached.
bit different on the condo contract. You have to reference.
Yeah, it'll be different in the condos. Yeah.
Are there private property taxes on condos?
The transfer
Transfer
fee?
fees, are there
You could.
Yeah, I didn't know. I mean, because it's a building, not, I mean, it's a unit, not a building. I didn't
It's
know
title.
if they could have
If
private
it's in a development, it's
transfer.
subject to it.
Private transfer fees or HOA?
No,
Just
private
private.
transfer.
Could have gotten there too.
Not now, they
On a
don't.
condo.
No,
The
not
condo
since
association-
2011.
The condo association I'm in now, they tax
Why didn't they just?
the overall facility, do the HOA dues, everybody pays their pro share,
Right.
instead of the individual
But
units.
there aren't really private fees.
Are we on the?
So you do.
I'm here to be over it.
Well, I mean, I don't have anything
That makes sense.
relative, but
I got you.
that would be helpful. Bad opinion, but it would be helpful.
It's gonna be changed in some fashion,
this session.
I think.
Oh, yeah.
You gonna fix this?
Pass the
Is
Constitution.
that what he's saying?
Yes, he's promising so.
Single-handedly.
Well,
It's the
Minutes,
US
okay.
Constitution.
oh, okay, that makes sense.
So we'll move on for that. I think that's a good change, addresses the comments there. And now we're moving on to special provisions, I believe is our next one, which had the most comments on here. 16 comments. Or let's step back on what we did to talk about that first. So what we did, we had a special meeting of the committee to consider changes to special provisions that were proposed by a working group, unauthorized practice of law working group. And we've always had a concern about agents practicing law. And I always say, agents probably know more about residential real estate law than most attorneys because not many people practice this. But in what they do borders on the line of practicing law so much. In fact, they do practice law by filling out these contracts. They're just allowed to do that part of it, but they can't go past that or adding business details to the contract. What's a business detail versus something legal? In the last Trek legal update materials for the public, listen to this, has a lot of examples of that pretty much everyone's a practice law or a very problematic business detail. And so what these changes are intended to address is to highlight that even more and to get across to the agents what they can and can't do. And so the paragraph description was changed. And it's now states this paragraph is intended to be used only for additional informational items. And we have a lot of comments about what informational items are. And our definition that we put in there is an informational item is a statement that completes a blank in a contract form, discloses factual information, or provides instructions. We have comments on each one of those. Why is this limited? What does it mean? We'll go over those.
It's limited because you can't get it right.
The last thing is real estate brokers and sales agents are prohibited from practicing law and shall not add to, delete, or modify any provision of this contract unless drafted by a party to this contract or a party's attorney. That last statement is what we have most of our comments on. We had 16 agents write in that thinks that last statement prevents situations in which they are the principals, they are the parties to the contract. They think it prevents them in that situation from drafting provisions or modifying provisions.
Unless drafted by a party to this contract.
I did not understand how they realized.
I didn't get that at all.
I completely lost.
I would never guess we would receive one of those comments, much less 16 of them.
It's a good example of why they should not be drafting contracts.
Well, that's right, but we spent an inordinate amount of time on this language. I thought it was well written. Obviously, it got a lot of comments anytime you change special provisions, but it specifically addresses the very thing that.
I think this is at the heart of an education issue.
Yeah,
Because a
absolutely.
language, I don't know if we can be any more clear than what we put in there. And so I think it goes straight to education. From my point.
Because they're all comments, whereas if I'm the principal, I can't write, I can't
They
draw,
just need-
I can't delete something, I
It's like they
can't do
didn't
this.
even read
I'm
it.
like,
They just like needed a ruler and a pen and just read through it and go, oh, right there, I can do it.
There's one other alternative comment, we'll spin off that, well, title company and fee attorneys can't draft provisions for the parties anymore either. Because they're the party's attorney, and here they're thinking they're independent, nobody's attorney in the transaction. But clearly, if you're drafting something on behalf of somebody, you have a client.
Unfortunately, that's always been the rule.
Yeah.
This is making it clear. I think more than anything, the comments are they don't like what we said.
I would agree with that, and not to be sarcastic about that, I almost think that our language is even more so correct that they need it.
Yes.
A lot of time, yeah, they proved our point.
Yeah, they did. That's good.
Yeah.
That's how they say it. They proved our
irony
point.
of the situation.
Now, several question the definition of informational item, right? In question, what does it mean by complete and blank in a contract? And there, the intent, I believe, was if you run out of space, you can complete it there in special provisions.
It's long been taught that in legal one, when you go over contracts.
And I personally like the language. I think it's pretty clear, and there's maybe some outline comments.
I do have a
And I-
question. Will somebody say, oh, well, there's a blank in paragraph 11?
You can complete it.
I'm gonna write that one for the next class. And discloses factual information, nobody really complained about that one, or provides instructions. There was a couple comments, I believe, on, well, this is a limited list. So you're saying informational items are these three things. Well, what about other things that we can write in there, other business details and stuff that now you're limiting it to these 3 items? I don't believe that's an intent. I think this is an instruction to the parties and guidance to the parties on that. So I didn't get a lot from this comment.
The only, and this is me teaching this, but the only thing when it says, you know, that complete a blank in the contract if you run out of room, if you look at our paragraphs up here, it's saying add it to an addendum, add it to an exhibit, don't put it in special provisions. And that is a challenge, because I talked to a commissioner and she said, well, if that's the only thing you're doing, I'm not gonna nail it, but read the contract, Mary, it says exhibit or addendum. So if we have too many tax IDs, put it in addendum, or if we have a legal description too long. And so that's the only question I have about this, complete a blank, because in the contract it says,
So do you want to delete just that piece?
that's what I would take out, yes.
What piece? Say it one more time.
No, you can't take it out because it reflects the definition in the new rule. It's gonna be proposed.
Well, then how do we, I'm just saying, because then we have,
You just educate on what that means.
all right,
You know, the most
because I got
important,
nailed on that one.
the most important thing to educate them about is that this is a tool for the real estate agents when the client wants them to go off the reservation and draft something. Oh, I'm sorry, read paragraph 11, it says real estate brokers and sales agents are prohibited from practice. I can't do that.
Exactly.
This is that last sentence is a tool.
I guess
For
if
the
you say
real estate
complete
agents.
something, okay, I was just, that's my question, is
Yeah,
complete
so
something,
let's
because,
say you have a long name or a long list of names in paragraph 1. I think the commission would be hard pressed, I'll speak for you guys, to take disciplinary action because you put it in special provisions as opposed to a exhibit.
oh, I know, but they just clarified that one, right? They said, it says
It's completing the blank.
They just
Okay, so
said,
I'm good with the 11. I think we should keep it and move on.
And,
and I think it is educational.
and there's 2 people that said just remove it altogether if you're changing it up. So I don't think we're going to do that.
We might get some comments on removing
Just a
it.
Well, I think we're pretty unanimous on the language, keeping it as is, noting the concern with the filling in the blanks. So we'll move forward on that.
Here's a question, we talked last time about having the amendment that also has language that says other modifications.
Yeah,
So
we
if I
put
had
put
something
language
to-
in there,
Put in
We
there in special provisions,
in
would that
amendments.
also be a place where I could add to something?
Well, that's an amendment
That's not
form,
okay.
so you would already have an executed contract if you're using that form. So I think logistically, that'd be hard to use up front.
Okay.
You're not amending, it's part of the original.
That's why they said exhibit or
Yeah, okay. Gotcha.
just add something. And that's what commercial is. They add 9 pages of exhibits.
All right, the next one, and Brian, I know you made a comment on this one, and so I'll let you take the proration section, our changes
Yeah,
in
and what,
in
do
your,
you know what page that was?
here, I'll search the,
Where your comments.
Search
It's
for
on
Brian
page
Watts.
59.
Or 173 on the contract.
yeah, 59 is Brian's comment.
Yes.
I just noticed the way we had drafted this, prorations, we said the only thing that we would prorate are prepaid regular periodic assessments. And that's not what we intended. We intended that we would prorate regular periodic assessments, including prepaid items. And so this is no real change to what we intended, but it makes clear that the change we made was the proration of regular assessments included prepaid items. It wasn't exclusively prepaid items.
So I guess the comments that were made is somebody explained what prepaid, regular, periodic meant. So are you saying that it's not written correctly here, that this wasn't the way it was intended to read?
Well, let me give you an example, well, 2 examples. One, a prepaid assessment is when the HOA says at closing, the buyer, or you need to pay 3 months assessments in advance. Those are items payable after closing, referable to a period after closing. And so therefore, that would fall under the buyer's side under paragraph 13. But there's also the situation of what if I pay, the seller has paid the assessments for the current month and you close on the 15th of the month? Well, in that instance, half of it's the seller's obligation, half of it's the buyer's obligation, okay?
Yeah, that's.
So that's the regular proration. But also the prepaid assessments, we say that falls under the paragraph 13 proration paragraphs so that we can properly allocate that to the buyer, and it doesn't fall under the HOA addendum when we're splitting the fees being charged by the HOA.
So how should it read then? Are you saying it's?
It should be,
Yeah,
look at how I wrote it on
The
page
parenthetical.
59, yes.
He has a suggested, change there on page 59 of the material.
That's the parenthetical is the only difference, isn't it?
We're deleting, well, moving
We
prepaid
moved
down.
prepaid into
Oh,
the
okay.
parenthetical.
And we did have, I believe, a comment or two on that issue as well that followed, what you're suggesting. I like the change. I think it's thought out and makes it more accurate. Does anybody else have any comments?
Yeah, I think it's
Target
clear.
scratch.
Yeah.
So could you restate how it's going to read now, please?
Up here.
Is it the way I'm-
Look at page 59.
I'll
Look
just
the
mention
blue
this.
paragraph.
Okay,
Let's
so it's
mention
gonna
this in
read the
case
same
it's
way
relevant.
59.
The HOA
On-
addendum is where
yeah,
you
on
got
the
that
blue.
language from originally. That was the, taken from a sentence that was added.
That's good.
Does that mean we need to change it? But
Just look maybe
Yeah.
to see if there's an issue there.
I think it will be the same change in the HOA addendum at that point.
And then I think there's also something
Thank you.
additional in the condo contract.
Except for prepaid. That's provided.
There's two places in the HOA addendum, there's two things.
No, that's still
fine.
okay.
That's still okay.
okay because that's what the HOA requires. That's what they're requiring in connection with the sale.
And also some additional language in the condo contract as
So.
So you're saying the regular period required by association,
Oh, I was looking up here.
yeah, are to be prorated percent to paragraph.
Right, yeah, just to make it consistent.
Yeah, so change paragraph C, well, that last.
I think so, then that way it gets.
Okay.
You were on that committee.
We want to go to page.
Questions, good answer. While Ron's typing, there, I'll tee up some other issues. I think it's a good time to do the HOA addendum as well. Texas Realtors, I believe, had a suggestion here in paragraph C of the HOA addendum. In the last paragraph that we added has a double negative. And there was I personally really like the language they suggested. I think it's real clear. Actually, might even be a little bit shorter to remove the double negative.
Where
And so we're looking at If you look on the HOA addendum in paragraph C,
Mhm.
the last sentence says, this paragraph does not apply to a fee that is not imposed by an association, even if it's collected by the association for the benefit of a third party. And so it has a double negative in there, and the language suggested by Texas Realtors would say, this paragraph does not apply to a fee that is imposed for the benefit of a third party, even if it is collected by the association for the benefit of a third party. Their suggestion is on page 10 of our materials, at the first full paragraph. If SJ was here, she would be screaming up and down to remove the double negative. I'm confident of it, so.
So we'll do that.
Yes.
I'm fine with
That change.
I'm fine with that change.
Imposed for the benefit of
There's gonna be so
Part
much
of there,
there.
yeah.
Yeah, I was kind of teeing up another issue.
There's gonna be so
I'm
much
just trying to
stuff going
figure
on,
out
nature
which
is
way
sure
to go.
legislation. It's not. This is not the end of this amendment.
Okay, so,
It's never.
PTA support charge. Whenever you sell a piece of property, you have to pay $100 that we're gonna send to the PTA, which is one of the exceptions under that private transfer fee law. So I'm collecting $100 for the benefit of the PTA. And I'm gonna pay that to the PTA. That is a third party.
That really happened?
I think there's some neighborhoods, I think in the Austin area
Okay,
that
that's
have
a new one on
a
me.
PTA support fund.
That's a new one on me.
Yeah, that's the 501c3s are one of the carve outs under the private transfer fee law.
So if that paragraph that with a cap does not apply to that, that would then be a seller obligation. The buyer obligation.
Yes, it would.
There are several examples in our materials as well. One from I believe an escrow officer that attaches a lot of HOA certificates. And they highlight a lot of different fees in there. Generally speaking, it's management fees, or a service fee or some type. I can find exactly what they're listed as, but what if it's a fee to the management company?
Mm-hmm.
Processing fee to the management company. That's a third party for the benefit of the third party.
Mm-hmm.
Or is that to me was the most confusing category that I can argue both ways within our language.
Is it with the new legislation, all their fees have to be on the website now?
Even assuming it is on the web, I believe there is some more disclosure than that.
So at least they'd be able to negotiate it, is what I'm saying.
Why
They'd be
did we
able to
have this
negotiate it if
sentence
it's
in the first
visible.
place? Why did we have this sentence in the first place?
We didn't want them collecting the,
It's on page 141, I think, John, is what you were referring to, that one of the attachments, and the question about foundation fees and capitalization fees oftentimes come up. The capitalization fees, according to their example here, was a benefit to the association and the community, so staying with the association. And if that's the way it's been looked at, that if it's collected by the association and stays with the association, would fall under those fees that could be shared for paragraph C between buyer and seller.
I agree with
would the
that.
association
And
ever collect
another one,
a
that's good on those comments, she also highlights conveyance processing fee. Member charge, several working capital ones.
Does anyone know if the management certificate the associations are required to put on the TREC website is
That's the thing I was
it's
thinking.
supposed to be the presentation of what those fees are that are only happening because of a sale? So do we know if that is conclusive, and that's what the associations have been told? So that title companies and agents and the consumer can go to that certificate on the website, and that should be all of it? Is that, do we know?
As practically title always gets a certificate, they don't rely upon anything filed in the records. We're getting a statement of account, we're getting the HOA certificate in for each individual
Right.
deal. I'm not sure whether what's online is conclusive or not. As a practice, we're not pulling that information and relying upon that side of it.
Right, and my understanding was that the HOA is told that they're supposed to file this management certificate that is what we would look to for the source of those expenses. But
Anybody have any more knowledge
Any more
they can share on
information?
that?
The
Are you
Brian,
asking whether the management certificate has fee information?
yes,
It does, and it's like a list of contact information and like HOA website information. It's who is managing this association, their name and their contact information. It's pretty high.
so the requirements of the HOAs to disclose costs, are they being requested to do that? And is that part of what they submit to the HOA, to the
No.
Trek website?
No, the commission has really limited jurisdiction on this.
Yes.
And it's just to accept or public display those management certificates, which are dictated by statute, but what the contents are, but it's mostly like contact information.
Okay,
Still
thank
have no
you.
way to find out what it's gonna cost the seller before we get to the closing table.
And we put the onus on the seller because they're in the best position to find that out up front. That's why we created the cap. So the buyer knows what they're getting into, and the seller should take the risk that it's higher because they theoretically can get it out.
they're a member of the HOA. Brian brought up an idea of it, I thought, and I think you were saying that the whole thing in this paragraph does not apply to a fee that is both for the benefit of a third party, even if it's collected by the association for the benefit of the third party. I think we were trying to be concerned about if HOAs were collecting a private transfer fee. Is that, I'm trying to go back to where we had the discussion,
It's
which
been
is.
spinning in my head as well, and I don't remember exactly why we.
And I don't know, is there a situation where an HOA would try to collect a private transfer fee from a third
I
party?
don't, no, I don't think they have that.
And if that's the case, do we need that sentence?
Do we need the sentence at all? I mean, where has there been any sort of abuse?
Yeah.
I don't understand the PTA one, that's what I.
Yeah, but if it's, I don't know it seems like that sentence may be causing a little bit of issue, and there's not really a, you know.
I don't know that we need
This
it.
is all gonna change. This is the hottest topic in legislation right now.
Has
So why
anybody
we added
had,
that sentence?
has anybody had a situation or a transaction in which this was an issue, that the HOA was collecting a fee? No, they may have been, we didn't pick up on it, but has anybody knowingly seen one where the HOA is collecting a fee for a third party?
And if so, shouldn't it, if they are imposing that fee for the PTA or whatever, it should go into the calculation that we have here about buyer pays X amount, not to exceed this, and seller pays the rest. I mean, it makes sense to me. I don't know, I just can't remember the problem we were trying to fix.
If I see the issue that was highlighted in the comments, that this will be misconstrued,
Yeah.
for the service fees and all these other
Right.
fees that are
I
out there.
move that we zap the last sentence of
I love taking it off because I love shortening anything.
I'm in favor of that as well.
I'm good with that.
The last sentence of C in the addendum.
Yes.
So the
Paragraph does not
interesting thing
apply.
is, and Ron, I think you might have been the speaker. There was a webinar shortly after this form came out, and there was a woman who was representing the title industry, and there was an attorney, and I thought it was Ron, but I guess not. And they really clearly were explaining the costs and the issues with these private transfer fees, and it's not that it's a new issue, there've always been these costs. But now because the form was changed a year or so ago, agents are paying more attention to what are the costs that the seller is going to have, so we know how much to put in that blank. And so now they're just asking, what are the various fees and who's responsible for what? And I think that we've just found out that it's gonna be so different for every single homeowners association that it behooves the listing agent and the seller to find out what those costs are, to be able to pass it along to the buyer's agent. But the thing about this last sentence that made sense is those speakers were clear in saying that, don't be so upset about it. I think even Texas Realtors in an article said that it's the costs that are happening because there's a sale taking place. And if it wasn't for the sale, the fee would not be charged. So this says this paragraph does not apply when the association accepts funds, even if collected by the association for benefit of a third party. I think that was going back to what they were saying is it needs to stay with the association. So if that isn't clarifying anything, then whatever it will be to, and again, it is indeed education, in what are the expenses because the sale is taking place, so the buyer can know what they're going to contribute toward, what the seller's costs are, and it's the seller who needs to know it. So I don't know if that made any sense whatsoever, but it is a need for clarity for the agents. And if that's going to be more articles and more training, then that will help, because I don't think we talk about anything in classes more than this section. What does that mean? And does that count the capitalization cost fee, and does that include, and we can't answer that question.
Well, the
We have to go
HOAs
back to
keep
the
coming up with
HOA.
ways to label them different to try and.
And to your point, I don't think this is clarifying anything. You
No,
know,
it's
kind of
not.
what, it doesn't
No,
solve,
it goes-
we tried with the other language to solve an issue or clarify something. And reading this now and having time to think about it, I don't think we're solving anything there. And maybe the limited PTA example or something that pops in is very seldom, that it happens in transactions. So I think with the comments we got back, this will create more confusion and problems than it's solving.
Okay, so we're gonna zap that last sentence of C, and then do we need to change the language in C the same way we changed the proration paragraph in paragraph?
Yes.
Yes.
I'm fine with that. I would note that, in our Texas Realtors comments, they didn't say they didn't like that sentence. It just suggested that, getting rid of the double negative.
Well, we're getting rid of the
I don't
double
know.
negative.
We're getting ready.
We are.
We are, that's it.
We are indeed. I'm
And
not saying
let me go, do you have some more insight from the membership on this?
No, no opinion. If it doesn't help clarify, because if I recall, that was the reason why that sentence was added, because it goes back to trying to help clarify what that definition of fees is. But if it's the consensus of the committee that it doesn't clarify anything, then that would be fine.
Well, it's very good drafting to take out the double negative. If we went that way, we were all in favor of that. Removing it would probably help.
We're just doing you one better.
We got completely rid of the double negative.
Yeah.
So
Okay.
okay, then changing 13 to the way that Roland had his comments, or we're doing anything else in 13?
Where was Roland?
That's it's the parenthetical that says including items that are prepaid. So 13, that first sentence is going to read taxes for the current year, interest, rents, and regular periodic maintenance fees. We're taking out the word prepaid. Assessments and dues, parentheses, including items that are prepaid, will be prorated through the closing date.
Yes.
Yes.
Okay, are we making any other changes in 13?
No,
Not at
No.
13.
just that one change.
Okay.
And
Don't
then,
give anybody ideas.
now, are you to the HOA addendum C?
Yeah, so we're taking out.
We're taking out the last sentence.
Right.
That's
Did not know we had escalated in contracts, so.
Continue working, I just want
Yeah.
it's at that moment. when,
Hey,
some people
we
start
could
getting-
make C a lot simpler if we just said, except for regular periodic maintenance fees, assessments, or dues being prorated pursuant to paragraph 13. Could we not take out that new sentence we added?
Can you read your sentence again?
So I propose the second to the last sentence of C be deleted as well. And we just have C start, except for those regular periodic maintenance fees, assessments, or dues being prorated under paragraph 13.
The issue and concern was, I thought, that you were trying to distinguish and address the question raised by prepaids.
Well, I'm saying, yes, but if this directs them back to paragraph 13, then paragraph 13 is going to control. Except for those regular periodic maintenance fees, assessments, or dues being prorated pursuant to paragraph 13. And you could say including prepaid items.
I see what you're saying here. It's combining the two, making
Yeah,
it
it's just,
brevity.
it eliminates the need for that whole sentence that we added at the end of C.
Am I missing that the way it's currently worded, that we're only, under the current wording, we're only accepting the prepaids, the way it's worded? And so the way you just read that off, I mean, the way you just said it, Brian, you switched it back to how we, and this is, I think, the issue doing consistency. That we're really saying not just prepaid, but any
Yeah.
regular periodic maintenance fees,
Yep.
assessments
Where was my
are
change
being
again?
59.
prorated.
Yeah, that's the fundamental change being
Right.
made in both places. And his new comment was to, why don't we just throw in the reference to paragraph 13 in the first sentence
Right.
and get rid of that whole
Yeah.
next one to save the life.
That's a good idea.
I like that idea too.
I'm just writing.
Does anybody have any thoughts on that? You know, it's really just combining two sentences into one with the same substance.
I'm good, fine with it.
I didn't know attorneys could make this more concise.
Possible.
Well,
Lightning strikes
my
twice
next
sometimes.
change is, at the beginning of C, we say, know all men by these presents, that hire the seller, covenant and agree explicitly. Okay, so let's, Ron, okay, so in paragraph C, except for, scratch out prepaid and put those. Okay, and then after dues, put parentheses, including items that are prepaid, close paren, that are being prorated by paragraph 13.
That's in our material.
So that lead in is going to be, except for those regular periodic maintenance fees, assessments, or dues, paren, including items that are prepaid. In fact, we don't even need that parenthetical. Dues that are being prorated by paragraph 13.
Okay, so, on toward B.
By the way, can you put that up on the screen?
I keep looking up. Check it, we all have a lot of trust in Ron.
I don't-
So-
In Ron,
We're going to get the comments back and it's like, what in the world did we
You know that you
do?
have to, agree to these minutes before you see them?
In Ron, we trust.
Let's see here.
Purpose Ron.
Why is his photo on all the addenda?
I'm gonna make a comment for SJ. Why aren't our pictures on the website? We love you, SJ, if you're listening.
Please share.
She's not on.
Yeah, I don't think her mic would be muted.
Yeah.
Sure. What's that?
Use 915.
Yes. Here we go. Oh, wow, that's a lot shorter.
Except for those regular periodic maintenance fees, assessment and dues. Prorated by paragraph 13. So do you need that parenthetical? Because that is in paragraph 13.
I think I would leave it and let it be consistent with
Okay.
the wording in the contract, in the proration part. That's my 2 cents.
And you need the blank.
Because then somebody will say, oh, well, then you- did you mean prepaid or not prepaid? I mean, you know.
Why do we
Yeah.
start? I mean, what
So
are we
I'd like to take
starting?
out the word being, you have a problem with that are prorated by.
To be, how about just to be prorated?
Why don't you say that are prorated?
Okay.
Because they are.
Why do we start with except? Why don't we have the positive except for?
Because
That's how it originally started.
We had
As well.
except,
Not saying
except
that
we had as provided in A and D.
if we were.
you're talking about the negotiation.
I'm not
And no one,
advocating for change, I'm just.
Yeah,
and no one likes change.
So,
that.
didn't know
this
if it had
or
to
as
be-
provided seems awkward to me here, except for those regular periodic maintenance fees or fees
That should be bold and capitalized.
provided by.
Okay.
I guess it should be and, right?
Well, we're not trying to get that cap to include those amounts, are we?
Correct. They're separately allocated.
So it should be.
Yeah, so it's an exception. They're accepted out.
Oh, that is accepted. You're right. Never mind.
All includes any, right? That we have.
Yes.
And also.
Yeah, that's good. I was told there would be no man. Sorry.
Would it be easier to have little items or something for it to read?
Yeah,
more
that's a good.
clearly?
I did have that same general thought before we start making these changes, that there's so much included in that sentence.
Too many
Things about
except
making that
fors.
change, but that wouldn't be helpful.
It's a run-on.
Yeah, normally then I'd move this up front and do the exceptions in the back, so you'd say buyer shall pay all association fees.
Yeah, what is it?
Here, this might show you real quick.
Yeah, draw a sentence tree.
And we'll wrap up this HOA language and then we'll break for lunch.
I know what an adverb is.
Well, you're 5 steps ahead of those people.
That's what my fifth graders go into right now.
Oh,
And a
gosh.
lot of the prepositions, and all, I have to rethink and learn.
I know. We don't fit the
What it is, I don't know what to label.
Where is the library at?
On the iPad,
It's
come on, you
dangling,
know
it's
that.
dangling. My
You've
son-
heard- you've heard that.
now? Did
they
they
actually
actually teach that?
Mhm.
That's good to know.
You've heard that old joke, haven't you?
It's, I'm having
Most
to
people
relearn
don't
it.
know how to do it,
The
What's
what?
up?
but you know what?
Aggie goes to Harvard and
Okay.
walks up.
Every time I start practicing them, when I
You
end
tell
it.
me where the library's at.
Yeah.
Sir.
And I have to
You
try to
around it.
rewrite it, sometimes you cannot get around it.
I'm sorry.
But it aggravates me because I know. I remember that from 7th grade sentence structure, diagramming.
My son
We're all-
finishes sentences with prepositions just to annoy me. That's his entire motivation. He's 22 years old.
He ignores them if you end it or begin it.
My son ends his sentences in a preposition just to annoy me.
Oh, yeah.
And he's
It annoys me
20
personally
and he's
when I do it to
22.
myself. and then
I think that-
it.
That,
He knows better.
I don't know.
I think that's confusing having
That's all
similar triple
Congress
X's
do
at the end.
Okay, now we're gonna move into,
Don't you think about that when you're typing an email? When you start writing a sentence and you're like, crap, that's a preposition. No, I do.
I mean, like,
I'm
I go,
like,
that's not right, and I fix it, but I don't necessarily change the terms.
I sent,
Yeah, no,
I
yes.
fear it, because I guarantee you, whoever responds.
that's not an underline.
His computer's.
No, but I'm my
yeah, it
worst.
just doesn't like that line.
That looks like my bank
I like
account.
that. Most people wouldn't know.
Luckily, my high school sisters on Facebook, so occasionally I reach out to her and go, is this?
Right, so we could say,
There you go, that's the best thing.
Hey, you could say, I mean, the buyer pays blah, 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 not to exceed, and seller shall pay any excess. The previous sentence does not apply to.
I'm just, my brain is mush.
Yes.
I mean,
I like the original one
Yeah,
almost.
I think C works better. It really does.
I see what we're trying to accomplish there, but
Yeah, I just was thinking if you put the, and I do probably more grammatically correct, but if you just put the little I, except for little I, those periodic da 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 da, and little double I, or whatever, but for fees provided by paragraphs A and D. It just, for me, it helps separate it out.
Yes,
I like that.
I'll go with that.
Does everybody see the language on the screen with the top version? We added little I, double I to make it a little more clear.
That does help.
I like that.
Yes.
we have the disassociated and transfer fees. Other charging associated transfer fees. Okay.
It's a little awkward where it says parenthetically that are prepaid, that are prorated.
I think we were trying to track the language that was switched in the proration paragraph of the
Yeah.
contract.
Could we just say including prepaid items?
Could be and are prorated as opposed to that are repeated twice like that.
I'm good with prepaid items, to say including prepaid items.
Yeah, but getting it somewhere,
Sure thing.
and it's going all together.
Mhm. Yeah, including prepaid items. And make the same change in paragraph 13.
It's been doing it for 12 years, you should be good at it.
You realize that it doesn't.
I mean, what happens when you?
Y'all might wanna look at that.
Let's, you want to leave that up on the screen when we
Yeah.
contemplate that?
Yeah.
And we'll I think we're close. All right, we'll officially take our lunch break. Thank you for a long morning, and we'll pick up here.
It's not even close.
Thank you.
I'm gonna go see what the road is.
Thank you, everybody, for taking a fairly quick lunch today. Since with all the materials we have Chairman Scott Kesner, who's joined us on the call as well. So welcome, be on your P's and Q's here. But we left off at lunch discussing the HOA addendum language, and specifically the fees and deposits for reserves. And up on the screen, Ron has worked through lunch, thank you, to present 3 different options for what we were discussing to help facilitate this. So I believe everybody's had a chance to read these 3 options. And Brian, you can.
Yeah, first of all, I like the idea that if we can move that 1 and 2 to the end, it makes it a lot clearer. I like option number 2,
with the following changes, where it says except for, just say except. And then one, regular periodic maintenance fee assessments or dues, including prepaid items, will be prorated by paragraph 13. And 2, as provided by paragraphs A and B.
I like number 3 because it's divided into 2 sentences instead of 1 long sentence. Subject to those changes, I think it's easier to read.
I would agree with that statement as well. I think breaking it up with 2 paragraphs or 2 sentences, to me, it's easier to track. But I do like Brian's changes as well.
I'm okay with this third one.
I like the second one better, but I'm okay with the third one as well.
I like the third one with the changes.
We do a poll, see who. So I'm not strongly in favor of one or the other, but I do like the third one. So with those changes that are made there, let's start. Does anybody else have any comments before we take a?
Brian, what did you say on doing on 2? You said,
Well, first of all,
As provided,
except
you said-
one, after including prepaid items, say will be prorated by paragraph 13, rather than that are prorated. No, I'm on the second option.
It's the same on both.
Yeah.
I think we went with R before the. In the
I think I
affirmative.
like I think I like it that way, but you had said something else about little on 2 also, Brian.
I'm sorry?
Didn't you say
It's gonna
something
create
else
my
on
brain for a
2?
second.
Instead of fees provided by
Oh,
A&D, you
as
said something
provided
else.
by, just as provided by,
It was
except as
except
provided
for-
by paragraphs A and D.
Well, we're accepting out
Yeah.
fees, right, is what we are, right? Because that addendum has fees in it,
That's a subject. I think we need that subject in there, the fees.
because it's,
Okay.
well, let's see, in D, they say seller shall pay the title company the cost of obtaining the information.
Get 2 cents.
So it's cost in D, and then
There's no
A.
cost. No, but this is,
is actually on 3.
I like door
the
number
last
3,
one I think is pretty much.
where Cheryl Merrill was standing.
Everybody drifting to number 3 now, or the third option?
Do you want fees or costs in there? Because I think that's the,
Obtain, pay for.
I agree with the consumer right there.
A
That's what I'm
and
saying.
D are those.
That's gonna be clear. And those people that,
I guess it's the same. fees and
Okay,
costs.
D, we talk about costs of obtaining.
Which may be why originally C was worded a little bit more vaguely. Because it used to just say except as provided by paragraphs A and D. So maybe that's why, so you didn't have to. worry about
Costs and
if it's
fees.
a fee or a cost.
Costs and fees provided.
Because in 1, we're talking about fees, assessments, and dues.
Paragraph A is talking about the cost of getting the resale certificate, right?
I think that covers us. I mean, broad, we look at the understanding of the consumer.
All right, so I'll delete these 2.
That's a consensus. All right.
Back on 1 to 4.
Back on to 1 to 4. We'll continue as we did before lunch of marching through the contract and taking it by paragraph with the comments.
John, did we want to look at the TLTA?
Yes, we can circle back. So we had a question of why did we put that last sentence in the language in terms of private transfer fees will be responsibility of the seller. even though the association may collect it, right? So the TLTA concern was just that the HOAs were collecting these private transfer fees that should be the seller's obligation. And Brian actually had a conversation that he can.
I talked to Roland Love, who's an attorney he's the chair of the regulatory committee. I just called him at lunch. And I said, why did we have that? And he said, well, twofold. Number one, we were worried about the private transfer fees. I said, well, I think we're covering that elsewhere in the contract, right? Don't we have somewhere in there saying that they're the obligation of the seller? And then he said, and I could send you things, but he says, there are some HOAs in the Austin area that are collecting all sorts of money for people, for like the PTA or whatever. He says, and there's some sizable amounts. I said, well, as between the seller and the buyer, isn't the seller in the best position to know what those are? I said, well, the way we got it worded is buyer pays X and seller pays any excess. So if those fees are being charged, they should be the obligation of the seller.
I agree.
And then that removes the confusion, like we talked about before lunch, on what falls within that category and what doesn't.
And I made that comment. I said, people are worried that this is gonna be confusing. And he says, well, don't. He said, if it's still a problem, we can always revisit it later. He says, I don't feel all that strongly about it.
That's helpful, that's really helpful.
Yeah.
Okay. So
First, do no harm.
So the next section we have is paragraph 18, escrow. And we've already gone over the capitalization of escrow agent. There was one sentence we put in here about being able to condition the release of the earnest money, requiring the title company being able to require a written release of liability before doing so. There were a couple comments that, well, it should say shall, the title company shall release it and not give the title company any discretion. But what we have a situation there, if we did that, we make the title company judge and jury, and put them in the middle of liability.
And we obligate them as part of the contract, and they're not a party.
Thank you.
Exactly. And so I don't think that's a change that we can make, and what we did was just clarify the title company's right to hold that money until the parties agree on who it should be released to. The next section we had quite a few comments on was paragraph 21, the notice section. And this was one that we actually had several people say, good job, we like this, we like the change and be able to get courtesy copies of notices as agents. What we did here, for the benefit of everybody, is add a line that simply says with courtesy copy to. In that way, the agent can put their information in there if they want to obtain the notices or receive a copy of the notices. But at the same time, to make them legally sufficient, they have to go what we believe should be the parties, right? The parties to the contract. All too often, agents put their information in there, which puts them in legal jeopardy. It can harm the consumer by having an agent get a notice if they don't forward on to their client. But so we have 5 likes to it, but 2 had a suggestion that we talked about last time, we probably need to revisit, about adding a second line for the buyer or invoice seller. That a lot of these contracts is husband and wife or more than one party. And as of right now, we only have one line for email and fax and for phone number. And so the suggestion was to add a second line back in and then still keep the courtesy copy language.
I think we talked about this, but I'm curious, when this says all notices must be in writing, why do we have a phone number? Why don't we just replace that line with email/fax? Their phone serves no purpose.
That is a great idea.
Unless you need to talk to the
I was gonna
buyer
say,
or the seller.
The
No.
title company calls the client.
Yeah.
so
But it's still a notice.
This is not for the title company. This is for the parties to communicate with one another. If the title company wants a phone number, they can call and get it.
I
But this
think it's always been
used for the title company, the mortgage company, all parties to look at it. It's contact information.
Oh,
I don't think we should take out the phone number.
This is back to the, hang up the phone, I need to use the internet.
This is what this is, but then we gotta realize what this is for. This is contractually between the parties where they're to give notices. It
In
has-
writing.
It has nothing to do with if the title company needs the contact information for the buyer, they can call me, I can give it to them or whatever. It's,
That's adding another step, in my opinion, to the title company.
oh, I'm sure.
And it's no harm done to have a phone number there when the wording says it's supposed to be done in writing.
But it's inconsistent when you say that it has to be in writing and you have a phone number. Hey, you need to be sure to give this in writing, here's my phone number. What does that, you know, that doesn't, it doesn't make.
If it's gonna move on to another page anyway, what is the problem with adding two lines?
Yes.
I'm just saying there's a way to add a line without.
Yeah, and honestly, I don't disagree with you, but I also think it's no big deal to just add two lines.
Add 200 where?
Hey, so for
Under
phone
phone.
and email.
You're talking about under buyers? It ought to be parentheses, S, close parentheses, buyer, plural, buyers, seller,
Well,
sellers.
it's the way it is now.
We're both a buyer.
It's a defined term at the beginning, and so if they put multiple in there, then it's defined
Delete the
as the
phone and
singular,
have an extra line.
even though there might be multiple.
Why don't we ask the people who have title companies here if that's an important thing to have a phone number on the contract?
I sue people.
We
It's
like
not
it.
important. When I give notices, letting you know, specific performance, you breached, you did this, I don't really use your phone number.
Well, what if the phone number, however, is used for a written text? And that's the only way the person can be contacted. We're taking away that option to communicate.
Yeah, in the draft we have now, and pull in another comment that's outside the contracts, was the formatting and spacing. And there does look to be maybe a half line extra space between the line and the phone number. So if we fix the spacing issue and added another line, it likely wouldn't make it any longer than it is now.
Instead of phone,
Anyway, so
put
even if
text.
it- Yeah, I mean.
We like the phone number, but to be honest with you, in our area, most realtors put their phone number there, so it's useless.
Well, education is gonna have to tell them, which it is now in legal.
I know, they don't listen.
Well, they're gonna have to listen or they're gonna be sanctioned.
Why are they gonna be sanctioned? They're allowed to do that.
So does everybody agree to
And then
add,
they become
They have to be,
liable.
they're responsible.
so does everybody agree to add a second line in? And we received several comments on that.
Yes, yes.
Yes,
So
yes.
second line in, and then I like the comment of the phone, but I do see the
I think we should.
reason to have there.
Yeah.
So is everybody okay with adding a second line and keeping it going?
Now, can I ask a question? What's the difference between with a courtesy copy to and with a copy to? The word, to me, the word courtesy
Good point.
says that is not a legal obligation. Will you, and please send a copy to. No, I don't think I will. And contracts, I mean,
Hey, that's a good point. It's,
I think there's an ambiguity if we say with a courtesy copy.
yeah, because
You either
that's,
do or you don't,
that's right. This is where all
Not a
contract
courtesy.
notices are, with a courtesy copy means what?
please.
Legally, could you?
I think it creates an argument that I don't need to get the copy.
I don't
You ask
think
me to, but I'm not obligated.
No, you don't have to.
Liability to
Pardon me?
whoever.
I don't believe you have to if you put with a courtesy copy. The very concept of courtesy means it's not a notice.
Well,
That's what we decided last time, but that's why you decided to put courtesy copy, if I remember.
Because it's not considered
We
delivered
didn't
to
want it
us.
to be out obligatory. Now, are we changing our mind?
Well, technically, I didn't like it last time.
I'm
not
telling
changing
you,
mine.
Hold on, so let Brian.
you're gonna have a lawsuit over whether a notice was effectively given. I didn't give the notice. And people are gonna argue, what is a courtesy?
Well, who's the
But that's
courtesy
not the
copy?
notice
to?
party.
Pardon?
Courtesy copy is going to the licensee, it's not going to the buyer or the seller. So that name is gonna be perhaps the agent.
And are effective when mailed to, handled,
No, the
or
notice is going
transmitted
to
by
the
fax or
party.
No,
electronic
we're just saying-
transmission as follows.
But
With
that's a
the
courtesy
courtesy-
copy to that party, that's whose name will be there.
We did limit it last meeting on this discussion. We had this discussion and said we don't want to make it a legal obligation, so we left in courtesy, was there, and I'm not necessarily tied to that, but that is the reason.
Okay,
And
and I'll
that was
just
my
tell you
point.
that if
Take
I
out
didn't get my courtesy copy, I'm gonna make the argument that you did not give notice as required by paragraph 21.
Well, hold that thought, or
Yeah,
you,
no, that's a good point.
the party or you're the
If
agent?
I'm the
He
party
says-
entitled to notice, I'm gonna say, you
It
didn't give me
doesn't say
notice.
agent.
I know,
Why? Because you didn't give me
But
the
who's
courtesy copy.
who goes in buyer's spot? Because I've already heard a difference. Who goes in buyer's spot? The
Well-
agent or the buyer?
No,
Well, it could be
they're
anybody.
supposed to be the.
That's
He just said the
it could be a third party.
It could be.
No,
It could be anybody that go there, whoever you want to give notice of your.
I know the answer.
But that's,
The whole reason we did that courtesy copy, to try to get the agents to stop putting their names in these two paragraphs.
That's
I
what-
get it,
Well,
I
that's
get it,
what-
but I
that's
think
what
we're
we did.
creating
That's
an
what she's right. That's what we
ambiguity
did.
as to
The
whether
agents would
it's
stop
legally
putting their
required
names
or
in.
not.
And so maybe the courtesy copy, to your point, is creating more of an issue.
It creates
And
an
it should- maybe it
ambiguity
should
as
just
to whether
come
or
out.
not it
The
is
agents
required.
should be communicating to each other and to the parties in common practice, so maybe we should take that courtesy copy out.
I think, just take out the word courtesy.
well, this is when we have the
Didn't
most
you
likes
say
of all, so we
without
get
it,
most
there was
thumbs
a
up.
problem?
Okay.
Yeah, I think part of the discussion too is that now in the required courses, they're teaching the agents that they have to send any kind of notice from, where we were sending agent to agent, now we have to send to whoever's listed in 21. And so the idea was to encourage them to copy the agent, hence the courtesy, without needing that additional liability is why we put in courtesy.
And
So
to further that comment, the legal update materials that are out there now say, and this is a shock to a lot of agents, that when you send a notice, and you need to send it to the other side's client and the other agent. And a lot of them, well, I can't communicate with the other side. You
right.
know, I have to go through their agent. And this is clarifying that when you give notices under the contract, you do have to, and if they're listed in there, give it to the other side directly. And always copy their agent. And that's what's being promoted in the legal updated materials right now. So it's.
I don't
it's-
know. A lot of
I guess
people are gonna sue
my
over
my
courtesy.
point is, a contract is a place to state obligations, not wishes and desires. And if it is merely a wish or a desire, it doesn't belong in the contract. Because somebody's going to read this, say, you had to give me the courtesy copy. And somebody's saying, no, it's only a courtesy. And I'm saying we're creating an ambiguity with the word courtesy.
I think that's
The
a
wishes
very
and
good point.
desires part of that speech to our legislature.
the challenge I have is if we take that out, they're gonna start sending it back to the agents. And the agents are not gonna deliver the notices to their clients, and we're gonna have, that was what we were trying to get away from.
Well,
Because-
we can't
What
train
is your vote?
everybody. when they
Leave
do
it-
it.
I leave it in, I
So,
would leave it in
Brian,
as
if
it
it
is.
just said with copy to,
Yeah, that's all I'm saying.
and that just means in addition to
Yeah, you
someone
give it to
else.
the first
this
one
is a
and you
copy
give it to
to.
the second. Your paragraph 21.
Is it then considered delivered if I don't give it to the first one and I go and give it to the second one?
Maybe send it to both.
Send it to both.
Well, I'm saying, if I don't, is it considered delivered?
Well, that's another argument.
Well, I'm just.
That's another
asking, 'cause that's-
discussion that I've already been voted down in prior meetings. My interpretation
You
of
know
the law.
what?
Your time is
Tell
gone.
us what your jury decides.
Yes.
Well, if you get actually
delivered
get
is
notice,
what
you
you're
got
concerned.
notice, you can't say they didn't get notice if in fact you can prove it by other means. So the question is gonna be is, if you didn't comply,
You just made my argument.
and of course I did,
Yeah.
because you're a smart guy.
Paragraph
He's the
20
lawyer of law.
Paragraph 21 is a safe harbor. If you give notice pursuant to paragraph 21, it is notice. Okay?
Well, there's exceptions to that, but I'll agree with you. what
It
you're
has to be in
saying.
writing,
Okay.
it must be in writing, but if you give notice by paragraph 21, then notice is given. If you give notice actually in some other matter, means it might be okay, but you don't have the guarantee of paragraph 20. If you follow paragraph 21, you have given notice.
Unless you know it's not effective.
Was that?
Unless you know it's not effective.
And we want to promote the agent receiving notices as well, in terms of staying informed in the transaction, right? And so if we're looking at legal gray area, I originally was strongly in favor of keeping courtesy in. But in listening to this discussion and the potential gray area created by it, I'm not necessarily opposed to taking courtesy out to make sure the agent gets a copy. When they see copy too, I think more people are going to think I have to do it. And you know, the legal arguments aside, a lot of these things never make it to the court, so we'll never know the actual answer at the end of the day. But I think as a policy of promoting the agent getting notice and staying informed in the transaction, I'm okay with taking courtesy out. So,
If you gave them 3 blanks with no note whatsoever.
well, I think having the direction of copy to is picked up a lot. We had warm lights on it, and people
Yeah.
finally
Oh, I
came.
understand
We're
that.
finally able to do it, and it ties in with what Trek's promoting right now on how to give notices. So the education materials are already there.
Yeah.
And then I think it may be a good time to make the switch, and there's the opportunity for the training with the required course to inform the agents of what that means.
Yeah.
Okay, if the practice now is that agents are putting themselves there.
No.
And no, but that's what they're doing.
Right.
They're putting themselves instead of the client.
Some.
That could be everyone.
It's a prevalent issue. that's
Okay,
for
there are a lot of those doing
You
it.
understand it comes with liability, but it
Okay,
is liable.
it's more than 5%, so let's.
Yeah.
More than 5%, yes.
If you have the agent name in there and no others, and it says copy to. Is that a notice? Because that was a
Yes.
copy to somebody else, right?
But it's a notice on behalf of that agent.
So does that
Therefore, that
create
agent-
notice?
It creates notice and the agent has the liability for.
Right.
So it goes right back to where we are putting
Yep.
agent names in there.
Mhm.
Correct.
They can still, the agent can, the buyer or seller can choose to have their agent be the receiver of the notices. If there is liability by the agent to be sure those notices are passed on.
Always.
Yeah.
But how about this idea? And maybe we hit it and I was just glazed over. We leave it so generic as we have it with courtesy copy, and they say, I want it really sent to my dad because I'm always traveling, I'm a truck driver.
Yeah.
Your dad has no authority to bind you or to be a representative. The agent does, an attorney does, you as a party does. But I can't just say, my cousin Larry, my friend, my dad, I'm out of town, I'm at the beach. You can't put that kind of notice. Then it's ineffective legally to even give notice to the side. Then it's a useless provision.
I don't know if I agree with, if you put that's where notices are to be given, and you as the other side give the notice in accordance with that, I think that's effective notice. Now, they can't bind you to change up any contractual changes without a power of attorney or something like that, but if you say give notices here, and even
I mean,
if it's
I
a
hear what
PL
you're
lock sale
saying.
somewhere else, I think.
Like a
following the
termination
contractual-
doesn't require another signature on the other side.
Yeah, and as soon as you send it in accordance to
Yeah.
this provision, says it's effective when mailed to, hand delivered, or transmitted by fax or electronic transmission.
I guess if you find them
You
again,
do
you
it
say you
pretty-
agree to be bound to that.
Then that goes back to the law, when did you give notice, how did you give notice, did they actually send it?
Let me
Let me
that
ask you
happens a lot.
this, what about this idea? Instead of saying with a courtesy copy to, say with a copy to buyer's agent, with a copy to seller's agent. That makes it clear that the person, the copy is going to the agent.
That is the intent.
And that makes it a little more clear that you put the buyer and the seller's contact.
That should signal, you put the party's name in the buyer, and this is who.
With a copy to buyer's agent, with a copy to seller's agent.
Because that's the goal, isn't it,
I'll
right?
work
You
with that.
brokers, y'all are trying to get a copy
I
of
like
it?
that fine.
I like it.
That's interesting.
Well, a copy of it, but also that the buyer gets a copy of it. not-
And
Well,
they
that
leave
should
blank.
signal that you don't put the other person's
Right.
name there if you put the agent.
Do we put
Because I
broker
teach
or
it, Gene, I
agent?
just,
Buyer ad.
Agent is the way it's listed on
And
the
the copy for the buyer's agent.
I like that.
Fine
Well,
with
I
I'm
like
fine
that
with
too.
that. Are you okay with that? Because you are the brilliant
Well,
authority.
we should probably.
A good alternative thought.
Put, a parenthetical that says, with a copy to, what's the term we use here? Listing associate, or listing broker, other broker. We put a parenthetical and you just put the.
Don't we-
The same as on the back.
Don't we say, actually address, say agent at some point?
Yeah.
Because you're not sending it to the broker, because you're not gonna,
Represents buyer only. as
Well, but
buyer's
it's
agent.
listing broker
That's why
ad,
you
and
have
it's
to
whatever
provide
email
the
they put
email
in there,
address.
so.
On the
Listing
signatures,
broker
we
and
say.
buyer not broker, I'm okay.
I guarantee you, I'll put my broker's email in there and put mine in there.
yeah.
So you want to add their, with a copy to buyer's broker, copy to seller's broker, or seller's agent?
Agent, I think.
I would
whatever.
say agent, only for the fact that I got all these notices, I would be really upset.
Does this work
All
for
my agents, all of a
intermediaries?
sudden they send them to me.
Well, there's I believe there is a buyer's agent under the broker
They're still an agent.
and a seller's agent under the broker.
Yeah, well, you have listing associate and
Well,
selling associate.
Maybe we should say listing associate and selling associate.
No,
Okay.
because the
There we
second
go.
they say selling associate, they say, oh, that means that seller's
Listing and selling
associate.
associate, that's
Oh,
like.
God, yes.
That's fine. I wanna know if we ever came up with that.
I think the
Listing and
consumers
selling.
are confused on selling and listing.
Yeah,
That,
they
as
are.
opposed to buyer and seller, I.
Don't limit that to consider.
On
We
broker,
got agents that don't understand.
That is
it
correct,
either.
she's
on
correct.
broker information page, if we're talking about being consistent, it says buyer's agent, seller's agent.
I think that's simple, straightforward, understandable. I really like that.
It's so rare that we wouldn't have a buyer's agent. So,
But if you don't, you just don't put anybody in there.
right,
So in that proposal.
well, I guess I meant.
If my name's in there, and that's only one, that's notice. But
Yes.
if there's two names in there and one comes to me, is that notice?
I would still be pretty clear to make sure that they got it.
Yes.
That
Yeah, I
falls into,
understand.
that falls into the argument that would be present even if it said courtesy, right? We started this, do we take courtesy in or
Yeah.
out? And so that argument's present, regardless here, so if we say copy too, I think it's more affirmative that they have to send it to both. But then you go into this all underlying law, whether notice to one is actually sufficient, and we can never say yes or no.
But I think that was the idea, to kind of have it over on the sidelines that doesn't make that agent be the one of notice.
Which
And
is
that
tough.
at least it seems to be putting that right back in it.
Yeah, well, again, I think of paragraph 21 has two pieces. One, notices must be in writing to be effective, period, stop, full stop. That's requirement number one. And then the second part does not say, and it will be effective only when given as follows. It says, and will be effective if. And so this is, the second part is permissive. It is a safe harbor. If you follow that rule, you have given notice. But you may give actual notice in some other fashion, right? I've terminated the contract. Well, you knew I terminated the contract. Gave you the notice. If I follow paragraph 21, there's no questions. I gave the notice because that's what the contract says. It creates a fact question if I give it some way other than paragraph 21. And that's the way I've always looked at it.
So I got the notice and my client did. So was
And
notice given to him,
notice
or I'm the one
notice
that,
to an agent is notice to the principal.
so it keeps the agent in the
It
loop.
creates the
One
argument.
reason we've said,
you know.
don't have them in there.
I mean, whenever I teach the class, I always say, guys, if it's important enough to give a notice, give it every which way you can and be sure you follow paragraph 21 exactly.
And if you.
But if you're wanting me to give you a legal decision as to, well, I didn't exactly follow it, is it effective? What
I think
maybe?
what he's asking is what if they only send it to the agent from the other side? You better damn well be sure your buyer or
That's
seller.
gonna
gets it.
make more money for Tony. Because there's gonna be a lawsuit.
So
So,
you'll notice
anyway.
that we have spent a lot of time on this.
Yes. So the language that we have in the minutes right now is with a copy to buyer's agent at : and with a copy to seller's agent at :
So let it be written.
So I believe we're sitting around consensus on that language. Are we okay to adopt that and move on?
Yes.
Yes, looks good.
Is there a city?
Okay, so I think we're at the end. We've already discussed the paragraph 22.
Fuel Brenner.
Yeah,
Bid
the
notice.
paragraph, but I couldn't remember.
Which we're going to leave in
Ramsey.
the contracts, correct? That's what we decided earlier, leaving the paragraph 22 PID checkbox. For now, subject to coming back to discuss the checkboxes.
Right.
There was a comment for adding paragraph 22, adding back in the non-realty item addendum, which disappeared a few years back for some reason.
Yeah, so I forgot how many years ago that was. It was before my time on the committee, which is almost 6 years now. But the reason behind that was lenders did not want them to see
Right,
that addendum. And so
they make us take it off.
they, now we don't have a checkbox for that reason.
They can
Yeah.
always put under other if the lender's not gonna freak out. Lenders did not like the non-realty, because the appraisal goes with that.
I understand that, but there has been a trend to that. It still is a TREC form. And if there's negotiations, you may have to start with that, only to be taken out by some lenders who request it to be removed. So
And
that presents a bit of a quandary.
It's always a part of the contract too, whether it's on the contract or not, right? So it's always, the practice now is to either list it in other or not list it at all, but still have it executed as well.
Does that create any problem with a license holder needing to use a TREC promulgated form?
Well, they
And
are,
it's there.
It's,
So if it's not supposed to be used, why is it still
well, they
there?
are using it. It's not being
I know,
listed.
many people do use it to get started with the negotiations and see if the lender cares, depending on what it is that's in non-realty item addendum. So again, if it's not supposed to be used, and I understand the reason, it's been that way for 20 years, but then why is the form not been pulled?
The point is it's being used, it's not being listed in the list of addenda, because the lender doesn't want to see it.
the lenders essentially
Right.
running to stick their head in the sand and not see the whole contract.
Well, a lot of the lake
That's
houses and
essentially
stuff
what
are
they're doing,
using,
they're
a lot of the lake houses are
That's
using
right.
bill of sales, they're not even using the non-realty item,
Items.
unless the appraisal is including all the furniture and the boat and, you know, everything included. But other than that, they've asked us to use bill of sales,
I see that.
separate from
I
the
see that
contract.
a lot, where they're
Bill of
trying
sale?
to use, just do a bill of sale instead of the.
It's aggravating.
I would suggest
I
that
like the bill of sale.
we've had in past meetings, and for today's purpose to move on, we can put that at the end too, we have more time to discuss, but that has been in several meetings in the past,
Yeah.
thoroughly discussed and gone over. So for the 1 to 4, that is the end of that. And so I think the next contract that we can go to is probably the farm and ranch.
I know this one pretty well. Tony and I know this one pretty well.
So who,
Seen the farm and ranch.
remind me, who was on the farm and ranch working group?
Tony, me, CJ,
SJ.
SJ.
What page is it, Madam Chair?
This is on page 199.
Well, I think, so
And Charles Porter helped at some point too.
Charles, yeah, so I guess so just not to split hairs here, but we're gonna go through things on the contract, but we had the working group update as a separate agenda item.
Correct.
So we'll wait and do that
I think we
later.
addressed that here as well. When we're on this contract, we can pull that up. And I'll leave it up to you if you want to address that when we go over these items or at the end.
Because I think our last meeting was kind of a different issue, so it may not, they don't think it's reflected on this contract. But go ahead.
That's how I read that. So I think if we take that at the end and we keep it
Yes.
grouped together. And Mr. Kestner, what we did to keep this meeting moving forward and for the public, we reviewed all the comments in advance of the meeting. We're summarizing it due to the 299 or almost 300 pages of comments. We're taking them in groups. And then at the end, we'll go through to make sure we didn't miss anything. But we've made an informal summary of the changes and comments so we can discuss them all together. And so starting with the. Thank you. So the farm and ranch, we had no comments on the addition of the counties, which was the first change in the property description, just to take into account that a property may be located in more than one county. And also, I don't believe we had any comments on the striking of the including but not limited to language. There was a comment I thought was in this one too, but it looks like it's in the condo contracts. Well, there's a legal description issued in condo contract we'll get to separately. We also did not have any comments on the addition of any houses, or I guess that's making it plural, houses and garages, and saying any instead of the. The cash portion of the sales price we've already discussed in terms of 3A. 3D though, there were, I think, some applause to this language. People generally did like the change, the acreage adjustment change. Texas Realtors had a comment on this that I believe was geared towards they would like to see it added as well to the unimproved property contract. Which that may be something we want to bring up now since it discusses or goes over the same thing. I personally think there's two competing arguments I see for that. One is a lot of the unimproved property lots are small, right? They're small city lots where they can also be used for large tracts. And by adding that acreage adjustment in there, does it create confusion when you're dealing with the suburban properties
Because the
versus
subdivision lot doesn't make much difference.
And so I think that was the reason we did not add it. But I would tee that up to see if anybody has any change of heart reading these comments, that would be something that'd be beneficial to have in the unimproved.
You know, that's the adjustment is recognized by those people that practice in the farm and ranch area. It's too confusing. I mean, I taught a class or gave a seminar a few weeks ago on these proposed changes, and this one agent said, "Oh, this farm and ranch change adjustment, that's just too confusing." And if you move it over to the unimproved contract, oh Lord.
Can a farm and ranch, this form be used for property without any improvements?
Yes,
Yes,
yes.
Okay, so,
and it's not limited to the 10 acres or whatever, they
Yeah.
can use it whenever.
I would do.
yeah, so you can choose to, you know.
But that's what people are looking at, because unimproved, they're thinking if it's less than 10 acres, I have to use that one
Mhm.
versus the farm and ranch, and that's not a
Well,
true
and I think that
concept.
10-acre rule goes, it's different for mortgage market.
And Robin, if you'd like to address this on behalf of.
Yeah, no, thank you. So Texas Realtors did convene a farm and ranch task force to look at both the changes that were being proposed by this committee and some of our own documents. This specific recommendation came from that task force. A lot of those land brokers use both contracts, farm and ranch and the unimproved contracts. They really like the changes that are being made in the farm and ranch contract. They think that the unimproved property contract could benefit from those changes. That was the comment that came out.
So I think we all generally see how it can be used, be beneficial to large tracts, but I think with the confusion created, especially for the agents that aren't trained on it, and for, in the urban areas, it's used for these unimproved lots, that it can create more issues than it would help there.
So they're proposing just to put D, that's in farm and ranch, as a D in unimproved.
Correct.
Probably on a per square foot basis, as I'm guessing.
I think we probably have as many residential realtors using the unimproved form for basically builder lots as we have farm and ranch members using it for their purposes where they would need this.
I agree. Residential uses it for, oh, there's no house on it, then I gotta go with that form.
Yeah, exactly.
And there's,
5, 10 acres, 1 acre, half acre, oh, there's no house.
Well, my favorite, the house has no value. The house is there, but it's a tear down, so unimproved.
And the proof in the
So we
pudding,
don't,
I
we
mean,
don't
look,
get so strong.
unimproved property contract, the property is described as lot blank, block blank.
Yeah.
so it's platted out,
Yeah.
yeah.
Whereas the land in the farm and ranch doesn't say lot.
Yeah, I think it would confuse agents.
Okay.
And I did not see any comments that disliked the change to that portion of the sales price or the sales price adjustment. So I think that was well received by all. The next change was to surface leases. And there were a few comments received on this in terms of they would like to see the two surface lease sections combined. Because the surface lease now, as we've added to paragraph 4, is also contained later on in F, this is 6F. In 6F, the listing of surface leases is in terms of permitted exceptions on the title commitment and policy. It is something that the buyer cannot object to. Because if there's a surface lease that's picked up on the title commitment, if that language isn't in there, then the buyer can make an objection to it and have it removed. And here is allowing the parties to state that up front, that there is a surface lease there, and it will not be a buyer or an objection the buyer is permitted to make on the policy. So that's the reason it's in two different places. And the comments were, well, that's confusing, why don't you just combine it into one? And I'm not sure those comments appreciated the reason why it's in section 6. With section 6, of course, or paragraph 6 deals with title policy and survey.
Right.
Um,
It's totally separate.
I
But,
think we have.
and
And we had thorough discussions about this.
Yes.
When we put it in, so I think it's just, like you said, a matter of not understanding one.
I don't believe anybody had any issues with the surface lease language itself as we drafted it.
Okay, so let's say I disclose a surface lease in 4D, but then I don't put it in 6F. That's what's gonna happen. They screw up, they put it one place, they don't put it in the other.
And I think that's being diligent in knowing the contracts.
Well,
I'm not sure if that's,
I mean, I guess.
obviously it hasn't presented itself, so we don't have it out there, but.
The question is, I mean, I think it's legitimate if you combine the two, you make it a little bit more dummy proof.
Amy.
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 I have another question too, related to that.
Sure.
So considering that too, why are we limiting surface leases in terms of permitted exceptions? We have natural resource leases that would be exceptions generally. Assuming any other type of lease, fixture lease, could be argued to be a surface lease as well. Why don't we just say the following leases will be permitted exceptions?
Or how about if F, we just reword it to say, any leases identified in paragraph 4 are permitted exceptions.
Title of leases.
I don't know enough, if you don't have a copy of the leases yet and they're to be delivered, I don't know if.
Well, we give
a
a termination right to the buyer.
Yeah, but I may not necessarily have an issue with termination as much as just a title objection.
The one thing we have in the residential leases or fixture leases is an obligation to have it terminated before closing. The language we have drafted right now for surface leases does not have any requirement or negotiable requirement for the termination of the surface lease. And here in F, we're almost creating that term, has that termination right by objecting to it and making the buyer or seller remove it.
Yeah. So paragraph 4 says, except as disclosed in the contract, seller is not aware of any leases. And then it goes on to describe what leases the seller does know about. And once the seller has disclosed those to the buyer, those should be permitted exceptions. It's still, we still are keeping buyers having the right to terminate if they've not yet seen the lease.
Yeah, he's gonna need time to look at it, right?
Right. But we have that built into the residential leases, fixture leases, natural resource leases, and surface leases, A, B, C, and D. So if we do that, then why don't we just have F be very simple? Any leases identified in paragraph D will be permitted exceptions in the title policy and will not be a basis for objection to the title, period.
So that paragraph F was there originally because we didn't really address
Exactly.
surface leases to begin with. And now that we have added a provision for providing those,
Exactly.
do we even need F at all?
Well, yes, because then you'd have to renumber G.
Well,
And there is that concept of permitted exceptions.
sure. Of course, you've got paragraph E above it where you can provide exception documents in general that you know are going to be permitted exceptions and you can't object.
One thing that makes me feel comfortable when I'm thinking about this with Brian's suggestion is that we do have a termination right after the buyer receives the leases. They don't have them up front to review. They have the opportunity to review them and can terminate the contract within a certain time period. So if we make it the affirmative, like Brian's suggesting of you cannot, these will be permitted exceptions and not have to separately list them, it still preserves the buyer's right to review it in advance. It would streamline that part of it. So I do
your
like
buyer
that
just
thought.
needs to review the leases. If the seller hands you the contract, here's my offer and here's copies of all my leases, then the buyer just needs to make sure they review all of their leases and make sure they're okay with all of them.
Sure.
Because by default, under that provision, there's no opportunity to object later.
You know what you're
So-
getting.
I'm sorry, where does it say they can withdraw if they haven't gotten the lease?
Then I guess, I hope all the buyers have not signed the contract yet.
Yeah, exactly, that's gonna be
Good
a,
with that.
Oh, okay, good.
And then
Especially if
we
the
have
buyer
that built
offered.
into all those other
Gave you
addendums.
the original.
Oh, okay.
now the exception I would make that would be the
Sorry.
rural leases there.
Oh, and also C2.
So, I
Yeah.
don't know how you would handle those.
So it'd be
Okay.
B2 and the,
I think you have to accept out oral
Thank you.
leases, if you're gonna do that.
with an oral lease, then there'll be an encumbrance. It's not filed, so it would show up in the title commitment.
Well, it's always have, rights of persons.
Part of the possession.
So, I would say, I'm okay either way. I just wanna make sure we feel like they have enough time to review the leases and to terminate. But I guess they just have to negotiate a 7-day, 10-day period to get it to their attorneys and take a look at it.
If the buyer sends over the offer and seller says, wait a minute, there's an oral lease, I have to put it here. And then they fill that section in and send it back, it's the counter offer at that point. So then they would have that opportunity.
Right.
Presumably at that
If we
point.
go under contract, 3 days later, they give me copies of everything. I've got to make sure I've got 7 to 10 days inserted in there. And then I've got to figure out, do I terminate or do I want to do something different?
And it's, the counting is after the date the buyer receives
Correct.
the lease,
So
not from the.
I'm okay with it. It's going to be a,
Okay, so you want to put
Isn't the second place where?
Paragraph
we
F.
under the title section?
up,
And one, would you want to remove?
just have something to look at.
Well, Brian's suggestion is not to remove it, but to make it affirmative, that the lease is disclosed
Okay,
in
right.
the, for the will be permitted
That
exceptions.
works for me.
In paragraph 4.
I can't.
In paragraph 4, yes, all.
So then paragraph F would just be,
Leases identified in paragraph 4 will be permitted exceptions in the title policy and will not be a basis for objection to title.
And no blank.
No blank. And they will thank us because we eliminated a blank.
I am grateful.
And to look this through, since that's a little bit, not a sea change, but a substantive change, do we need to change anything in 6D relating to objections? We start off by may object in writing to,
Well, but we have the tagline and will not be a basis for objection.
okay, so what do you want to,
So paragraph F,
you want it to read?
have it read, leases described in paragraph 4,
Well, now, we need to actually mean provided to, right?
no,
To
lease,
the buyer.
There's a
Leases
separate,
provided to the buyer.
leases identified in paragraph 4.
Well,
Because they may not be provided,
can you just,
but your protection as a buyer is you have the right to terminate.
once they're provided.
So the,
so once you get them, you can still terminate the contract.
So leases
Because the big thing is
identified in,
world.
just put this up and we can talk about it.
leases identified in paragraph 4.
Leases identified in paragraph, where,
I'll get it.
oh, okay.
Go ahead.
Leases identified in paragraph 4 will be permitted exceptions in the title policy and will not be a basis for objection to title.
Which mirrors the language of 6E at the bottom.
Basis for objection and
for objection to title.
Yeah, will not be a basis for objection.
But I guess you have to It's gonna be F leases, colon.
And if you go up to just 6E, that same language is in 6E, just above there.
No backup, talk from the side.
Switch over.
Quite amazed. I'm quite amazed at his abilities.
Okay.
I'm not.
I'm glad I don't have to serve when he's, I'm glad I don't have to serve when he's not here.
That is on the paragraph.
We're never letting it go.
So I come off the same year he does, I just figured that out.
And I even said that to one of our colleagues.
Well, what I'm saying is, let's say you have a natural resource lease. So in C2, the seller does not deliver
Mhm.
the natural resource, he's a party. So there's no concern there, he doesn't deliver it. So I'm thinking I don't terminate, because there is none. And then I get the title policy and lo and behold, I will object. So I had to have received it to be able to preserve my right to object. I mean, to eliminate my right to object. So shouldn't we say leases buyer receives in paragraph 4, or pursuant to paragraph 4?
Doesn't the seller preserve their ability to terminate?
If the seller does, are you saying, what if the seller checks the box, but they never give them a copy of the lease?
Yeah, so let's
Then
say,
the seller's in default.
I know, but let's say I don't
Terminate
object.
for your
But
default.
let's say I don't terminate. Shouldn't I have the right to,
Object.
right? I hadn't seen it. I don't mind
But if
going
you-
forward. I just need to see the lease. But
Would
now
be a
I'm,
title objection normally. What you're saying is because you haven't,
I haven't gotten it.
we don't
right?
want to eliminate the right to, we don't want to call it a permitted exception if we haven't seen it.
But you have the leverage anyway.
It's permitted, yeah, you have the right to terminate.
Yeah,
He
but-
doesn't get, by the way, the wording would be leases identified in paragraph 4.
I hear what you're saying.
I mean, I know what you're saying, but I think what happens if you never get the lease? Well, then the seller's in default.
And you have the leverage of the ability to terminate to compel it.
Yeah.
If the seller checks that
Or sue.
they have delivered, they truly haven't delivered all the natural resources.
And I'll cure that fault, here's the lease. Okay, now I have my window to terminate.
In which case, if they didn't check the box and didn't tell you that they had one, and it showed up on a title commitment later, that's not gonna be a permitted exception because it's not a lease identified in 4 because you didn't check the box.
The first sentence of 4 is except as disclosed in this contract, seller's not aware of any
Let me ask
lease.
this question. Maybe I'm just being overly concerned about giving up a right to object for a lease that I don't get to see for some reason or another. Do you have a problem with that language, limiting it to the ones we actually receive? Because all we're giving up is a right to object on the basis of title. I might be overly concerned about the issue,
What about
but
the
I think we're reaching the same point.
Oh, so you're saying, okay, so you have, it should be, take out the first receives, leases buyer receives pursuant to paragraph
Yeah,
4.
or I'm at a D, but a bit more.
Do you receive an oral lease?
Well, that's what I'm saying is that,
That's what I was just gonna say, because you're not receiving an oral. Unless they write a note, I have an oral lease with Joe Bob. And so much,
Which is exactly how that happens.
so I guess you would receive something, because it actually would have to be some kind of statement.
So 4
Oh, can we
says
just
except
agree
as
to no more
disclosed.
You know.
oral leases?
What if you say
Written
it's
leases buyer, and oral lease is identified in paragraph 4.
Yeah, you'd have to put something about
well,
oral
I don't
leases.
think you want to give up anything referred to oral leases. Right?
Why?
Well, because all you're doing is you're getting a simple description of what happens later if you find out something about that oral lease according to
Well,
the tenant.
in paragraph,
So I think oral leases just needs to come out of that.
so if you check the box, then let's go to 4D. 4D2, I've checked the box, I've gotten an oral lease, and I've described the name of the tenant, the rental amount, and the term.
That's it.
And as the buyer, I still have the right to object?
Well,
I would
I
think-
want to be able to object if I later find out
Because
the
it's in the
tenant.
contract.
Well, if the tenant has a different view of what that oral lease is.
Well, and unlike the residential lease addendum we have that says if any of these statements turns out to be untrue, then the buyer has another objection right, or if it changes during the pendency of it, it preserves an objection right to the contract. And here in surface leases, we don't have that ability. There's not that built-in protection for the buyer, right, like there is in the residential lease addendum. So I see your concern there.
I may be overly worried about it, but I'm just saying, it seems to me if I'm going to give up a right to object to title, I should have gotten a copy of the lease. And if I hadn't gotten a copy, then I still have the right to object and I have the right to terminate. What's the difference if I have the right to terminate? Why should I have the right to object?
Stay quiet on this side of the table. Any thoughts on?
Well, we're letting y'all hash out the legalities.
Okay.
They're having
Tell you why
that
you're wrong.
post-lunch.
That's it. I mean, this is a tough one.
Well, I mean,
I think if we're going to go this far, if we're actually going to take a right of the buyer away to object, I'd rather make sure he got copies of the leases. That's all I'm saying.
Let me throw this back out there again. The language we have right now, you have to list which leases will be permitted exceptions. And so it avoids the trap of,
Did you
what
get
we're
'em or
talking
not?
about here. And then they can list them. If not, I mean, the seller should be diligent in listing everything there. But, if they're not, who should the burden fall on? By changing this up, we're shifting the burden more towards the buyer than on the seller that we have right now.
I said, I'll say
Burden's
two
just on the
things.
seller.
I like what we wrote.
About written
It makes
leases?
it more- I mean, I'm fine with what we proposed. But I would say, as far as what, this problem we're fixing, has there been a problem? I mean, are we seeing a lot of lawsuits over this, or are the title companies having a struggle with these issues?
The issue is no one is disclosing it. And the whole idea of putting it in here is to get people to start thinking about it, sellers start talking about it, because it has been a problem where they go into it and like, oh, I didn't know this, I didn't know that. But SJ's practice and mine has seen where they just don't bring it up.
Well, in the center background where our comments started and where we got on this was a few people saying, why don't you combine the two? Now, they didn't say change it.
Yeah.
They said, why don't we combine them into the same section? And it is a shift in burden here, that if we went to some language like this, would be shifting this to the buyer. And I think with the leases, to me, as I'm thinking through this and whiteboarding in my head, it should be the seller's burden to put in here to specifically list. They're the ones that know about it. And if they're concerned about it being a permitted exception or not, make them list it.
Aren't
Instead of
they
taking-
listing it in section 4?
Hey,
It's
Ron,
not,
the
they're
second,
listing it to disclose
option-
it, but they're not listing
I
it
don't
to
think
say
we-
you can't object to
if
it.
we're arguing over two, it shouldn't be written leases.
There's
It
two
should be
different
leases. If the lease
Which
is
is why I don't
disclosed,
think we need to combine them, because it's just two different.
and that would include oral leases where you properly give the tenant rent term.
I would propose that we take a straw poll to see if we want to make a change to begin with, before we spend more time hashing out what the change would be. Right? 'Cause
Specifically to what provision?
So specific to changing up the
Paragraph F.
paragraph
Yeah,
F, in
combining
combining it into 4, or just changing it up at all. So,
And the reason we would want it to combine them is that we run the risk of you identify something in paragraph 4 and then you don't list it in 6F, and then there's confusion. And the benefit of combining the two would be that if you list everything in 4, you've eliminated a blank in 6F. You don't need to worry about filling in 6F.
So would you move you're talking about putting the verbiage in 6F into 4?
No, we'll keep this in F, but there's no blank to fill in anymore.
Oh,
Because by saying,
We really have two different things here. One is whether they're combined, and if they're combined, or even if they're not combined, do we change up the language that's in 6F? And so I think we first have to make a decision. We gotta take step by step. Maybe the first one is, do we want to change the 6F language up, right? And then we can talk about combining. Because this is the drastic change in terms of buyer or seller having the burden. And Brian's point is, if it's identified here, let's make it more streamlined. Let's, have them saying if it's identified, it's not a basis for objection, because the buyer will have a copy of everything. If they don't, they have some other termination right. So let's not.
And keep in mind, paragraph 4 is description of leases. Paragraph 6 is title and survey. And this specifically is addressing the title issue. That's why it belongs in both.
And so whether we combine them or keep them separate, it's a wholly separate issue than changing this language up in light of the new language that we have. And so we can take this in either order, but I think makes sense to me to take it in the order of, do we want to change the language of 6F up, whether it's combined or not, to shift the burden on from buyer and seller. So take a poll, those who are in favor of switching it into some form of, not necessarily this language, but some form of this language. Raise your hand.
and we think shifting will put it on the buyer now.
Shifting would put it onto the buyer, correct? So 1, 2, 3, 4. Okay, those who think that should stay the same, raise your hand. 2, 3, 4, 5.
And by the same, you mean
Six.
filling in the blank.
Filling in the blank,
Yeah.
correct.
So is that 6?
And the,
I think it's,
in my.
let's say it one more time, raise your hand if you don't want to change it. 1, 2,
Don't rub it
3,
in.
4, 6. All right, so 6 and 4, I think that's something that we keep for further discussion and to see how this is, because I do see your point, Brian, on that. But to keep this moving, we'll put that for further discussion.
Do we need to
So
say, should F be surface leases or just leases?
We had this discussion before.
It was
we
surface
have.
leases before, I guess.
Yeah, but I think because it was, well, that's how it.
Yeah.
That paragraph was for that purpose before.
Yeah. Keep it.
And then, so the second thing is, do we combine the two? And the argument for combining it is to put it together to make it less confusing, less likely to be missed.
No.
Or do we keep it separate, because in the separate section, one is title notices and title objections and title policy, where the other one is identifying and disclosing.
Choice.
Keep it as it is.
Keep it as it is.
Keep it as it is.
Yes.
Okay. I have one last question on that you haven't taken a poll on.
Okay,
Should the word surface come out of there?
in 6F,
Just talks about leases rather than surface leases.
Because you don't
Yeah,
have
'cause
natural
paragraph 4
resources.
is leases.
Yeah. So I guess it's all right if you want to talk about only surface leases, because then you can still object to natural resource leases.
F was originally,
Yeah. it was
Surface
originally
leases,
for
right?
surface leases.
Yes.
So if we leave it alone, then we can still object to oil and gas leases.
there's nothing that prevents
Unless
that
it-
objection in the contract.
Unless they put it under exception.
Okay, that's fine, I'm okay with that.
Yeah.
All right. Okay, so that was a long way of saying we're not gonna do anything with this.
Yeah.
That's right. Well, we'll
It's
make
not
a side
gonna
note
hurt
for
on that
further
happening.
thought on.
Just as if it makes you feel any better, my rationalization here. I mean, for those who do farm and ranch work, they're used to be pulling the things that they know that they don't want people to object to in title. Right, I mean, they're used to putting their exception documents if there's an oil and gas lease or whatever they're gonna put there. And same on the surface lease, so it's not out of, this is what they're normally used to doing. So that was another concern of mine of switching it, because now because you have switched that burden, it's completely different.
they're gonna
than
start
what-
thinking differently.
Anyway, that's just for what it's
So moving on to the next change, we've already discussed the changes in paragraph 5. Also in paragraph 6D, in terms of capitalizing survey, for taking the capitalization out. We just went over the change to 6F. We've discussed the required notice section in 6G. We've discussed the language of completion of repairs in 7E, and the seller's disclosures in 7H.
Service.
For transfer warranties, residential service, special provisions, the releasing of earnest money, the prorations.
I think they're all the same now.
That's all the same until we get to the condo contract. But now let's see if we can bring up the working group. No, I didn't.
Stop it, stop it.
For the record, we did not. Okay, so who would like to speak on behalf of the working group in the conversation?
I can do that.
What page did these appear on?
So this is on, and I pulled up my separate one, so I don't know the page number.
It's on page 10.
There's an agenda item at the back.
It's page 232.
232.
Not yet, we're working through the contract forms, and then we'll come to the amendment agenda at the end.
So the last issue that we looked at, that you all asked us to look at, or that we volunteered to look at, I'm not really sure exactly how that happened, but anyway, had to do with a concern that had been raised about rollback taxes, and how the farm and ranch contract prorates, or assesses the responsibility for the rollback taxes. And so this particular issue, the contract addresses the issue of rollback taxes being the responsibility of the one who changes the use. But this particular issue that they were raising is apparently there's at least one county, maybe more than one, that is doing what they're calling a supplemental market adjustment, where they are assessing your rollbacks are for the 3 prior years, but then you've got the tax year that the closing occurs in. The rollbacks are only for the 3 prior years, but you've got the current year that the closing occurs in, where now the change in use.
They just reassess.
They've reassessed. And so apparently there's been some issues with that being sent, who it's being sent to and who's responsible for it and so forth and so on. And so we had this kind of fairly long discussion about whether the contract provisions address it adequately, or do we need to add something specifically to address it?
That was Collin County.
Collin County, thank you. And I think the way we left it is we were gonna kind of do a little bit more research before suggesting changes to that paragraph, because I think we felt like the paragraph actually kind of addressed it itself, and didn't really require additional language. But we were gonna kind of do a little bit more digging, and I don't know, Charles, weren't you gonna talk to somebody about that?
Yeah, I had, right now, there's no definition of supplemental market adjustment in the Texas Comptroller or any of their manuals. I'm trying to figure out if they're gonna define it. The only thing I can find is that Tax Code 31, it talks about a supplemental market adjustment after an appeal. So what Collin County's doing doesn't make any sense. I went to their website, they don't define it either. And so that's where we are.
So we hate to make a language change when there's no.
Right, so we
basis out
kind
there.
of, yeah, so we decided to punt on whether we needed to change anything in the contract. One thing that was brought up about, so there is actually a notice that is required regarding liability for additional taxes under Property Code 5.010. It doesn't apply though if your contract addresses the responsibility for rollback taxes. So I think that's why we don't have this notice in our contract. But it is a property code required notice if you don't address the rollbacks. So I think we're fine to not add it, but I just wondered not to add more notices if we don't have to, but in our little title notice paragraph, is it prudent to go ahead and have that in there? And it may just be that it was not put in originally because we were addressing it and therefore there's no need to have it. But at the point being that if you had the notice in there, it would also remind people that that is an issue in addition to this section, in the proration section. That would be an additional, reminder that you need to negotiate or to talk about it. So that's basically, did I miss anything?
So, that's all good information, and so for now, it's more review of the provision and maybe future suggestions on the minutes.
I think I would say, and just my thought, I'm not speaking for the whole working group, but I don't think there's any need to change anything right now. And I think let's see if anybody else besides Collin County starts doing it, or if it becomes a bigger issue, or if we find out more, we can bring it back up. But I don't think I would suggest any change at this time.
So has anybody looked to see if the tax code allows them to do? Because I thought it was January 1st,
Yeah, we
Not
looked.
October, or whenever you decide you want to supplementally revise the value for the whole year.
Right, yeah. It's not, when you look at the code, it's not,
It's
I don't know
not
how they're
clear.
doing what they're doing, but.
So maybe I do have the code right in the brain. They're going rogue. I don't know.
So
I want to know more.
I think we'll just my thought would be just, we know it's a potential issue. If we hear more about it, maybe think about it some more.
Blake Bennett and I will get it cleared up with the comptroller. Just have to still, they're still short staffed. If I feel a Hager, I'll ask him, but he won't know. But it's not fun, it's amazing.
Well, thank you for your work, Charles, and committee on that. So we'll move on next to the next contract, the condo contract. The first change in the condo contract was to add as described on exhibit. And there were several comments on this of essentially being out of place. And questioning, and to be quite truthful, when I read it, with it redlined here, I thought it was a little confusing where it's at as well. And if you read that sentence, it's kind of thrown in at the end of, do you have to attach as the exhibit? I think the intent was to give more space, right, for the property description. Somebody correct me if I'm misremembering there, but what we have here is created is almost an obligation to attach an exhibit to further the description of the unit. Did anybody else find that confusing or take those comments?
Well,
You could say
my guess
is
is, like on 1 to 4 family, in paragraph 1, we have, or as described on attached exhibit. Is that what we meant to say? Or as described on attached exhibit?
Just need an or.
Yeah.
Mhm. I would like that, 'cause it doesn't.
Have an or. Yeah.
Or as described on attached exhibit.
Well,
Okay,
I'm confused though. I mean, I can understand, would you want as described on, or as described on attached exhibit to follow the common elements? All of you drop it right down there before parking.
But
Because, I mean.
Quite frankly, a condominium does not exist but for the way it is described in the declaration. So I can't think of a situation where you would have a condominium. Or are we thinking about those horizontal condos to be built, the commercial office building condos? Maybe that was what this suggestion was. Because sometimes people are getting into creating a condominium regime for an office park. And
Yeah,
they
this is
actually
a
describe individual lots.
Yeah, but this is a residential.
Oh, you're right.
And so I would say, so just take it out.
Okay.
That's where I was going to. I think even if we had or as described, it's really not fitting in that sentence if you read the whole thing again.
And we did put up at the top that this is owner's simple title land, that they own the land, right? Title to land is not used for,
Not
if
for,
they own the
not
land,
correct.
yeah, not used if they own the land.
Does everybody, I believe in favor?
I mean, I don't know what the problem was in the first place, why that change was suggested.
So moving on to the next one, we had a few comments to our changes to 2B2. Most in favor, I believe, saying that they're glad we got rid of the CMRR notice, the certified notice requirement. And what we did here is make it in addition to what's in the statute. So the statute requires a certain type of notice. The termination right we're giving to the parties in here, we expanded on to say, well, it can be given in the same way as allowed in this contract. So we're not doing away with the property code termination right. What we're doing is giving an additional right to terminate under the terms of this contract.
They overlap.
And I think we were generally applauded for doing that. I don't think anybody had any comments on it being confusing or any to change anything there. Let's see, and C, the same change. We've already talked about the sales price in terms of cash.
Can we go over it again? Sorry.
We will at some point. Guarantee you that, yes.
Next
And
5 meetings.
for those of us who teach, we'll be going over this a lot. Escrow agent definition or capitalization we've talked about. The required notices in paragraph 6 we talked about. Completion of treatments we talked about. Our residential service companies, private transfer fees, special provisions.
I have a comment before we get too far.
Sure.
So I know it wasn't on our original deal, but it's something I've recently learned. 9, closing, B, at closing, sellers shall execute and deliver a general warranty deed conveying title. Seems to be constant throughout our contracts. You title guys may be aware of this, but about half the condos out there are non-warrantable.
That doesn't deal with title.
That doesn't do a title at all? That you can't get a warranty deed?
No, you can give a warranty deed. The condominiums are units of real property under the Condominium Act that are identified, and as a matter of law, they constitute transferable property.
Sure.
So you can give a general warranty deed. Yes.
I
think not warrantable.
The one I just bought in Bronzeville, they wouldn't do a general warranty deed.
What you did? Was it new construction?
Built in 1982.
Was it special?
What was the reason for it? Like,
They said, I thought, I don't do a lot of what y'all do, they just said it wasn't warrantable, so therefore they don't give a general warranty deed. They gave it a special.
Well, special is still warranting title, it's just buying through and under you.
Okay, okay, I just didn't know if that
General goes back to
matched.
the time.
They
yeah.
just didn't want to.
They got one by you on that one.
But, you know, you got a title policy. You
That's ultimately
know who benefits the most at getting a general versus a special warranty deed? The title company.
Let's keep it in.
So we discussed the transfer of warranties, private transfer fees, special provisions, prorations.
Question on prorations.
Yes.
So
We made a
do we
change.
want to make the conforming change?
Yes.
Yes.
That we
Yes.
made in the HOA addendum
Correct.
here,
Yes.
right?
Correct.
So,
And we previously removed regular condominium assessments. There weren't any comments on that, but that's the one language we struck out, so it should be consistent across the contracts.
okay, we'll just break that over.
Same changes.
Then, of course, the prorations paragraph in the condominium has condominium-specific language. So when we make those corresponding changes to paragraph 13, it's changing the language we changed, not completely replacing the paragraph.
Bless you.
And I have
Okay, now, hold on. Paragraph 12A, 3.
I knew he was gonna go there.
Well, that's what we're gonna
That's
do,
what-
is we're gonna bring that over from.
We're gonna bring that over as well.
Well, it's
That's in
similar.
addition, paragraph 12A3 and 13 have to be consistent.
Yes.
What
With
do
what
we
we're doing
want?
with the HOA addendum.
Do we wanna look at, the language specifically here, or just let staff bring over the just change for the condo form? So I have the language there that's in the addendum. So,
Pay any excess. This paragraph does not apply to, you'd include 1, but what about 2?
2 doesn't really apply, does it? Unless, or it should be something separate. Where do we?
It would be the payments that you have,
Those would be something.
paragraph 2? No, wait a second.
Here's the resale certificate. It's, paragraph 2C is 2C2, 2C is one of them.
And B2 is the documents.
Okay, so paragraph A is the payment of the resale certificate.
so that would be paragraph 2 of the condo form, right?
Yeah.
And D was the situation where the buyer says, I don't need a resale certificate, but but the title company says, well, we need to get the title insurance.
Well, yeah, you could just say, you said paragraph 2 and that covers it. If you say paragraph 2, that covers both those sections.
Agree.
Because I don't think there's anything else in paragraph 2 that's a problem.
When we go through the comments at the end to make sure we didn't miss anything, there was one good comment of a reference in one of our contracts that was incorrect. And I believe it's in the condo contract, but I have it in my notes to go through. So we'll pick that up when we do that at the end. And I think that's the,
Before we move on, did we end up adding a sentence on 95 and the 1 to 4 that we might need to tweak for the condo contract?
Where was it again?
9B5.
I can't remember if we did it or not, but I think there was discussion about adding a clarifying sentence on 95 and 1 to 4 in reference to the HOA addendum.
Yes.
So we
yeah.
need to
Same.
word it differently.
Yeah,
Good.
add that clarification.
I think it would be the same. Are there transfer fees on a condo?
I just mean you won't have
There
that
can be.
HOA addendum.
Apparently there can be.
Oh, okay, no HOA addendum.
Let's see what language we,
I'm just wondering if they're private. Transfer. fees.
oh, very good catch.
I will think there can be. The private transfer fees on the.
So will it be the same?
I know
It won't be
Yeah.
exactly the same because it'd be,
Private transfer fees or even on condos.
there's not an addendum for property subject to landlord ownership.
Wait a second. Should we even have that?
Well, you just, I mean, if you want to, you can just simply say transfer fees assessed by the association or government. Or this paragraph does not apply to.
That's what I'm
that
wondering.
language. Would that be
I don't
better?
think you need it at all.
Yes,
Do we need it?
I don't think you do in the condo.
I don't think you need it.
So are we sure there's no private transfer?
Well, wait a second, this is not talking about private transfer fees.
This
Well,
is,
we talking
Yeah,
about-
this
it's
is,
added at the end of 9-5.
we're talking
I
about
thought we were
this,
looking at 9.
this addition here in the 1 to 4, which is also in
Oh,
the
oh.
condo.
Yeah.
And we added that qualifying language.
Wait a second, transfer fees assessed by a property association.
Oh.
No, wait.
This is saying that is clarifying the transfer fee section.
With everybody's confusion, thinking that it
And this is
applies to
saying-
POA transfer
My
fees.
point, yeah.
Do we want it there?
Okay,
Where
so,
are
hold
we?
on, we're looking at B,
We're
right?
in 9B right now.
9B5 of what? Which
Of the
one?
condo contract.
What if we just added that if you want a clarification? We added that last sentence 9B5 as a clarification.
Yeah,
People were concerned.
it doesn't replace, but it's on page 216.
Do we need that in the condo?
I don't think we do. I don't think
It's
there's
on
private
page
transfer fees on
216
the condo.
here.
Maybe I'm wrong.
I would be uncomfortable saying that there's not one anywhere. But if we put it in, then we need to know if there is, otherwise why did we put it in?
Well, apparently there are private transfer fees on some condos.
How do we know? Do you know that for a fact?
No, they're not assessed by the condo. They're
No,
collected.
no, I know what you're saying, but they exist.
You can have a private transfer fee applicable to a condo.
That's my source.
Well, that would be going forward. Are there any
But-
existing ones? that
Well, if going
even-
forward, they'd be void. So
Right,
they
right.
have-
So if it
I don't think
hasn't,
there's any way for us to know if there are any existing. Because
No.
we've got 254 counties.
we don't, but why would we even bring it up if it doesn't apply to 5% or more?
I don't know if we need it. Do y'all want this?
No.
I if we're gonna have the phrase, I mean,
We've added 5 in.
Yeah.
The 9B5 is,
it needs clarification or it needs to be eliminated. And I don't know, eliminating is a good idea if there's a chance that we don't really know how many, if any.
But are we putting it in just because we're putting it in the same place in all the contracts? And what if it doesn't apply?
Well, then it'll just be an item that doesn't apply.
It's confusing.
Well, not if we clarify.
yeah, the same
So
clarification.
what is the clarification being
This,
added to?
this
every
paragraph
contract?
does not, sorry. This paragraph does not apply to fees assessed by the association.
Yeah, association is fine.
You may got a property code handy to read that and see if it
I'm pulling it up on my
excludes
phone right now.
It says it's all in real property. It can be applied to real property. Google's not answering.
After Google failed.
They failed.
Ask Google if there's
For
private
purposes
transfer
of
fees
this
in Texas.
subchapter, the following payments are
Where you
not
finish the sentence,
considered
I'll answer.
private transfer fees.
No, we insure real property at
But
a
we
title
haven't had
company
it
level,
before,
so why wouldn't a
I
condo be
question why
considered
we
real
need
property?
to add it now.
Oh, it is.
That's what I thought.
I think it
So
does
it's
have
applied
to
to
do
real
with
property.
consistency.
The question is it
Don't you
on?
think there's a whole?
But what we're talking about here,
I don't know.
remember, private transfer fees are,
Now we've raised
whether,
the condo.
Whether these.
You wanna go to the
It's
statute?
already there, we're just clarifying.
No,
All we're doing is
Look,
adding
go to-
clarification.
go
It's
to-
not like we're.
Yeah, it
Property
wasn't
yeah,
there.
hold on one second, too many conversations. So, Ron?
I said, all we were doing originally in the single family one was just adding a clarification. So that's all this is.
So the paragraph was there and we added one sentence.
We had one sentence just to clarify because people were confused. What is the transfer fee? So we're saying it's not an association fee. That's all we did. We can do the same here or not. It doesn't really matter.
But private transfer fees isn't under the title notices. Is it under the title notices on the
No, it's in 95.
Right, so
Well,
it's not, what I'm just saying is
if
it's
you want
not
to go to,
under the title notice,
5.202.
like it is in the residential.
No, but the residential is in 9B5 as well,
It's just a
Yeah, but
close,
95 is not here.
9B5.
how closing costs are paid, what fees are assessed.
Does that catch it?
Records of an association.
Oh, I know, but what I'm saying, under title notices,
Yep, I think,
It's not
but
there.
It's
having
not there.
that, there
It
are
is.
also,
That is not a private transfer fee under subchapter G.
right, which is, this is what we're clarifying here, right? To add the same clarification sentence we did to,
oh, I like it.
to the 1 to 4.
Thank you, Abby.
Because it doesn't apply to the POA transfer fees either, but because of the confusion that was created with the language, nobody's really familiar with private transfer fees as a general matter. It created that confusion, so if we leave in the language we have in 9B5, I do fully agree we need to add this kind of qualification, which Brian just looked up the statute here, and they are not private transfer fees, any association transfer
Although it
fees.
doesn't mention condos.
It doesn't deal with condos, right? It should be private transfer fees, if they were tagged on the condos, should tag on, arguably be enforceable. That's
So are we saying that it does not apply to condominiums?
It's the opposite.
No.
No, it applies, wait,
It
no,
does.
It does.
So we should clarify that
it
it's
doesn't
not
apply.
HOA fees,
it
right?
doesn't.
Yeah, that's the biggest thing, is we're just clarifying it's
I
not
think
HOA.
it's we have 95 as proposed with the clarifying sentence about the POAs.
Yes.
No
There you go.
HOA.
Did you hear that?
Second.
Yes, second, third.
Yes. Association.
I like it.
82.
We can look at the consent.
So that's an accurate statement there, that it does not apply to fees assessed by the association.
Yes.
Is there any last minute comments on this before we move on?
Research.
Okay, so this is merely doing the same clarification with condominium specific language in 9B5.
County clerk's office, I guess.
Before we move on from the condo contract, I don't believe there's any other changes we haven't already discussed or need to make special for the condo contract.
If you're making all the same ones, like you're putting the agent instead of courtesy copy.
Right.
Correct.
Condos, we need courtesy copies.
On that note, so let's see.
Getting charged. I just didn't know private. I mean, on the whole building, I get, you're selling the building, but I didn't know if it was on that.
So, the next we can pull up is the unimproved contract, which we discussed the change already, that's, to add the adjustment of the purchase price based upon the acreage, which we agreed not to include at this time. Let's flip through here to see if there's any other specific changes.
Can I just ask a question? In property condition, why, and I know it probably just got picked up from one contract, so they're all the same, but on a vacant lot, why is the reference to copies of documentation from repair persons for repairs and treatments included in unimproved property?
Well, and there were several comments on that, of why is that necessary in there? And I recall us having a discussion on it, but I don't recall the substance of when we discussed that at the last meeting, so there were multiple comments on why do you have anything about repairs and treatments on.
I
have a water
And we
well.
can-
Yeah,
Looks like you have a water well or a fence or something.
or some diseased
People
trees that
still
you're getting
use the
treated.
unimproved, so.
It's unlikely you'd have it, but
It sounded like a lot.
But we already had a paragraph about repairs and treatments
Right.
in that contract. And we were merely modifying it to be consistent.
yeah.
Probably nobody even realized that was there until they saw all the red lines and blue lines, and they're like, what, why do we have that in there?
I mean, that is a good question.
It is, makes you think for a minute.
Well, completion of repairs, what am I repairing?
Again,
You can live on a street?
Well,
I guess it would be the well or the
Oh,
fence.
well.
there could be drainage.
Oh, well, okay.
Yeah, there could be
And
drainage.
so to be
Yes,
fair,
suspicion about that.
to be fair to everybody who commented, there was one comment too on the seller's disclosure. Every property is in a floodplain. Why make me check the box yes? Which clearly is not the case, but somebody did comment that basically every property is in one, so why do we have it in
Thanks.
there?
They live on the coast.
That's
Name's Noah.
I believe that we don't have, making the same changes we did to the other contracts. I don't believe we have any additional ones. Now I'm looking at the 9B5 just to make sure, but that the same thing with the HOA addendum will apply to the other. So marching forward,
And proration.
what's that on proration?
Oh, I was just
Yeah,
noting
same.
that, and I know that
Oh,
we're
okay.
making it consistent, that the wording would change on prorations.
And so for the new home contracts next, I know there's a desire to review these in their entirety again. I think that is a very good suggestion. It's been a while since we, as a committee, have looked at these. But deferring that discussion to another meeting. Let's see if there's any, I don't believe there's any additional changes in these that we haven't discussed. Let's be safe. I did not pick up on any. Anybody catches something different? I believe that is the last of our contracts. We can move on to the addendum next, or addenda next. One that ties into the change for cash, we can start with the third-party financing addendum. There was not a lot of comment on the actual language of other financing. We tied into the comments that we've already discussed in terms of not wanting to disclose the name of the lender. And there is a comment or a couple of comments that touch on, there's a waiver of 2B in here. 2B of the third-party financing addendum is lender approval of the property. And there's a question, well, if you waive 2B in 2A, is it really a contingency and why still have it? But there also was a suggestion that would say, well, why don't we do the waiver of 2B for the other financing types? Why do we have the 2A waiver, why don't we have 2B waiver as well, that's generally applicable to all financing? And I thought that was a thought out comment on there, and I'm not sure as a principal matter, a matter of policy, whether we want to foster and provide that or not. So I would tee that up for thought and
I think
discussion.
when they think of property approval, we're normally thinking of insurability and appraisal. And I'm trying to think of what other issues, I mean, I guess title, but that's a title issue, that's not.
Well, we can't do that on FHA and VA.
No,
So you have to.
it's not a
accept those out.
choice. I'm just wondering if a buyer waiving property approval on a conventional loan understands what they're waiving. Whereas on a hard money loan, what we're thinking of like that, they can pretty easy, that may be easier to do, I don't know.
And to me, it's out of the buyer's hands, right? If we're going outside of this other financing, which may be mom and dad or private lender, the buyer generally is not going to be sophisticated in underwriting practices and not understand what they may be waiving. So as a policy matter, I'm not sure we're going to take that out or take that out of the contract, use double word there. And also, we added a while back the requirement to provide written notice from the lender at the end, within so much time. So I don't see a real need to add that waiver in there, but I did think it was a good comment. There's also a request in the comments, and maybe multiple ones, to add a requirement for some evidence on a 2A out, right? To show some evidence the buyer was disapproved. And this is going right back to the same reason why we added it in 2B. In 2B, buyers were showing up at closing and saying, property didn't appraise, sorry, I want out, but they weren't given copies of the appraisal. And so we made the requirement for the buyers who should have the burden to go get something from their lender to provide that evidence to show this the property wasn't approved. So should we do the same thing if they aren't personally approved? Did they use reasonable efforts? Did they have something to show they weren't able to?
We had a long discussion at one point about that, and the question came up of whether a lender would even provide it, or, I mean, they're not a part of the contract. I mean, an appraisal is pretty much a document, and the buyer's given it, that's in their possession. There's a lot, the property, but it's a little different to have a lender say, you're not getting the loan in writing. I don't know.
I mean, one, you gotta give them to give it, two, you gotta get the underwriting and identify why. They could have been, they just didn't like them, or it could have been truly a credit score, like you really won't know.
Now, the counter to that, though, it puts the output, who's getting the out, and then going into it, they know they have to get that notice. So should we put that burden on the buyer? And I don't think necessarily we should, but the other difference that they're on the table in this discussion is 2A's drafted differently, and the buyer has only so many days to do it.
Right.
And if the seller is concerned, they can put a short period there to get it to mitigate this going all the way up to the closing day or 3 days before.
Buyer's not getting it approved is more than a 5% problem, but I don't know.
The only place where the buyer has to get a copy of the appraisal is when the lender appraisal addendum is used. The wording in 2B of the third-party financing addendum is something in writing from the lender saying that they're not going to make a loan, not a copy of the appraisal. And I think it's a valid question. And 2A, if a buyer wants out and they say, hey, agent, tell them I can't get credit approval, so I'm exercising my right to terminate, I think that would balance off with what was added for proof that it didn't appraise in 2B, property approval, where credit approval is the other part of final loan approval. And we're taking their word for it, that they didn't get approved by their lender. So I don't think it's asking too much.
It's a common frustration, for sure.
It is,
You hear that
and
a
it
lot.
would parallel what already exists in B for the property.
Anybody on this side of the table have any thoughts on adding a similar requirement for some written notice? Not necessarily the document, but something from the lender?
I don't think we're gonna be able to craft it.
Ken.
See, Mr. Kessner.
Yes, just real quick. I don't know if we can draft it or not, but we're seeing where there's 2A is for buyer approval, which is only the loans available, loan types available, credit, income, and assets. And B talks about the property approval. We're seeing a lot of people use 2A as an option, period. And I don't know how you would fix it, but it is definitely a problem. I've gotten probably 3 emails and phone calls in the last 6 weeks where they're terminating on buyer approval and then turn around writing something else up. And so I would like some kind of documentation, but I'm like you, I don't know how you would write it. And I'd be interested if it's happening with the other brokers there too, that they're using that as the option.
What about the wording that's already in 2B2, a copy of a written statement from the lender setting forth whatever, and make the 2 sections parallel, getting some written proof from the lender?
With the addition of being so many days after the effective date of the contract instead of so many days before closing. So it keeps it in the same vein as it is now, just requiring something in writing from the lender.
Well, keep in mind, A is written to be affirmative, that I do have buyer approval. B is written in the negative, the lender that's rejected.
I'm not sure I agree with it's in the affirmative, because it says it's subject to buyer obtaining buyer approval. If buyer cannot obtain, you may get they may give written notice within so many days.
But buyer
That's-
approval will
What if-
need to have been obtained.
What if a phrase was added at the end of the first sentence? And this contract will terminate and the earnest money will be refunded to buyer, along with written notice from the lender, something right in that area. I had a better idea until I started to read that.
Well,
Can you copy that so we can look at it on the screen from the
Typically,
TV?
I mean, what happens is the buyer says, I'm terminating the contract because I did not get buyer approval within the number of days. And then he asks for the earnest money. And the seller either signs the release of earnest money, or he says, I don't believe you, show me. And until you show me, I'm not signing the release of earnest money.
Well,
Yeah, but what we're getting like in 3 times in this last month of my lawsuit, my case is not lawsuit, potential, where people are out of town. You just have your friend, the mortgage company, he just puts out a sheet of paper that he didn't approve.
well,
Which is fine,
and
but
it
then-
is.
But it's wasted everybody's time, so is that reasonable evidence that you really couldn't get it in used efforts? Because
Yeah,
all you got was,
I don't know, you can fix that one though.
Well, and it's not a turn down necessarily.
He does it all the time.
Okay, go back.
Well, I think that this will be, if we add to 2A, that's a substantive change. So this is something I am willing to kick to the next meeting, because we've got things that we need to get to.
Can I say that they're not, it's not just being turned down, it's you haven't gotten approved. It could be still in process, that you get approved a week later, but if you don't get approved by that day,
Yeah, which
That's
is usually
sure.
21.
yeah. Yeah, and the question is, how's the lender gonna write that letter up? I mean, maybe they will, you know.
Yeah.
We're not saying we have to have a letter saying you're turned down, we have to have a letter that says the process is not complete.
Yeah, and did you apply promptly and provide all information as required?
I don't know how you judge that.
I think this comment was identified not to a change we made, but in addition to,
This-
everything
this-
else. So I'm also not opposed. I do think it's a problem. I do think we need to address it. And I would like to put this as an agenda item for a future meeting, maybe when we do the legislative changes, would be something to, because I don't want to just kick down the road, but it's for timing's sake with all the other changes we have to get to. But it is a point very well taken, and I'm in favor of studying that more. Yeah.
If we don't read
Yeah, I think, I was getting ready to compare the language between the two, but, but if we can make that a future agenda item to discuss.
Yeah.
Keeping you on here,
I'm in
too.
the line of fire, so I don't wanna be collateral damage.
Thank you, Mr. Kestner, for your comments. Well taken.
Thank y'all.
Did we skip the amendment?
No.
No, we're working through
We're not
them
going
now.
in the same order as the packet.
Yep. What we're doing is trying for, if we went through the packet in order, we would be all over the place and we'll be here for 3 days, I would fear. So we're trying to take it by topic. So the next form is, well, we can do the amendment next. That's the next one on my. So this is page number
Which one?
223, the amendment form.
I just saw that. Where'd it go?
We had, I believe, a few comments that we're just trying to drum up work for attorneys by adding all this language about practice law.
Yeah.
And as much as I would love to drum up work for those practicing law, as much as I used to drum up for attorneys, I think everybody's desire, sincere desire, is to keep agents out of trouble and to protect the consumers from agents attempting to practice law and harming the consumers in the process. But that, I believe, was the thrust behind some of the change we made here about specifically not practicing law instead of insert only factual statements.
Was there any comments? I don't remember this one.
Well, all the comments were on 6, and that's not something we did. We didn't touch 6, but they're still commenting on it.
And what I've heard from the option, why it's not going to title instead into the seller, because they're assuming that the option fee has already been delivered to the seller before an amendment is written. And that's why
And that's what we've discussed in these past changes of, we want it to be in the affirmative that it has been paid. And they should pay it with the amendment. And if it hasn't, the question has been raised several times, well, what are the situations when it's not? But I think in our past discussions was thoroughly discussed on that one. And we came on the side of leaving it in the affirmative that it has been paid to protect that additional option period right. And then if it really isn't, then we fight about that still.
I just need to talk to your title company, find out what their process is, because every title company has a different process.
Do you want to, in the line, because I don't know if we discussed that.
There's a Texas Supreme Court case from now it's many years ago, the Jovich case, that says that when you have an affirmative recital of a nominal consideration for an option, and you say it has been paid, that's conclusive, and the court will assume it has been paid to support the option. And we didn't put it in the contract because the option fee sometimes is not all that nominal. But in the amendment, there are two things. Number one, it's almost always a nominal amount. But number two, these amendments are done bang, bang. They're for a short period of time. You rarely go through the title company.
It says buyers pay
And
the
so,
seller.
and so the best most practical solution is to have that nominal amount and just say that the buyer's paid it to the seller. Because it's usually just a short-term extension of the option period, right?
Yes.
And there's that Supreme Court case that supports that, and really there's no reason to muck it up when you're talking about a short-term extension made at, late in the day between the seller and the buyer directly. No reason to go through the title company, just say it has been paid to be done. Now, whenever people ask me about it, I say, if it says $10, pay the $10.
Yes.
Don't give them an argument, but that Jopich case is really good authority that the courts will say, yeah, the intention was to grant the extension. And we're not gonna
John,
stub your toe on it.
other modifications, for consistency, it says real estate brokers and sales agents are prohibited, same wording in paragraph 11, but down in the line that was added, consulting attorney, it makes reference to prohibits real estate license holders. It seems like we should, not to confuse things, what's the difference between agent, broker, license holders? Would it not be better to be consistent and say brokers and sales agents and or license holders, one or the other, but the same thing, because that's what they're referring to?
Well, that's the language from paragraph 23 of the contract. I think right at the end, consult an attorney before signing.
And does it list license holders?
Yeah, but her question says, why was 9 and
Look at
the
paragraph.
notice match? And
Yeah.
that's an excellent question.
Yes.
Because somebody's bound to say, well, what's the difference? And I think it was just an oversight. So in special provisions, we use real estate agent.
If you wanted to make it consistent, all you have to do is say real estate license holders are prohibited from practicing law, because both brokers and sales agents are licensed
I
holders.
think we talked about this when we were discussing paragraph 11.
Yeah.
Well,
Somebody said license holders, and somebody said, no, let's make it clear, brokers and agents.
well, what we did in paragraph 8, you're referring to paragraph 8, I think.
No, 11.
Now, 11 and 23.
11 and
Got two
23.
different places.
Okay.
What does 8
Well,
say?
8, we refer to brokers and sales agents, because that's the common terminology.
Okay, and 11, we do the same.
Oh, yes, the title of it.
In 23, we say license holders, and I think it's just a matter of taking one to the other. I don't think it was done intentionally, but I think now's a chance to be consistent. So how do we want it to be?
I think in trick rules, they're referred to as license holders.
Well, it's just a matter of This is a style question, so I think we can put a global instruction for the staff if we want to change to use real estate agents and brokers.
If it wasn't that those two sentences are an inch apart,
Yeah.
Yeah.
it wouldn't
That's what I
matter.
just did that.
Well, we could use the same terminology, we use brokers and sales agents. Maybe we just instruct the staff to correct those.
Looking at this from the consumer point of view, I think they understand that better than license holder.
Yeah.
License holder, I think, is probably a more technically correct one, but as far as
Hairdresser is a
consumer
license
protection-
holder.
What's that?
A hairdresser is a
Yes.
license holder, so, I mean, this is a real
But
estate.
it says real estate license holders.
Yeah, real estate license holders, then fine, take it up above there, but I think we're just creating unnecessary confusion by having two sentences so close together.
I like the consistency thing, and I do think for consumers, real estate brokers and sales agents is understandable more than license holder. I would be in favor of doing it license holder if we didn't already have, like Ron said in paragraph 8, the whole section that's
And
brokers
11.
and sales
Well,
agents.
can we focus on just the amendment? I mean, instead of talking about changing everything in the contract, like on just the amendment?
Yes.
Well, I think that's the only place that it's,
On
it's
just the
cross.
commitment,
Oh.
can we make those consistent because they're so close together?
And leave the same in
How
paragraph.
would we just do that in all the forms?
Because paragraph 8 is it 8? One of
8
them
already
is
has
titled,
brokers and sales agents.
is titled brokers and
So
sales
we
agents.
use a.
That's what we're talking
We're
about.
talking using that term.
Well, I thought we were saying with the statute, which is license holders.
No, I think the thought was brokers and agents, switching over to that.
Do
instead
you
of
all
license
see a
We used to
problem
say
if we don't
brokers and
use
agents,
license
and we
holders
changed
in
it to
that?
license holders because of,
I tend to agree with John.
holders.
All right,
It was
so
in
they
style.
say, they
Now-
say we don't have to use license,
Second style.
so.
That's it. Thank goodness that SJ's not here on this one. We know where that.
Well, I think John's got a good point, though. I mean, agents and brokers is pretty clear to the consumer.
It's probably better.
Anybody have a strong feeling about license holder?
I prefer confusion and consistency.
Keeps you in this high-paying job you have
Yes,
here.
that's it.
That's it.
It's a hobgoblin.
That's how I pay for Hawaiian shirts.
Yeah, I do want to do a quick search in the rest of the contract to make sure there's not another place by just making that general statement that we will be creating more issues, license holder. Special provisions, only 3 places. The only place is in the bottom of the paragraph, this form is intended, we leave that as license holder to make that, was that the question you asked earlier?
No, it was a consultant attorney.
There is a disclosure, the Trek disclosure at the bottom of this form. The form of this contract has been approved by the Texas Real Estate Commission. Trek forms are intended for use only by trained real estate license holders. I would vote that we leave that license holder and change the rest.
agreed.
Is he market?
So, any other comments on the amendment? Moving on. No. Next is the seller's temporary residential lease form. It's in there, and there's no changes to it, but the comment that goes to the prorations is, well, what about prorating the rents under the temporary residential leases? There were a couple of comments on that. And I think the language of, this is on page, no, I printed this out, they didn't include it. There were comments there. But the lease says, one, it will be essentially prorated. The language of the lease itself says it'll be prorated. And the other says it doesn't matter if it's more or less, this is the amount.
What are you talking about, prorated?
You pay the lease, the rent in advance.
It's so much
and
per
all in
day.
advance.
It's so
Yeah.
much per day and you pay it all
In
in
advance.
advance.
Yeah.
Yeah,
So.
so,
And it
What
says,
do you matter like that?
so I printed this out separately because it wasn't in our materials, but the rental in the seller's form is different in the buyer's form. But the seller's form says tenant shall pay landlord his rental blank per day.
Yeah,
with the full amount of rental for the term of lease be paid at the time of funding of the sale.
So if you move out
So it's
early,
already-
they want a refund, and that doesn't happen.
And tenant will not be entitled to a refund of rental if this lease terminates early due to a tenant's default or voluntary surrender of the property. So we already have a per day in that one.
Right.
In the other one, let's see, buyers.
It's a per day, I don't know exactly.
Per day, and
He's
it
paid
ends at the
weekly.
date of closing, and so if
It's paid in advance.
you get a credit
I would
back.
Well, no,
be
you
opposed
don't.
to
It says at the
getting
actual
rid
term,
of the
this is on the
temporary
buyer's
period.
temporary residential lease. The rental says, if the actual term of this lease differs from the anticipated term, any additional rent or reimbursement will be paid at closing. No portion of the rental will be applied to payment of any items covered by this contract. So it also discusses it being paid at closing. So I don't think we need this in the proration section. But there were a few comments on that in our materials.
He's trying to eliminate a rebate from the seller after the close.
It's already, yeah,
Yeah.
I don't think there's a change.
The problem they have on those is they just put 0 and 0, and then I wonder why they can't
Why
get
they
any
have
money.
problems, yeah.
So
0
the-
rent, 0 deposit, yeah, I'll let you just stay here, and then they wonder.
So the next form we have is addendum, the HOA addendum, which we've already discussed. Seller financing addendum.
This is theoretical.
Page 210.
This is page
Seller
210.
financing?
Yeah. You start.
Yeah, as interest rates go up.
In my summary of the comments, there weren't enough on this one that I actually had any summary of them. So unless somebody has something they want to discuss on this, maybe we defer this until we see what's actually in the comments themselves.
I don't remember seeing anything in the comments.
I think there may have been one stray one in there that wasn't really of substance, but we can address that if we get to those.
I think this is an outstanding work product.
I agree, I agree.
Actually, there was one comment that said they liked it. I think that may be what it was.
That was my mom.
Stacked up here.
Funny because my mom didn't like them at all.
Fixed releases. So I'm gonna go through the ones that there weren't a lot of comments on for the addendum regarding residential leases, the addendum regarding fixture leases, the oil and gas reservation addendum.
I think that change on fixture leases makes it so much easier to read.
Fixture leases. Oh, yes. And there weren't any negative comments to that from what I recall. The notice to prospective buyer, and we may have had one of why is this necessary, but there weren't any really specific ones there. And again, we'll catch these here in a minute as we go through. In the loan assumption addendum, I'm surprised we didn't get more comments on that one. You know, especially with the market changing the way it is.
They don't
They're not
understand
using it
it.
yet.
Yeah.
They're not using it yet.
It hasn't happened.
They've never done
Most
it.
agents-
It will like
Most
crazy.
agents have never used this addendum,
No.
right? Like,
And most closers have never done the prorations.
I've-
So it's
I've-
gonna be a learning curve for everybody.
Assumptions.
I can hardly wait to relearn that.
And it will be interesting if this is used, because I believe the vast majority of loans are probably not assumable.
Without
This will-
qualification.
With interest rates going the way they
Well, that's the
are.
thing, it's all gonna be with qualifications, so what is it really gonna?
So this one
They're
should be
all
Christmas
assumable,
feature
but-
for us to discuss once we get comments back. With that, I believe that's running through all the contracts. Do we want to take
The
a
third party?
third party?
We did over G,
We
we
did
talked
third
about
party.
G,
We
I
did
guess there
third
was no
Yes,
comments
there was no
about G.
comments on, other than this generally
Okay.
why should I
There
have
was
a
no
list of
comments on
terms?
G, I thought they were okay.
You want to take a 5-minute break real quick, and then we can run through the comments and the other agenda items?
All right.
We finished walking through the general comments and the changes to the contracts, and what we'll do now is to make sure we didn't miss any of the comments, because not everything was summarized. The first we start off in page 9 of the materials was the Texas Realtor suggestions. And I believe we walked through most of them, but there is a request for 1031 language. And Robin, I don't know if you want to address that.
I think, yeah, it's, excuse me, it's another thought or recommendation that came out of our Farm and Ranch Task Force. It's a common way, or it's common in the Farm and Ranch community to have those types, either for both unimproved and Farm and Ranch themselves. There is a similar provision in the Texas Realtors commercial contract, which we included the language in there just as an example, not as specific language to use, but just to have in there. The thought is Texas or Farm and Ranch contracts, they're different than the general consumer 1 to 4 family residential contracts. The property owners are often more familiar with those types of business owners generally, and so more familiar with those types of transactions. It will be beneficial to add that. It eliminates the step of having to go outside to find an attorney to use that. If the committee feels like there's a general catch-all type of language that could fit in there, then we feel that it would be an improvement.
And I think that's well taken, the comment, and I would propose we look at this further into the future, because this happens a lot, not only in Farm and Ranch, but a lot more and more common that I'm seeing in the 1 to 4 in the various other contracts. People are writing their own provisions in. And I don't think a lot of people understand why it's important or how it changes things. And a lot argue whether it's beneficial or not to have it in there, but there are some things that the parties have to do in a 1031 and in cooperation between the parties that maybe facilitate it better if it was previewed in the contract, and the buyer or seller knowing it's a 1031 going into it, and the requirements that would be, especially at the end of the transaction, in assigning the contract and doing these various steps. So I would propose we look at that further, not only for the Farm and Ranch, but for the other contracts at another date.
Yeah.
Unto itself.
And I
When
believe
we've done 1031s, the 1031 company tells me what to put in there.
Exactly.
That's what I was.
It's not worded, I mean, they tell me what to put in there. Please put under paragraph 11.
And I believe we've addressed the other comments at Texas Realtors. Was there anything else you wanted to discuss before you
No, thank you.
Thank you.
I mean, it's important, absolutely.
The witness is excused.
And just to clarify, just because we didn't comment on anything, doesn't mean we don't think that it was well done.
Well done, Robin.
Okay, so what I will do now, if everybody's okay with it, there are a ton of comments, and I've summarized each one in my little notes, and I'm going to quickly look at my comments and see if it's something we've already discussed. If you catch anything that I said we already discussed and we haven't, let me know. But I do plan to run through this pretty quickly. So starting on page 12, Heather Lange's comment we've already discussed. 70 checkboxes, the same one below for Robin Puckett. Leslie Lerner gave a lot of comments, 60 required notices. We've already discussed that. Checkbox logistical issues. Page 13 near the bottom, questions statutory range private transfer fees we discussed. With copy 2 we have discussed for comments. The Farm and Ranch about surface leases being combined into one on page 14 we've discussed. A lot of checkbox issues, starting on 15, checkbox issue for E we've discussed. Same for 16 for the unapproved, where the ones checkboxes and added the SDN to the checkbox. The page 17, doesn't want seller be responsible for costs of transfer and warranties. We talked about that. Thinks Oak Wilt needs to be defined. We talked about that. Page 18 doesn't want the disclosures in the contract. Page 19 is worried that property being sold 30 days prior to closing shouldn't be considered cash. We went through those issues there. The questions and necessity of prepared language in the unapproved contract. We talked about that. Page 20's the special provisions disclosure issues. We've gone through that and agents being able to write the language that they are parties to. 21 is checkbox logistics. 22, special provision principle drafting. Clarification. 23 is checkbox logistics. And the public that submitted these comments, we're not shortchanging you. We all do read these things thoroughly, and these are summaries that we think we've already discussed. So we did consider your comments. Page 24, special provision drafting clarification. 25, the same. 26, doesn't want special provisions to be changed. 27, generally doesn't want any changes made to the unapproved. 28 wants the special provision clarification, same for 29.
Now, just the similarities and all.
Yes, these are a few that are copied.
all the same
Cross-reference efforts.
They're duplicating.
Yeah, same for 30. 31 complains about the logistics issues with the checkboxes. 32 is special provision clarification, same for 33, 34, 35. 36 thinks cash language addition is unnecessary and confusing. Disclosures belong in a seller's disclosure notice, and thinks training, not contract changes, are the solution. I think we can agree to that last one for many of these. 37, concerned about oak wilt. Yeah, people not knowing what it is or being confused. I think oak wilt are a different issue. About trees, the neighbor, this is one where the neighbor tells you that's oak wilt, and may or may not be, but we discussed that. 38, the old cash language was clear. Repairs, why does it have to be, why are they in the unapproved? We discussed both of those. 39, cash verbiage being too long. Title notices, I didn't understand actually the comment there. Number 612 should state and not or plus forms are attached. So I guess they're not, we've already discussed this. If those things are not true, or they put them in an attached form, which we've gone over. And special provisions is confusing and long. Number 40 at the top, likes paragraph 21 with copy 2 language, provides clarity. The bottom is concerned about special provision wording, thinks limits agents from filling in language for their principals. They did provide language, suggested language we've generally gone over, which they wanted to express things saying which real estate brokers and agents are permitted to provide as defined as follows. They want something saying affirmatively agents can do it, but I think we've thoroughly discussed that language. It's clear.
The only thing I think is the reason this is coming up so much is agents are coming from other states and they've been allowed to do this or something. I don't understand why they even
Other states.
do this. I mean, we haven't been told to do this for 20 years, 30 years.
But I think I think they're also misreading. They're just saying that agents can't write anything, practice law, fill out their own forms, and then they're not reading it all the way through. Because once you say you're a party to the contract, that's answered.
And I will say, to credit Nathan Cook, the language they drafted, I think is pretty well drafted, but we talked through the reason not to include language like that. Mm-hmm. But as far as the suggestions, Mr. Cook, thank you for offering those. On page 43, once the notices in paragraph 22, we discussed that. At the bottom, cash is clunky, prefers hard money not included. To say, and the cash portion of it to specifically say cash does not include hard money. But
there's no good definition.
And that's why when we talked through this language, we had that, I think, exact discussion of expressly excluding that, but then there's all these other types of financing as well that's not hard money that you would have to put in the complete list. And again, if I run through this and you want to discuss anything, please stop me. Confused on the escrow agent meaning. This is one I think may have been saying escrow agency or maybe not, but they were confused on escrow agent meaning. Check boxes should be in the seller's disclosure notice, which of course these are contracts that don't require the seller's disclosure notice sometimes. Paragraph 11 is confusing on the statement which completes a blank form, I'm on page 44 now. We should talk about that. Going to 45, thinks cash language change leaves no place for hard money loans. And wants 3B revised, or to, which we've already gone through that in detail. Page 45, title notice, add lead-based paint in SDN, which we're going to look further into these checkbox issues to see if we want to add any of the other ones in a different place. This is one that wanted the temporary residential lease prorations to be put in the contract, which we talked about as well. The bottom of 45, checkbox logistic issue, thinks the floodplain is generally every house on the market, so why have that in there? Page 46, checkbox logistics, already in the seller's disclosure notice, so why have it? Bottom of 46, cash means just no financing contingency. Questions use of prepaid, regular, periodic. What qualifies for that? And I think we thoroughly discussed that as well. They do give some optional language in there, which I think we all considered coming into this meeting. Did anybody not read that and wants to go over the suggested changes there? I don't want to shortchange Mr. Scott Rooker's comments, but we did consider those before this meeting. The next one, which is later on the comments, so we can discuss now, it's highlighted later, but they want some changes to the survey section. And this is Mr. Rooker as well. And specifically in 6C, we haven't discussed this, to sellers existing, provide a legible copy of the survey.
Who determines what's legible?
I don't think.
It already has language that says acceptable too.
Right.
So
So I don't, in my comments here, don't want to be judge and jury for legible. You know, that's between the parties that they want to fight, I believe.
I think they're concerned if they checked off the borrow paper and knew if it's not acceptable, all of a sudden they get an illegible copy, they think that's not performing, but.
It'd be hard, I think, to make that, somebody determine that and create more fights instead of the more black and white one we have now. The next one, I would like to defer this to a future meeting. There is often confusion on getting the exception documents. And as we list here, the buyer has so long to object after buyer receives the commitment exception documents in the survey. And the question is often asked, okay, what if you get the survey? Does the time period run from then? What if you get the commitment but not the exception documents? Does your time period to object run from that? Or is it after all three are provided? Does then your time period start to run?
Yes, that's your answer.
And the comment here to clarify that is the last of, which I would like just to, punt that down the road to think about that, but that is a question that I personally get quite often.
That's well said, last up.
And I think that clarifies it for consumers.
Well, the problem is that you get also the revised title commitments, right? Does that?
Yeah, and
Well, we
Yeah,
added new language for that.
you don't know if a revision's coming or
Year or two
not.
ago.
You don't know when it is to last.
it has been repeated over the last several years in courses on legal one, when you get to the cure period, talking about that this can happen time and time again. And so you've got to keep track of all of these different dates.
Right.
So it's not just, it's each one individually for the number of days and.
Well, on this one, and that's where the debate comes in, whether it's all,
Well,
because if an
I
updated
think we're
survey
trying
comes
to
in,
teach-
a new one, an updated commitment comes in, but does the original time period run from when you receive all three?
According to what Trek says in legal one, each one has a life of its own.
And that's why I like
change
to
is
read them
necessary, but
together.
if somebody does, then absolutely, let's talk about it at another meeting.
That's why I want to get this, because it's a broader topic than I think we
Yeah,
have time for today.
clarification, sure.
Okay, moving on to the next one. Thank you, Mr. Rooker, for those comments. That's well. 47 thinks we've talked about that. The financing, transfer fee misunderstanding, concerns that fee attorneys and title companies can't draft language now for special provisions, which we've already discussed that and the issue there. 48 thinks verbiage is too gray for cash. Bottom of the page, private transfer fees, doesn't think people will understand, which we add clarification language. 49, cash, worried about disclosing funds for an IRA or 401k. is wondering, the next comment's why lowercase survey, but not title, policy, or closing date, or exception documents, which are all defined in the contract, is why we left those
That's
capitalized.
insulting to the server.
Next one, in paragraph 11, why not just remove it if we're doing the changes we're doing? 40 or 50, strongly in favor of new language in the second part. So strongly in favor, but vehemently opposed to the beginning part. Once this paragraph is intended to be only for additional items. And this is where we talked about there's 3 additional items listed. And they're worried that that language limits it to just that and none other. But we did discuss that already. That comment goes through 51 and we go to 52. Repair and treatment language thinks opening a can of worms by requiring the documentation. Doesn't think contractors will provide. The next one, Cash thinks the language is invasion of privacy. The bottom comment is the same thing. 53, Cash invasion of privacy. Kid wants a checkbox left in to remove room for error, so they want it back in 22. Title notices wants it in paragraph 21. Disclosures at the bottom wants to be on a separate form. 54, transfer fee, this misunderstands the nature of it, which we clarified. With copy 2, the double line which we addressed. The bottom comment, surface lease 6F wants to combine into paragraph 4, which we talked about. Let's see, move to 55, wants a 9 PM deadline on the earnest money and option money.
That is the most popular thing we've done, is putting it at 5 PM. That's the last.
You need to work till 9, do it the day before.
I go to bed at night.
Speak into the speaker.
Yeah. So on that one, I think we've thoroughly discussed that issue at prior meetings, and leaving the termination deadline at 5 PM is what we've decided. Page 56, Cash, current financing addendum. This is Don Moore's comments, which we discussed at length. And hers go on to 56, 57. If you haven't read those, she really did put a lot of thought and time into this. And if she is a former member of this committee as well. And so she really cares about these contracts and made very good comments. We discussed Brian's comment on 59 already. 60, the special provision will just be confusing. 61, warranties concerned about logistics for sellers doing it before closing, but they may not know how to transfer warranties. 62 is private transfer fees, wants a checkbox for who pays. We talked about that. 63 wants to keep title notices in paragraph 22. 64, Cash agrees with the change due to hard money. Somebody doesn't like the cash change. 65, notices to keep in paragraph 22. And that's the one who brought up the reference in 6E7. So it was a very good catch to bring up, the only one that caught that, I believe. Checkbox logistics, already in seller's disclosure, questions whether transfer warranty payment should be negotiable, and thinks private transfer fee definitions confusing. 66, limiting where to put 401k borrowing in the sale of other house, which we talked about, and thinks that the repair language will lead to earnest money disputes if receipts are not provided, which that's more of a termination dispute, I think, than first before the earnest money one. 67, escrow agent thinks we need added blanks to have filled in every time. And I think this was a red line misunderstanding. I think they looked at the red lines thinking we added a blank to the escrow agent every time, as opposed to just changing it to capitalized escrow agent. So I think it's a red line misunderstanding there. 68, transfer of warranties. They wanted to include if any language. If we talk about this, we already have the word any in there. So if there are no warranties, they were concerned that we're requiring a warranty to be transferred. But here, we already had any, so it doesn't require you to transfer one if one doesn't exist. But they suggested a clarification here. Then they wanted language about a buyer having the ability to transfer other warranties that are not tied to repairs, which we talked about. And asked if 9B3 obligates seller to transfer other warranties, which we discussed that it does not. Page 69 was 2 lines for buyers, which we addressed. 70, repairs who determine the documents are acceptable. Any items that sellers can complete themselves, which we discussed both of those. Can closing be delayed if docs aren't provided, was a question, which we won't be in the middle of disputes on contract breaches and whether you can delay closing or not, or whether it's material. I don't think we want to venture to provide an answer to that legal question. 72, cash sale of other property for 1031s, and whether it's concerned about the cash language in that regard. Can you pay cash but then later choose to amend, which we talked about. I think there's no recourse if the buyer doesn't disclose source of financing. 73, repairs, thinks the unapproved contract language is clear and better, but it's really the same thing. So I'm not sure, they, I guess, just don't like the changes. 74, escrow agent wants to change escrow to escrow agency, which we put on the kind of the end of this meeting, which there's 2 things we'll bring up, that and one other at the end as well. 74 is the same. And then they provide an example of a contract that listed an individual escrow officer instead of the escrow agency.
There's certain associations that put it in the mark.
77, wants the residential service language to be removed altogether. Thinks that they're not doing a good job. At the bottom of 77, same, and adds that they think that we're endorsing home warranty companies by leaving it in the contract. 78, title notices, likes it, but wants to simplify by stating that they have been given. We really didn't discuss that comment, but if we do that and they haven't been, we're creating more issues there. So I personally don't think that is a should adopt.
It does say
Fine.
either have been provided or attached, either way.
And so it's on kind of where he's going there. So there's some protection, but I guess he wants to take out the attachment language. This is one too, which was repetitive, and I actually had an internal broker dispute last week on this, on whether these are actually part of the contract or not. And there was a huge dispute internally, and there's an intermediary transaction, but there is a lot of confusion on that, which we talked about, whether they're actually part of the contract or mere notices because of how they're referenced. 79, repairs make transfer of warranty fees negotiable. He thinks companies will increase their fees if they know that they have to be paid by the seller. 80, paragraph 21, likes the CC language, questions what is considered a notice or what other communications fall under that section, which we'll look into clarifying potentially as well. When can you copy the other side's client? Which this is addressed squarely in the legal update materials that are out there now for educational purposes. The course is now saying if it is a notice, make sure the other side gets it in addition to the actual principal, in addition to the agent or broker. 81, repairs, likes the change, wants closing to be defined. So we have closing date defined in the contract, but we don't have closing defined. So this is one that's saying they use the word closing here is can be confusing. Can we define closing? I'm not sure we can on that. We have when is closing? When is funding? Is that how you tie that together? What is closing? What is closing? So I would venture to say that one is be a good process to wrap our heads around it to define for this purpose. Any other thoughts on
No, we're trying to, I don't think we can find something the third-party vendor is using to operate, how they close a transaction.
That's outside our control, and they understand it because it can be different things to different people or for different purposes as well.
A lot of dirt.
Delivery of season.
Paragraph 11 thinks completes a blank in the contract form is confusing. Not sure of the intent of it. Likes the courtesy copy language or the copy to language. 82, warranty transfer expense should be negotiated. The buyer should have the option to decline the transfer, which we've already discussed. 83, repairs once the seller be able to complete themselves.
It says that.
What's that?
It says that in the
No.
repairs that they can
Yeah,
do
we
it
can
themselves
negotiate
if a license not required.
Well, it's negotiable, but
No,
now
that's-
says it will be done by somebody.
Either licensed or does it in the regular course of their business.
But
But also you can negotiate in the amendment when you're doing the repairs, say seller personally, you know, and whatever.
and we had a discussion on that as
Because you're
well.
amending the contract.
84, warranty transfer should be negotiable. Questions what completes a blank means. 85, why was the addendum removed? Should fit back in now. 86, warranty transfer, doesn't want seller to be responsible. 87, warranties, doesn't like transfer language. Worried sellers don't know how to do it. The transfer of warranty scares them to death. That is, sellers should know best on that one and figure out in advance. 88, paragraph 11, agent who wants to be able to draft provisions for themselves when they're the principal.
Is a real estate.
Same for 89.
Congratulations.
For 90, should be seller's obligation to disclose, but the fee should be an obligation of the buyer for the transfer of warranties. So they want a disclosure in there, but make it an obligation of the buyer. Paragraph 11, broker as principal in drafting special provisions. Same for 92. Same for 93. And 94, cash, worried about funds from sale of other property. We've gone over that for the cash portion of it. The winner comment goes to page 95, and I'd like to give a special thank you to Candace Cargill. His comment was, thank you, thank you, thank you. No more question marks. So I assume that no more just is applauding all the changes we made. That comment wins the day. 96, blank space should be increased. Where is this in? They would like the paragraph.
Increased.
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 Increased. Oh, increased. Okay. In paragraph 3, this was for, which one here? I don't want to shortchange this one.
Well, they want the blanks to be longer so they can negotiate
Oh,
on.
so for the sales price, so they can write in next to it a counter offer for the amount that's being
Yeah.
offered, which I don't think we want to venture into. 97, cash, sale of other property, they're concerned about that. Thinks this change will result in agents practicing law and special provisions, which hopefully the new disclosures we have in there for admonitions are well taken, so they won't. Number 90, page 98, Todd notices wants check boxes for notices provided. 99, special provisions, concerned about if it completes a blank, does it fit the statement in paragraph 2A? So this is where we took out, I believe, let's see which contract this is on. They're concerned that 2A requires you to put it on an exhibit and not necessarily in special provisions, because there's a specific statement that says, or as described on the attached exhibit. And now in special provisions, we said if it completes a blank. And so by having that language specifically in the 1 to 4, where it's describing attached exhibit, if the agent puts it in special provisions, is it effective? And we touched on this earlier.
You have the word or. You can do either one.
Or is
So I think we discussed that earlier, but it is a good, thoughtful response in reading the language. I applaud them for Cynthia Bass for reading them that closely. Page 100. Should, number 7, shouldn't it state, and this isn't a not, same thing about the contractor should say no, or you should attach a form for the seller's disclosures. Paragraph 11, they think it's confusing and rethink that the other language is simple and better. 101, borrow, vague, doesn't include 401k language we discussed. And then they asked about the warranties, confused on the warranties, and the timeframe for providing notices. What happens if PID mud, this is a slightly different comment. What if a PID mud goes into effect after you're under contract? Which I think is definitely a 5%er to addressing these contracts. Not very muds are going into place when you see the contracts. So I'm not sure there's anything to actually address there to make these contracts longer. 102, cash and survey, which we discussed, both of those by capitalizing survey. 103, sale of other property and cash. 104, they comment on the other end of the spectrum. It says disagree. So we assume they disagree there.
Thank you. The whole thing.
105, invasion of privacy for cash. Same for 106. 107 wants lead-based paint seller's disclosures to be added to title notices. New home wants to begin, and we discussed, defer this one to a future one about the option period beginning when the builder gives notice of substantial completion, I believe is what they meant to say. But we can defer that to later. Title notice on paragraph 21. What's the in paragraph 21? With those, jumped into 110. We've already discussed that exact comment before. 21, title notices in paragraph 21. Same comments. Already discussed that 114. 115 is essentially the same thing about why it's in paragraph 21 for title notices. Yeah, we're repeating several of these now, so I'm going to jump forward to the next one.
What page now?
Now I'm on 119. We've
115 talks about a seller's disclosure for Farm and Ranch. We discussed that. I mean, I know the answer. I don't think we discussed it.
Farm and Ranch. No, the very top comment there. I think I skipped over that because it wasn't highlighted. So I'd like to see seller's disclosure of Farm and Ranch as detailed in the detailed as a commercial property disclosure, the form 1406. So proposed 2 disclosures for Farm and Ranch.
So in our subcommittee, we didn't feel like it was really our scope to go down that road, but we did tire kick briefly that that's an interesting idea for the future.
And a whole separate form.
Yeah, and how it put together, we didn't get past, A, B.
Well, the actual,
but
yeah.
the concept wasn't, we were trying to incorporate a lot more in the contract with surface leases and things like that. So then we started thinking about, but I paid my meter.
Not going to be booted or towed.
That's right. But there was a lot to that, and it wasn't going to be tackled easily and in one breath.
So we'll defer that discussion to.
Well, the
next year
actual,
meeting.
the actual seller's disclosure that Trek promulgates on regular pre-owned homes is exactly what the legislation requires. It's not, we didn't come up with it.
That's where we went back to. We're like,
Yeah.
there's nothing that prescribes that we should be doing it like
Right.
the property code does for the other.
Yeah.
But, we'll leave it to the legislature to let us know what's best
Oh,
on that front. Legislature we trust. Jumping to 119, likes the seller's disclosure, thinks it's good in the Farm and Ranch. 120 is logistical issues, wants a separate form for the disclosure. 121, so this is the one that needs to be changed in the seller financing addendum. So this was a very good comment. In the changes we made, paragraph 3 should be paragraph 4. And so when we added the paragraph, we didn't add the next number, we just did it.
Yeah, we've got 2 3s instead of 3 and 4.
My mom didn't catch that.
Can we do 3A and 3B?
So that was,
She's
it was
getting slow.
Garrett Brandt. Thank you, Garrett Brandt, for picking up on that. That's a good catch. Do we need to put that in the minutes there, Ryan? Make that correction? Sure.
The next one's good.
Yes, oh, we got another winner. We got tied for the winner. Love it. Absolutely love it. Keep sending those in for the many members of the public that are on here, all too. Send in those nice love comments. We love reading those too.
They must have put our photos on the website.
So the 123, do not agree with needing to consult attorneys. Same for 124.
We send that to SJ.
Let's see, we've already discussed the 125, applauds the change to take out the certified mail requirement for the notices of termination. The 126, which we went through Don's comments before, one's highlighted at the end, which we discussed too, as described on exhibit. We deleted earlier, correct. 129, notice of termination, concerned about the statute requires certified mail. But as we've gone over before, this is in addition to the statute. And the statute doesn't prevent us from giving a different termination right. So we're not taking away anything from the statute, we're just giving an additional right to terminate the contract. Title notices, things agents will believe they are part of the contract for the PID notice and LUD and such, which we've gone over several times. 130, things as described on exhibit seems to be incomplete, which we've taken that out. We've already discussed the 131 comments. 132, concerned about this language. This paragraph does not apply to a fee, is not opposed by the association. So we've discussed this language there. Things is vague and what category does it fall into? It's 132. Bottom 132 wants to review specific HOA fees, which we've already went through some of these earlier and discussed the others. And so thank you, Susanna Ward, for sending those in. And we jumped several pages ahead. She has several examples there. So we're on page 140. HOA, too much financial burden on the seller. So they don't want the seller to have to pay all the excess over a certain amount for the HOA payment. The next one.
I agree with it.
Is, agree with the next one?
Yeah.
On the.
Change is a little confusing.
Yes, change is confusing. So the 2020 CAT fee. So they want us to look at a specific fee, which we actually did look at this specific form earlier today. And so we discussed the fees and what's associated with the HOA fee. So I don't know.
So 141, this is an example of those private transfer fees that are for a 501c3, that they have foundation fees for the betterment of the community.
Expand anything further on that?
As a seller, you get to vote on those.
Next one, so HOA thinks the change is a little confusing without offering further details. It's all confusing. Page 143, the amendment form seems redundant since license holders should know the amendment becomes part of the contract. I'm not sure what they're referencing.
We put the explanation in the amendment about repairs. We said paragraph 7 covers who does repairs and what has to be done.
There's yeah.
And it is redundant, you're correct.
But we discussed that redundancy.
It was meant to address the lack of understanding. You're correct.
Page 144, be helpful to add a reminder instruction to include contract addendums section in paragraph that is being modified. That's an interesting thought. I'm not sure we want to get into the business of doing that, but they want, essentially if there's a modification for there to be some statement to say what is being modified. Brokers.
Good agents do that already.
Yeah.
More of an education issue or clear, to be clear in these contracts.
Usually
if it's even
include
necessary.
yeah.
Oh, we got another, man, we had several winners here. I missed these, love it.
That's Nikki Friend, she's been doing it. Sometimes she says she
one of
loves
them's
it,
just a
sometimes she
repeat.
says she
Oh, okay, that's why I only had it once. 145, so love it. Thank you, Vicky, for And if you notice, these forms are just because of the online comments. And so this is the first meeting I recall having them like this, which is great for consumer and agent feedback, but definitely adds a lot to our. I would wonder if this is easy logistics of combining all these into, like we do for the emails, or if it's just as easy to put them in.
I think the way that it's programmed is they're sent out as individual PDFs.
And so.
Definitely on our wish list.
Okay. If we can, the IT guys, if you're listening to this, if there's any way to combine that to save paper and trees would be fantastic. But we do like receiving these comments because we get more in.
We have another one to get rid of the lawyers.
It was one.
Same
Every
person.
form got their own
She's
comment.
made
Exactly.
the same comment about 7 times.
You better hope everybody
I did
does
figure that out.
right?
So
Island Park, she wants to write what she wants to write.
146, completely disagree. Okay. Write what you want to write. Next is 147, a third-party financing addendum, which we've gone through Don Moore's comments here. 150, why have to name the lender? So this is one that basically for privacy, why do you have to name the lender there? Well, and then why require to name term of loan if right to terminate 2A and 2B are waived? So that's on the species of what we've already talked about there as well. Some more disclosure to the other side. Page 151 wants 2B waiver clause to apply to all methods, which we talked about. 152, need to capitalize escrow agents, which we did elsewhere in the contract. So, as well in the third-party financing addendum. That was actually a good point. I think in the third-party financing addendum, we have it lowercase. We will make that conformity change, or change to conform. Page 153, 1G should state very clearly this is not for seller financing. The thing here, we already have a separate addendum reference in paragraph 22 for seller financing. And so you'll be selecting the wrong addendum to use.
And if you have a seller financing addendum, then it is financing identified in the contract.
I would agree that it seems clear. But I also recognize that it isn't always.
If somebody
Well, there's a
accidentally
box
used
to
it.
check in 3B.
Well,
Yeah.
I think on the appraisal addendum, don't we say something about this is not for cash or?
Not for FHA or.
Yeah, I mean, that should be clear, but we had to put it on the addendum. So, I mean, I'm good either way, but there may be some legitimacy to this.
And so in the seller financing addendum,
It covers a whole lot more stuff.
Put it in 3B and check the box that says seller financing addendum.
Oh.
Right, yeah, when you fill out the contract, you would not be using this addendum for seller financing. because
Yeah,
you
it's
would
pretty
check
clear.
The other box.
That would probably charge you.
Sounds educational.
that's what I
don't have a strong
Disagree.
feeling about it, I'm just saying I empathize. I feel her pain.
With an
Any
exclamation.
other comments before we move on to that one?
That was it, right?
No, not quite yet. So then we have, disagree.
Oh, yeah, there was a couple.
155 days omitted. I beseech the word, this is actually another good one.
I besieged,
So we have the word days omitted in the
I
loan
believe.
assumption addendum.
I believe,
So if we look there, there's a place in our comments, which is on page. Let me see. 226, thank you.
Paragraph 8.
Yeah, it says within 7, it's C, isn't it?
236.
Yeah, paragraph C.
Yep, so the blue lines in the bottom of paragraph C.
Yeah,
So we,
last sentence.
it just says 7, 11 by
and then Tom Allen, thank you for reading these carefully and catching that. You're the only
Man.
party that
You're
caught
the
that
man, dude.
omission. So Thank you very much.
Susan disagrees.
Yep, Susan disagrees on 156. We've gone over the Farm and Ranch Working Group comments.
So we're now on.
236, unimproved
Item
property.
6.
Wants the sale price adjustment in the unimproved.
Where are we?
Sorry, we're on 236, was unimproved contract. What's the sales price adjustment language in there, which we've gone over?
9 minutes.
9 minutes? We're getting there.
Oh, there we go.
237 wants legislative action to include condos. Let's see. Oh, so Chapter 209, Texas Residential Property Owners Protection Act only applies to homeowners own a house. Let's see. So this is one, condos are expressly excluded from that act. But they've essentially asking for legislative action to include condos into it. And Cindy Delagarza, that's one thing that we cannot get into is legislative changes. So the legislature would be needing to petition to have that changed. 238. This is once a blank deadline for when other property has to go under contract. This was an interesting change I would like to defer to a later meeting. But right now we have that in the sale of other property.
Just receipt of proceeds.
Yeah.
But as a seller, maybe want to actually go under contract by a certain date as well. And I think that's an interesting idea. That way, because if you get within a week or two of when it has to close in fund, it doesn't become realistic. So do we offer another deadline in there? So if you don't have it actually under contract, the seller can move on to the next buyer.
I will say from representing buyers in a contingency situation, I've always hoped that the seller would be open to an extension of the closing if I can get it under contract, and it may be beyond that date. Now, whether that's the right thing to do or the right play to make, it's a.
14 days from closing and I don't have a contract on that house.
I can't close.
I'm reaching out, we're not waiting until the day of closing.
Right, I'm not telling you.
Negotiations are happening before that.
Right.
But I think it's an interesting concept that deserves maybe a further discussion at a future time. Let's see, this one came in the Greg, wants to add an option to make receipt of funds date the closing date of the contract. Add an option, let me see, read my notes here. I said, sell of the property. Yeah, I'm not sure, Greg, do we have any thoughts on this from Mr. Tracy?
The lady, but I think what she's saying is there's a date in there and you may need to have a different date when that comes into effect.
Oh, yeah. If you amend the closing date of the contract, she wants to have it so that it would automatically extend the deadline for the sale of other property.
Oh, yeah. You have to remember to change those.
What brokers do you think about that?
It made it, just because you're changing the closing date on the house you're selling doesn't mean that the buyer's buying, doesn't mean the buyer's house closing date has to change. They may be still closing.
And it could be addressed in the amendment at the time you change the closing date of the contract.
It is a pain to remember both dates, but
No action. 239, logistics of providing landlords floodplain notice when a seller's temporary lease issues.
It's the law.
It's stupid.
So.
Well, they're basically
not-
saying because they don't know the house, because they're giving them a
You're
lease.
disclosing to the seller. Yeah, but the legislature in their wisdom.
And my comment here is I'm not sure there's a way around it. It's law, you have to do it, so.
It's a very strange thing.
Okay, 240, mold notice. Wants to know if we should put a mold notice in the contract. Let's see.
I saw, they had it in the Texas Realtor commercial contract, that if you've done mold remediation, then you have to provide the buyer a copy of the certificate. So that's to put on our wish list for the future.
We'll defer, good thought, we'll defer that.
It seems like a seller disclosure issue, and I think it's weird, yeah.
There is a statute that says you have to give it.
Right.
The next one wants a deadline for delivery of FERC documents to be added to the contract. And they give an example of an issue that they had.
Yeah.
And, you know, I think that's one we can probably defer to a later date for more full discussion on that. But does anybody have any desire to take that up now?
No.
Take it up with work.
Next one, survey copyright violations. Wants to remove paragraph 6C1. It's concerned about survey violations, which is I think that's a pretty extensive topic that we don't want to, for time purposes, venture into today, since it doesn't go directly to the language that we're using.
Well, it's a
And
topic
we
that
talked
we
about it
addressed
before.
20 years ago, yeah, so it's an old topic.
There are some,
I am seeing more
There
are
copyrights
some
now
lawsuits
than I
coming
did
up.
previous
Well, and
years.
this is in the legal update materials too, squarely copyright survey issues, so I think it's gonna be top of mind for a lot of
well,
agents.
there's a couple lawsuits now that
No,
Even
there
where
aren't.
they want, where they're.
Huh?
There's a rumor that there are lawsuits.
I thought they said there was 2 now.
I don't know who they
Do you know
are.
where they are?
I mean, we've been trying to find out. We've heard the rumor that there are lawsuits.
We were talking about this last meeting, that there was a river we still haven't found.
So maybe if you hear about where those lawsuits are,
Yeah, I would be very, very interested in hearing about those lawsuits.
Well, let's call Avis. Avis Booth Guy supposedly part of that was.
I, as a
Did she
matter of
ask you?
fact, asked Avis.
Really? She didn't know.
And she said, it's unsubstantiated rumor.
I'll be doing.
okay.
It's usually associated with lawsuits.
Well, especially at an NDA, according to this thing that now has expired. 224, inspection, wants to limit buyer's ability to inspect until after the earnest and option money are paid. And this isn't that uncommon of a complaint. So what it is here is the buyer doesn't want to pay the earnest and option money. They want to inspect real quick.
But they want the option.
They want the option.
Gotta have consideration.
And here, they want an express provision saying, buyer, you cannot conduct any inspections until you pay the earnest and option money. And I know we discussed this in past meetings as well.
I think that should be on our list of future things because it is abused.
Well, you can inspect before you pay your option fee. You can't terminate before you pay your option
It doesn't
fee. But
say
I know.
that.
It says reasonable access under 7A to the
Yeah,
property.
but there's
reasonable
also
times.
provision to pay the funds, and can the seller say, until I get my earnest money and option fee, you don't have the right to inspect? Not for us to answer, but I think that it happens enough times that we should give some consideration to, can we put some clarity into that?
And I think there, just a thought to toss up for future consideration is, they cannot, if they do the inspection and try to get out, they haven't paid their option money, then they have to pay it timely, or they can't terminate their being breached.
And
And then
then
it's
they're
an
gonna have to
issue
get an
of the-
attorney,
yeah,
and they're not gonna spend the money
Yeah.
because the seller wants his house back on the market, so it's not fair to the consumer.
And there, the seller has to look for the nominal option money that they could have received.
Which you're-
versus the-
Money where your mouth is.
Yes, and I don't disagree, it's frustrating, but it is an issue that is not that uncommon, especially with investors. Page 244 wants additions to the contract. One wants a provision that all keys and openers need to be provided for title. I don't think we want to venture into saying where are the keys and how the keys need to be provided. This is an interesting concept. I don't think necessarily make into our contract, but an offer must be accepted by provision. So if you don't accept this, we don't have all these offers concerns having offers hanging out there. And I think that really goes to the diligence of the agent representing or the consumer revoking that offer, make sure it's not hanging.
It insinuates the seller has that length of time to consider it too. I like the seller to know that I might be withdrawing, if I were the buyer, might be withdrawing that offer at any time.
And you're seeing these clauses pop up a lot with the escalation clauses. The escalation clauses that also include offer must be accepted by, so they're not shopping the offer around to a lot of places to up that escalation. But I'm not sure we want to put that in our contracts. The next one they want to add is the option fee needs to have a provision to refund it if it's found out during the inspection that seller has failed to disclose issues. And that would be opening up a can of worms on what was disclosed or not
That would be
disclosed.
damages for the lawsuit, or
Talk about
This
lawyers getting
representation.
involved. I guess for option money, it's not that much, but. 245, Leslie Lerner, wants to, wants stove, this was a comment that Leslie received that she forwarded on. Wants the stove to be changed from an accessory to an improvement and provides materials on stoves over the years, and wants a stove and a range. For today's purposes, I'm not sure how much conversation this warrants, but for today's purposes, I'm not sure we want to venture into.
I do think we should look at this later because there's confusion about stove and range and kitchen. I mean, it's.
But what's the relevance, one way or another? It's
Aren't they all,
property.
aren't they all part of the property?
Not necessarily,
No, no,
that's the
the
question.
property is the land, the improvements permanently built in, and the accessories.
Okay, but
And a stove is listed in accessory, so one way or another, it's part of the property.
okay, but my kitchen range is not permanently affixed, it's simply plugged
Correct.
in.
No, but it's
So
listed.
it's an accessory, it's in the laundry list of accessories.
It's
So-
not.
Yes, it is.
No, it's not.
We have
Yeah.
stove, but we do not have range. That's our point.
Exactly. And then we have
What's the-
kitchen equipment.
Stove
So
is like
what
your
is that?
potbelly stove, something that provides heat to the house.
So
But
can
if
you
you
have?
take it out, there's a
There's a
big
picture.
hole in the ceiling.
That's why you got
So
the
that's a
picture.
stove, that's.
No, that's a range.
I have
That,
never
there is a
seen that.
distinction in stove. There's a separate pot, but there's now, a stove doesn't necessarily mean it's also a
But
range.
I am in favor of being correct, and I think it definitely deserves, thought. But for today, for time purposes, I think we defer this, and
Yeah.
it is well taken, and if we can be more correct or change it up, I think we should, but not today. But we can make a note to defer that conversation.
Cook stove.
247, wants penalty provision for party wrongly refuses to release earnest money. I would
do
like
this.
to get
We
that.
tried,
That was an interesting one. Did we try in the past?
we tried triple damages and was told we couldn't do it.
Okay.
Years ago, exactly, years ago, it was 3 times earnest money, it had meat to it.
We had to take it out because of a lawsuit. So,
Yeah.
it really is, we were not happy.
You point
Well,
people
The brokers
about
weren't happy about it, the attorneys didn't seem to care, but the brokers were not happy.
For the benefit of everybody who listens to this meeting, that is one of the biggest areas of disputes, right? Of earnest money disputes and people wrongfully holding it up. And so it is a great idea, and I'm glad to hear there's a reason we don't have a penalty provision in there. But no, we know that it is a major issue.
Will they allow us to shoot them if they don't?
The baseball bat, and pattern ring. Let's see, assignments. In the middle page, Calvin Wright, checkbox that makes the contract assignable or not assignable. And this gets into a whole nother discussion about whether they're assignable and if they're assigned, what are the
And do you
obligations.
even need to put it in the contract?
Aren't they automatically assignable unless you say otherwise?
Unless it's personal, if I'm gonna give you seller financing.
So the general list, there were originally it is assignable, but then how can you assign to a third party that seller may not know anything about, them getting approved for financing or something like that. So it is generally assignable unless it comes to personal obligations. Wants Trek notice of prospective purchaser to be added to paragraph 22 addendums. So we can look at that as we're looking at the different notices as well. Once, and the next page, 248, add additional EM form with a deadline. Let's see, add a line reference additional earnest money being deposited in timeframe it has to be deposited. And oftentimes contract closing dates are extended. With this extension, the seller wants more earnest money to be deposited. Does anybody think we need to take any action?
By the way, on
Oh,
248, the thing about the T47.
Sorry, I'm on 248 at the top.
Oh, you're
here.
up there.
Yeah, sorry.
Okay.
The T47, there's several comments on, or at least two, about T47's why, T47 doesn't require notary. Well, absolutely it does.
Yeah, just FYI, TLTA is considering going to the Texas Department of Insurance to get TDI to say that it doesn't need to be notarized. But until we get Department of Insurance to change its rule, there's really nothing we can do.
Right.
And then they say, well, another comment, whether it's this next one or not, was, why doesn't the whole contract have to be notarized? And so for now, it is an affidavit, it is
Please
required by
don't make that
PI.
wish.
And for everybody, the title company needs the date of the survey forward to know whether any property, changes to the property have happened. And T47 you go past when you bought the property, because you can look at the survey, you can look at the property and tell the differences. So that's a common question we get a lot, so if anybody's listening, that's a little clarity there. Next one, 1031 language, once 1031 language in the contract. And an offer good through date, which we've already talked about. Bottom of the page, when staggered payments for OM and backup offers, second payment due when offer goes in the first place. And we discussed this at past meetings as well. There is some inclination that it might be a good idea, but I think none.
It might make it low option fee.
It might be advisable on our future list to take the backup addendum and provide for how much earnest money and option fee and blanks is put up at the time it's a backup contract, and the ability to, once it goes into the primary position, pay additional earnest money and option fee to meet the request of the seller without having to play with it, and which is what's being done in paragraph 5 in reference to special provisions. If we can get it all on the backup addendum, then it would serve a purpose. It would really help the agents.
I've heard that one before. The practical problem though is that if you sign your backup contract and you become the primary, at that point in time, they all forget that there's an obligation to pay an option fee. They don't pay the option fee, and all of a sudden, they've lost their option.
That's gonna be up to the agents.
Well, we, I
Keep
mean,
track of the dates.
the way I do it right now is like $5 option. And then on earnest money, it's like $5 earnest, and then under extra earnest money is after I go into first place. And
That's cool,
they're gonna
but
lose
that's
$5.
cool with,
But how do you document that carefully on their behalf to protect them?
that's
Fine.
cool
Well, we're
for
playing-
earnest money.
In my
not
opinion, is
option.
we're playing with paragraph 5 and 11. Maybe we need to give them an easy fill in the blank that doesn't have us practicing law.
I like the thought of looking into that further too, and I applaud the education committee for putting this in the legal update, right? Not the changeover, but the fact that the option in earnest money needs to be paid upon execution with those deadlines. Because it is a common issue. People, well, I don't want to pay now until I go in the first place.
Yes, and to
Yeah.
your point, it even says in there that it is one of the most misunderstood and unused forms, the backup addendum form. And agents don't know what to do with it, so they don't use it, and it's not fair to the consumer. So I think we could help them if we consider modification to the backup addendum.
We actually had a broker who I thought, I know, is incredibly educated. She questioned this whole, why can't I get my option back if I never go to first position? Because you've got the right to sit in that first backup position. You lose your option fee, is what an attorney.
It also says right
That's what
in
you're paying.
the manual.
You're
that
paying
it
for the
is
privilege of
Texas
being
case
first in
law,
line.
It's not track.
Well, you're also paying for the right.
To
To terminate while you're in
Even
line.
before you
exactly.
go
Correct.
primary.
But that came from code, actually,
That's
the explanation.
Okay.
That makes sense.
Because if you're the backup,
Oh, I've known.
All right, so
I mean, I go, what are you willing to?
we're getting close to the end here. All right, so 249, bathroom mirrors wants to add to the list of accessories. These
We should
passed for
talk about
today.
that when we do stoves.
Yes, that's a good idea. Look at that whole list of items for accessories. Paragraph, option and fee and earnest money to be delivered by the end of business day or 5 PM. So of course, delivery is not the 5 PM deadline, only the termination is the 5 PM deadline. Include language to address what happens if option fee is not delivered timely, which we do. And so, it's too bad, so sad, you don't have an option. Page 150 wants title companies to release earnest money to buyer without the signed release by seller in certain situations. So this is turning may until will, which we discussed that obligation earlier. We don't do that. Allow for choice for mediation or arbitration in paragraph 16. So which we talked about that many times before, changing the legal rights of the parties. They're not going down that road. 251, suggests language to instruct title companies on how to prorate taxes. So they give a Some suggested language there, which we discussed at proration provision at the length. And that the main concern there was if the current year taxes differ from, I think the prior year's taxes. I think so
Yeah.
they're trying to-
I think what's coming up is, at least what I am finding with some of my agents, is if they're buying a house and if there's an exemption, not just a homestead, there's like, you know,
Over
a
65.
disabled vet or whatever, the title companies are not prorating correctly. And I don't think agents are smart enough to catch that, I hate to say that. And so what's happening is after they close, they're getting another bill to bring the taxes current.
So is this a large enough issue to continue the discussion on later? At a future meeting?
Well, I think, I mean,
I want
having Air Force bases around and everything, and Army bases around this area, this is huge.
As a buyer,
Our
you do
world.
have the choice of going back to them to get that money.
Yeah,
I mean,
so
I
what?
know- Yeah,
That's really gonna
Yeah,
work.
let's have a look.
Yeah.
That's
Yeah,
gonna
let's-
work real well.
Let's add this to our future discussion list, because it does sound like
There's
there's.
some that don't know how to prorate correctly. They take what's on the tax record rather than,
Well, that's what they get from the tax certificate.
Oh, my God.
So we go to 254, non-realty items to be a checkbox addendum. 255, earnest money released by title, wants to remove may but will. 256, complaints about formatting and spacing in contracts, which we talked about earlier, so we'll double check the spacing.
It is getting embarrassed.
That's something we will check. We always do our best to get that right, and everybody works hard, so we will double check those items. Page 257, clarify for licensees that escrow agent is the title company, not the agent's preferred escrow officer. So that's one that we have to finish discussing at the end here. FHA, let's see, 258. FHA suggests having agents sign contract. So this is one we won't get into having agents be parties to these contracts, but the thrust of the comment is if we had the agent sign these statements up front, we won't have to sign these clauses that are required in FHA transactions at the end of the deal. So you have the mandatory clause and I think agents not attending closing and getting them signed, at least at the title company's been an issue. Right, the agent's not attending us, having called them, say, get your butt here to sign this form.
Or you're
Or
getting
some-
your check.
Yeah, and so I've seen the issue present itself, but I don't think we'll ever venture into making the agent parties to these contracts, so
No.
unfortunately.
This
it's not
is a
something
mortgage broker.
We can add. That is true. And they give an example of it's a real estate certification that goes with the mandatory clause. 260 wants a statement that the buyer has received the survey.
I thought that was an interesting idea of a box or something, you know, because there are cases where they are, of course, I just put 0 days or something in the blank, because if they received it.
And there too, it matters the title company receiving it, under C1. It's not just the buyer, it's the title company.
Oh, yeah, they gotta get both of them.
Right. So I don't think we can add that because it still leaves open that other door. At least get the title. 261, earnest and option money, wants the amounts on the same line to remove confusion. Doesn't like the two numbers being on different lines.
are you serious?
Yes. 262, taxes, add checkboxes for who's responsible for deficits in actual taxes. And so this is one where our form states that parties will essentially work it out between themselves, and there's a difference between the two.
And I don't think you can negotiate the unknown, so I'm not in favor of the check boxes.
It's,
And the other thing is, like they say, you can go
His-
back
his
and argue,
email
but
address.
no one's gonna pay you.
22,
it's tough.
add non-realty items addendum, which we discussed. 264, earnest and option money, confusing with formatting. I'm not sure it's the second person that said it, but wants it on the same line. 265, add non-realty items addendum to put on 22. 266, option, wants option to begin when builder gives notice of completion. I think we already talked about that, and we'll look at that more when we look at the new home contracts. 267, non-realty items, addendum being added to paragraph 22. 268, unless checkbox saying buyer has received the survey. Notarization is a joke, doesn't understand why the whole contract doesn't need to be notarized. We've discussed that. 269, farm and ranch, can we not eliminate the reference to the Texas Agricultural Development District since there are none in the entire state?
Is that accurate?
Is that true?
I looked on their website, their government website, and there's a listing that says something about Chambers County. There's none created under this one government code. And there's one created under maybe the local government code or something, a different code that is in Chambers County. So I'm not sure if that's an accurate statement or not, but it sounds like the current law allows it to happen. So I'm not sure if we
So
want to remove
it could
it.
happen in the future.
Yeah.
But it's interesting, I think what they're looking at is under at least that one code provision, there hasn't been a single one established. But, interesting thought, and something we may look further into, maybe farm and range group if you want to look more into that. But I did look at the website, government website, and it looks like there may be one in Chambers County. 270, HOA addendum, line addressing capitalization foundation fees. We've already discussed that at length. 271, option doesn't like highest paid language in amendment. We've also had many discussions on. Wants language for seller to extend option at no cost to buyer. I thought that was kind of a strange comment.
I hear it all the time, but I don't agree with it.
Brothers, any other thought on, or attorneys on that? I don't think we want to change the language of the contract. 272, amendment, talking about option fee. Amendment does not address the details or requirements for deposits of additional fee for the option.
It does say just, yeah,
Says received.
it's received, but that's all.
Third-party financing, 273, buyer approval wants to provide evidence of the denial, which we talked about. 274, suggests clarification language. This is on the appraisal addendum. And I actually thought this language was pretty good. You know, we always struggled with this, and I think we maybe defer this to later, but
Maybe that addendum's gone now.
it's, what's that?
I said, maybe they won't be using that
Yeah, it's not
addendum
as-
anymore.
But I have
It'll
a
still happen.
particular class, or when I go over this and talk about it, I always discuss, look at the bolded title, if you want to know what happens from the buyer's perspective. Waiver, partial waiver, additional right. What is the buyer getting or doing? But I thought these were some good comments that we can consider when we look at that form again on what happens. Getting near the end, all right, 275, residential lease addendum. Buyer's lease, let's see. It does not directly address prorating rent between buyer and seller, which we talked about. The foreign investments in agricultural property law. And this was one that was brought up at a last meeting. I think we probably defer this again to a future meeting and have more time. But do we need a disclosure in the contract regarding the Agricultural Foreign Investment Disclosure Act? That act's kind of like the first notice. Because there's a notice that needs to be provided if there's a foreign person in, what does it exactly say here? Any person who acquires or transfers any interest other than a security interest in agricultural land to submit a report to the Secretary of Agriculture not later than 90 days after the date of the acquisition or transfer. So we have FERPA notices in there, and I think this comes.
So that's a post-closing obligation.
Yeah, and that's an obligation of the buyer, I assume, is that correct? Or the FERPA notice is the buyer about the seller, but is this a notice?
If the foreign person acquires or transfers.
So did the Farm and Range Group discuss, this? I know this was an agenda item to this one, providing actual language, but was this discussed at all? If not, I would suggest that maybe this be rediscussed in the.
I think it was.
I don't remember discussing it, but we can.
I would propose we tee that up for the Farm and Ranch, this is agriculture specific property, excuse me.
What we wanted, and then the farm and ranch deal, we were trying to say within our scope, but we really wanted to be recalled back to say, just look top to bottom, and that would be in this.
It's another thing Blake Bennett found, it's kind of serious, it's one of these things they may start to enforce, that's all. It's kind of scary with them.
Who has the obligation of reporting? Is it all parties or the buyer or?
I don't know yet. I mean,
Oh, okay.
But they said they could take 25% of the total amount if the seller didn't report it total
Well, it
proceeds.
sounds like the seller has the.
Yeah.
But it
So-
states here, it's, says it
Seller
requires
or
any
buyer.
foreign person who requires to
Both,
give the
both.
notice. If buyer or seller may be considered a foreign person, they are advised to consult with the appropriate. And I guess, is this language from a different contract? Montana. Okay. So we can consider that further, the farm registry will consider that. We have an additional, before we get to the case, an additional item 6 comment. Thank you, contingent buyer on one of my listed properties. So we can all read this, I'll read this out loud. So it sounds like you're the buyer under a contract that has a sale of the property addendum revises the close date on their sale of their other property. And they're questioning, well, how does that impact the current contract? With the
It's just an offer.
So I don't think there's any impact or anything we can
Well, yeah, I mean,
want to do.
if the buyer purposefully changed the other contract so that they would not satisfy the condition, and it gave them a right out of this contract, one, it's hard to police it. Two, I don't know how we could change the contract. But number three, I mean, there is a concept in the law that a party cannot take action to thwart a condition that would allow them to get out of a contract.
I think consensus, no action on that.
Yeah, I mean, I don't know that there's anything you could really do about it.
So before we move on to the case, circle back to the change we made in the actual changes that we put to the commission on the PID notice, flood notice, leaving it in the title disclosure, title section. We talked about just putting it forward the way it is and looking at the check boxes or moving it to paragraph 22 later. And so I want to make sure we're on that same page. If we did it that way, they can go forward. It's not a substantive change. They can go forward. If we made the change, it would be, what do you say, April next year, that then it can go out. So with what we have right now, we're looking still at the end of this year. If we push forward it the way it is and revisit it later, which may be a year more down the road, but.
I think you'd actually be closer to June if you didn't do it today. If you didn't actually sit here and make those changes to re-propose in November. So a little bit past April.
So if we sat here today and did it, we could do it potentially a little bit earlier. But if we push forward the way it is now, our contracts will stay on the current timeline. And I think it deserves a more full look into the contract to see what other notices we want to include and then push forward with what we have now. It's adding something extra. We put the PID notice back in paragraph 22. That was one of the big comments. And if the other notices like the mud and such aren't listed, well, that's already current practice, right? They're not listed in the contract now. So we're making an incremental change for the better. And I think we more fully analyze that and discuss it at a future meeting. Everybody's on
Let's
board
go
with that.
forward and keep on track, make the incremental change. Other thoughts?
The last thing we defer to the end is escrow agent to escrow agency. So we'll discuss that at the end. I'm not sure, it's an issue.
I think it's a big issue.
And making that, I think, is a substantive change. It's just changing escrow agent to agency, 2 letters.
And it's created it to be such an issue now since it's been that way for how many years?
Well, I think the fact that we put it in the comments, right, or changed escrow agent to capitalize and called it people's attention. And I think it's happened probably more than most other issues we see as far as causing a problem.
They've been doing it wrong for years.
Yeah.
And I think the difference now is 200,000 of them instead of the 70,000 that there was.
And ways you can fix it. Number one, to make it, number one, educate. Number two is to put a statement in, the escrow agent is the license holder of the earnest money, not the individual escrow officer.
That's more.
Or number three, or number three, you can say blank title company, escrow agent, attention blank. Put the person's name in there.
But then if they move.
The escrow agent is still the company.
Right.
Attention is, this tells you.
I think it's easy to say agency.
Well, but the point is, you're not always, individuals can be the escrow agent as well, attorneys.
And I'm a little concerned about, to me, escrow agent is, I don't want to say a term of art, but I mean, that is a term that we use legally. And I just don't, I have concerns about just switching the letters because we think people are gonna start doing it right because we switched the
This
letters.
has been an issue for so long. What if we defer this as well and really look into what that change can
That's
be?
another 6 months and it's
It's
bad
more
out
than
there.
6 months, but
It'd be
It's
more than
bad
a
out
year,
there.
yeah.
yeah.
It's bad out there.
Well,
When I'm
it's-
teaching, they're all,
But do you wanna stop everything else we've done?
No.
Yeah,
So
that's.
We
that
need
you
to
can
move
incorporate
forward.
that now.
Now we just need to educate as we've been and not stop.
If it's a
I
two-letter
actually think the
change, I
attention
wouldn't be
blank
that
might be
bad, but
helpful. I think I think adding attention, and that calls to their attention, that's where you put your escrow, your preferred person. You can put after the attention, and then, I'm more in favor of that than calling them an escrow agency. That doesn't.
We've
If they have a
consistently
preferred
seen,
person, it makes it sound like
Yeah.
that the agent is the one picking the title company. We know that that's not supposed to be the case. It's just making it worse, I think.
can you do escrow company?
It doesn't have, I mean, the
They
escrow
are an
agent
agent, they're a dual agent.
technically doesn't have to be a company.
Yeah.
Under the insurance regulation, if you're licensed as an escrow agent, you can be an individual. I mean, very few of them, but
Is that the term of
Imagine.
art,
what?
to be licensed by the TDI as an escrow agent?
to be, this is separate from, escrow agent doesn't have to be a title company, doesn't have to be a title agency. It can be anybody else.
But isn't someone who's taken the escrow funds always an agent, so to speak, in a legal term?
Yes.
Like you're representing,
Right,
holding
exactly.
money, fiduciary.
Right.
And
But
they're
which is why I
licensed.
don't wanna,
That's why I don't like company. I don't know about agency, but I don't like company.
Well, if
I get what
we,
you're
if we make a change, it's not just in like one easy form, it's
Mhm.
all forms.
Good
All we
point.
have to do is-
We just need to leave it.
But don't we define it? So it would be defined in the contract in that
I know, but
definition
I'm
as
talking about all
well.
Linda and everything else and
Yeah.
refer to.
Just put that on our, we gotta do some stuff in the
What
next
is,
few
what
months.
is the definition of escrow agent?
how can we stop what we're doing?
Well, if it
Is
was
that
this
why
big of a
we're
deal, how come
capitalizing
nobody
it?
brought it up when we were redoing all the contracts?
Person or company name.
Because we capitalized on it,
We have talked about it before.
Got it.
Uh,
We have talked about it before.
but it hadn't been
So,
to this
I
level.
think a clarification,
Yes.
we didn't have
are
to
we,
write it.
can we decide that we're recommending that the commission will go forward to adopt forms before them? Or are we saying, don't adopt, let us continue to work on it?
I think we're pushing, and helping procedurally here, pushing forward to adopt with the changes we made today.
Yes.
Non-substantive changes we made today.
I think you have that option, yes.
I think that's where,
So we are recommending the commission to adopt the forms, subject to the changes we made, non-substantive changes we made here.
I think it's important to move forward, and if we're taking this much time on if it's agent or agencies, I think Amy brought up a very good point. If that is the proper word in that industry, then it's up to real estate agents and brokers to learn that. And I would bet you if we changed the name, they'd still put their favorite person in that line. So let's just go with what they're used to.
and the definition is something that we created with our changes. The forms before our changes did not have a defined escrow agent. And so we made the definition and put it in there is why we capitalized everything, which then resulted in the comments that we received.
Because it's blue all over.
It's blue all over the place.
An article in a magazine.
I'm happy to propose.
Thank you. the proper way to fill in that blank.
So I think
As an
where I'm
inspiration.
here, where we're circling is, we'll think about this one more, but let's push it out the way it is. And then we'll see if we can figure out a better method to do it.
All those.
Because it is
in-
definitely a known issue.
It's a big issue. As a broker, it's a big issue. I
It
don't,
is a big issue,
It's
but
a
it's
huge
not
issue.
bigger than some of the things we're
Yes,
actually accomplishing.
absolutely. Well, we can educate.
It's like, do I kill you to save all of them?
So.
Right?
Just
And you
make
have
sure,
to
train.
make sure everybody understands. I wanna make sure everybody understands that we are, November seventh, the commission is
Kill one.
likely to adopt.
Yes.
Right, with the changes, the non-substantive changes that we're making, non-substantive, like that.
They are so non-substantive.
Thank you.
No, I think they're all made in response to the comments received, and I don't think the totality of changes is so different than what's actually proposed. So that's the standard we're gonna look at.
And one thing I would propose we do as well is instead of looking and trying to fix the minutes right now and improve them, we're all tired at the end of the day, let's actually review these closely with the changes we made and try to do that maybe by, sometime next week, whenever we need to do it, but everybody review it. What's that?
We're not having another meeting.
I guess not.
Yeah,
so
we have to, tired or not, we have
I
to.
suggest we go through the minutes right now and just sort of make sure.
Yes.
Make they're good.
And then if there's typos, corrections, staff can always fix those.
I would make sure that we get it right since it's going.
You could send it in the draft that you send to the commission, and then we can just proof for typos or whatever we might see, right? Advise you about those.
And what, you mean like the actual contract form, can like send you our draft form?
Yeah, the ones that will go to the commission after this
Yeah.
meeting, and then we can look to see if there's any typos or errors.
We will, yes.
Which
We like to do that. Well, we send it, I think we typically send it to the two chairs, right?
Yeah, I was gonna say, I've never.
It varies. I think we would have, that's just the amount of comments.
Lee promises to look thoroughly through every. Cherry that
Yeah, you're right, it depends on.
That has color to it, yes.
So on our agenda, just to go through, there is one case in there. It's about a mineral interest foreclosure. And there's over 500 defendants served by posting at the courthouse door. The plaintiffs, who were heirs of one of the owners, challenged the default judgment that was entered because the address was available in several deeds that were recorded of record. And the court held, just ensured that it was a violation of due process because there was that information available that was not used. But also said that they had to pay, I think, before they, what was the actual verbiage here?
Had to pay the taxes.
Yeah, had to pay the taxes before they can reclaim the property or take some action to reclaim the property. So it's an interesting read there, and it is from the Texas Supreme Court, so.
On item number 9, before that, we did talk about that at the last meeting. Is there any comment on USDA loans and proper placement?
I think we can defer.
For that.
Yeah, I
it
think
goes under conditions.
just in the interest of everybody's time and stuff, we can defer the item, goes at 7 and 9. We can put them on the agenda for the next round. If that's, I mean, I'm not trying to control the meeting, I'm just trying to read.
No,
Are there other agenda items that we didn't address that we need to defer?
Just 7 and 9.
Okay.
And we'll go over the minutes here shortly. Our next meeting is currently set at June 9th, after the legislative session. So it would be a long break in between. I'm not sure there's a need currently with what we've done for a January meeting.
So it'd be June 9th.
June 9th, correct, after the session.
Assuming the session's in.
Well,
Unlike
assuming
last year.
assuming track accepts all of our proposed changes.
Yeah.
If they didn't, then we might want to have.
That's true.
Yeah, that's right.
A January,
And then we'll go,
but I think you could call an audible on to November 8th.
everybody's keep that in mind, that if there are any issues that arise.
So our next meeting is not until June.
Correct.
So my question to you there would be, given the laundry list of things that you'll see on the minutes here in a minute, of things you want to talk about. Do you want to just go ahead and start talking about them? Because there's a number of pretty big items.
I think we should read before June.
I
do
think,
too.
I think we should meet.
Definitely.
February, March, I'm not saying have a bunch of meetings, but
Well, we have a proposed date in here, January 13th, which I think we may discuss last.
Friday before.
Okay.
If the point is, we're not gonna be making any decisions to make recommendations to the commission, then we can do it anytime we want, right?
Right.
I mean, the January 13 was given so that we would be a certain number of days before the next commission meeting, in case we wanted to make a recommendation.
Right, so that might be one to hold and see what happens in November. And then if you all want to, if you want us to look at some dates for just like, for lack of a better term, just a meeting,
Chit-chat.
we can do that too, we can send those around.
The reason I would like that is, I mean, this was a pretty lengthy meeting because we put out a lot of changes for comment, but there is a lot of stuff to go over. And if we didn't have one, then the next meeting can shortchange other items to this one, so we want to do it either way, whether it's January or later.
we'll keep that January meeting in case the commission says, no, we need to get back. And then, it also gives us, if not, we'll use that date to do our other.
Yeah, I like it. Everybody okay with that?
Yes.
What's the January date?
13th? It's not a Friday. It is a Friday.
That's the Friday before MLK. Monday.
There'll be a holiday weekend.
Oh, so you mean.
It's a holiday weekend. I'm just,
I mean, do you
it doesn't
wanna
matter to
hold
me, I'm
that,
fine. but-
do you wanna hold that one for like, okay, if things go different in November, we've got the 13th, and then, you know, we can send around some available dates, maybe like February, March.
It would be easier on staff to not do it while prepping for a commission meeting
Right.
if it's not needed.
Right,
for-
January is a pretty full committee meeting month for us.
John, what do you about looking at February? So they can be free?
Like post-commission meeting February is,
Like that. Does anybody have any, it's hard to say, in February on Fridays in February, any absolute?
I can't do the 10th, that's the only Friday.
Yeah, we
I
can.
didn't.
yeah, it'd be after that.
That's right. The
That's right before our.
So it'll be the 17th or
The
24th.
3rd, I'm gonna be hungover from Groundhog's Day, so.
17 or
I would
24th.
say, yeah, it's the
Okay.
17th or the 24th.
I have
but
both.
I have both.
I'm good.
I do right now, but when will we know?
Well, can't we set
Well,
it?
let's set it, let's just go ahead and set it.
Okay, which one?
There's no reason. Let's do 17th.
January, February 17th.
But
Is that okay?
February.
Okay.
what, can we hold 17th and 24th and then we will, we've
Yeah.
gotta coordinate our.
Sure.
Yeah.
Okay, the 20th also is President's Day. Does that cause any issues because it's before a holiday? It doesn't with me.
The
President's Day.
17th is.
It's the 17th would be the Friday before the.
Okay, I think that's the Friday after our commission meeting.
Yeah.
So probably the 24th, I'm saying this very generically, but probably the 24th is better. We can get on this on Monday and we can calendar things pretty quickly.
Okay.
Okay.
Thank you. Yeah.
I do too, I just hope you're.
Yeah.
So I guess the last order of business is to review and go over the minutes. Ron is finishing up. I'm reading this packet, I was surprised that, worried that we're going to be able to keep this to one day. I know it's late in the day, but good job, everybody, for getting through this and being patient.
I'm all fully responsible. I'm fully responsible. I'm used to taking credit for things I didn't do, so.
Are we adjourned?
Something.
Now we have to do the minutes.
Minutes.
Oh, sorry, buddy.
Almost.
Oh, no.
Right, at this point, we should just wait.
No,
for
but everybody else is
six
left
to
to build
leave,
it.
and then at the same time, 'cause if we like, yeah,
Strong guy.
All right.
I just don't want to be driving. Too late for that.
No, I take.
Oh, yeah, we have those in our office.
Go back home.
Well, and if we sit still too long, really.
But you're not-
Light goes off.
It's always on the agenda.
I have that problem, I'm sitting in the dark.
It's always in the minutes.
Oh.
Yeah, I do not have, 10 years.
Oh, my goodness.
There's no need for you. In fact, I probably shouldn't even keep it. It's better if you plead ignorance. I shouldn't really have anything that could ever be subpoenaed. That's the goal.
Well, that's what they say.
Okay.
That's true.
Do we lose everybody or do you want to go through these?
No, I'm here, we have to.
Yeah, let's go,
No, we have
I got a subpoena one time for something I had done in my volunteer role with Texas Rangers.
I think we can start.
I immediately called. Was it that?
So,
He's Major's phone, I called him like, don't worry, I'll handle it, send it over. Never heard another word.
So that's the rest.
There you go.
This jacket's.
Sure. Okay, so what we have here, just real quickly, is obviously back up here, you see who was here, make sure that your name's on the list. And then we had the committee minutes approved, subject to those corrections. No comments from the public. And then number 4 is a whole laundry list of what we did, so it kind of gets a little bit messy, so it's not necessarily the same order. But we discussed our comments and we began our review by reviewing the comments by topic or by paragraph number, I should say here. And then we decided not to make any changes to any of these paragraphs. I think we made the change in paragraph 22. Is that right, adding the SID notice back?
Yeah, we did.
Correct.
Okay, so I need to change that.
Going back to that.
Because I have that on below the regular, so I think that.
You take out the end. Put the end before it too.
And it's no below. So then we decided to make changes in 9B5 regarding transfer fees. So transfer fees assessed by a property owner association are governed by the addendum for property subject to mandatory membership of the property associations. And then the same thing in condominium form, it's that's going to say this paragraph does not apply to fees assessed by the association. So.
Do we need to state that, which contracts that goes to, or what? The first part of it?
Yeah, what I do is I leave that to staff to balance that out to all of the contract forms, except where we know it's different. So I think it's the same in everyone except the condo form. And then in C, the committee decided to change the proposed language in paragraph 13 so that the first sentence of paragraph 13 reads taxes for the current year, interest rates, and regular periodic maintenance fees, assessments, and dues, including items that are prepaid, will be prorated through the closing date. D, we decided to add or change paragraph C in the POA addendum. And I think we have that. We worked out that one that has that. Took us 3 times to get there, but that's what we approved.
It's so pretty.
Decided to.
I almost feel like we're all taking a selfie here for that screen.
What?
Almost like we're all taking a selfie. We're all like.
Oh, yeah.
So make a similar change to 1283 of the condo form. So.
In which? Of what?
I or and to, does not
What's that?
apply to.
We talked about that,
Did we?
being an
Okay.
and or inside and in with the,
Alright.
because if not, it doesn't apply
That's the
to both.
445 logo.
Are we okay with that? So it's basically the same thing, just in the condo form. The committee decided to add an additional line, paragraph 21, for the address of the person to whom the copy of the notice is to be provided. Copy of notices are to be provided. Moving too fast right now, guys.
I think the additional line was the buyers, like buyers and sellers.
Right, so you have an address there for buyer and seller.
There'll be two lines.
Yeah, but not just on copy. Remember, we did two under, like, delivered to buyer, and then we said, give them room to do two emails instead of just one.
Yeah.
Okay, so that, I misunderstood it, so.
Yeah.
Just 2 buyer lines and 2 seller lines, plus the copy to the agent.
So are we gonna have an address for the person receiving the copy or just an email?
We'll still have the
We
same,
said two
same
email
exact,
lines.
just add a line.
It's not the person's copy under this one. So there'd be 2 of these and 2 of those. This
Okay,
is
so you
fine.
want 2 emails for buyer and seller?
Yeah, I don't have to reference the contract, show them easier.
Yeah.
That's what he's looking at on the screen.
Oh, gotcha, okay.
So 2 emails to buyer and seller, and then you want, do we need a name of who it's going to, the copy going to?
We said.
I'd just leave those 2 lines
Or
for the
just
buyer
an
and
email
seller.
address?
Yeah.
Do we need a name, an address there, or just an email address?
Just an email address.
I think since you have buyers, agents, sellers.
Okay, that's right, we have that, that's right, we changed that. So, to add an additional line in paragraph 21, address. This
Maybe for email address?
Yeah.
Or is it just an email address or just
Just
another
that, we're
address?
just adding a line for a second email address.
Okay.
For the parties.
Do I need to follow a sticker on to leave the building? Okay, good.
I don't need that.
It's in my
I don't have the
papers.
name tag to get you. and
Good job.
All right,
It
that's
doesn't,
all
we
right.
could, you could have a.
As long as Abby knows what we made.
You said
I'm here, following.
Because I actually
Good.
had it earlier, and then when they gave me someone.
So then we decided to delete as described on exhibit, paragraph 281 in the condominium form. The committee requested staff.
Quick question on that. That was a change that we had proposed making, not to the actual form that's out there. I don't know if we need to make a distinction there. Is it,
Opposed.
So removing the proposed change?
correct?
Withdrawn?
And then the committee requested staff to modify the term license holders to brokers and sales agents through all the forms, but not in those structural boxes.
What is the proposed condominium contract form?
That's the one before the commission right now. So it's in red.
That's our
Gotcha.
red line.
There it is in
All of
red.
those are proposed, okay, I thought.
Okay, and then H, the committee asked staff to correct the numbering in the draft of the seller financing addendum. I, the committee asked staff to capitalize escrow agent in the third-party financing addendum and in all other forms.
They're all really proposed, right?
Yes,
Do we
correct.
need the word
These changes.
proposed with the condominium contract?
Any of them with changes.
Well, these are additional changes to the contracts.
Yeah. I guess we should say all other proposed forms, right?
Oh, like,
Yeah.
The committee decided to insert days after 7, paragraph C of the loan assumption addendum. Guess that's the proposed.
Seems unnecessary, but.
In a while, yeah.
I can't remember what on this place.
Except for the one where they had those fights.
Apparently they used to have 2-day meetings.
Yeah.
That's what I heard.
That was
I've never had
pre.
one.
And this is the laundry list of everything we decided that we would discuss later. So I'm not sure we want to get into this because I may not have heard everything.
I'm amazed how you do
But
this.
nothing-
Fabulous.
Great job.
Nothing stops us from adding this later, so it's not like it's.
I'm okay with that.
And then we have heard a report in the Farm and Ranch Working Group, which actually occurred before, so don't think of this as
In order.
chronological. And then the committee decided to insert the PID notice back into the list of addenda or notices that are attached in the contract in paragraph 22 in the proposed.
It's not a notice, right? Isn't it an addendum? PID notice? It's
The addendum.
it's
Well,
an
the-
addendum.
I think the statute calls it a PID notice, but the form is actually titled addendum, yeah.
Well,
It is.
Yeah, I wouldn't worry about it.
But we-
It's just for the minutes, so we know what we're talking about. And now then we decide to recommend for final adoption all those forms.
And I'm gonna go ahead and have. I'm getting them.
And then John, you summarize the case, and then we defer to agenda items 7 and 9.
I'm just gonna pay you.
4:45.
I think, oh,
4:50, 5:52, right?
I think, didn't we,
Yeah.
4:52.
We're not adjourned yet.
didn't we say we weren't doing the January 13th meeting?
Well, we're holding it.
depends.
We're holding it,
Okay,
just in
What
case.
the commission does with the proposed change.
so we will be notified.
Yes.
52.
Because she gave me.
And just keep in mind, any typos or errors or clarifications that the staff needs to make for these
You need to
minutes,
fill in the
they can always do that.
One more number.
Yeah.
The red.
Or 53.
Yeah, I think it's 53.
So do we need to say that we approve these? I guess we can't approve the minutes.
It's 4:52.
We need to make a motion.
Oh, I'm sorry, I was reading that.
4:52. Hurry, hurry, hurry.
I was reading the clock at the back of the
Call the,
room.
the writing paper back.
You're welcome.
Where's
And then
where
there's
did all
like
this shit
minor,
go?
like
There.
there's.
Oh,
we can chit chat.
Tony, got one quick thing. So we just went over the minutes. Do I have a motion to approve the minutes?
Motion approved. Second.
All right, all in favor?
Aye.
All against?
Amen.
All right, I have a motion to
Lord.
Everybody.
adjourn the meeting?
Thank you.
All right, meeting adjourned.
Day to you, sir.
Because he is